Tabling of documents.
I have the honor to lay upon the table the Fall 2018 reports of the Auditor General of Canada. Pursuant to Standing Order 108.3G, these documents are deemed to have been permanently referred to the Standing Committee on Public Accounts.
Tabling of documents, the Honourable Parliamentary Secretary to the Government House Leader.
Yes, thank you, Mr. Speaker. Pursuant to Standing Order 36(8), I have the honour to table in both official languages the government's responses to 2 petitions.
Introduction of government bills, statements by ministers, reports from interparliamentary delegations, presenting reports from committee. The Honourable Member for Sault Ste. Marie.
Standing Order 34.1, I have the honour to present to the House in both official languages a report by the Canadian Parliamentary Delegation of the Canada-China Legislative Association and the Canada-Japan Interparliamentary Group respecting its participation in the 26th annual meeting of the Asian-Pacific Partnership Forum held in Hanoi, Vietnam from January 18th to the 21st, 2018. Thank you.
Presenting reports from committees. Introduction of private members' bills. First reading of Senate public bills. Motions. Presenting petitions.
The Honourable Member for New Westminster Burnaby.
Thank you very much, Mr. Speaker, and it's my pleasure to table a petition today with more than 1,000 signatures, which joins the over 5,000 signatures received in this House so far and over 500 signatures received online, Mr. Speaker, around the issue of children's rights in Canada. Today is Universal Children's Day, and Canada has signed the United Nations Convention on the Rights of the Child. However, Mr. Speaker, as you well know, a number of government programs, including Housing First and the Canada Child Benefit, do not apply equally to all children across the country. Children that are in marginalized situations, homeless or incarcerated parents, do not have access to the same programs. So on behalf of these many constituents and on behalf of the Elizabeth Fry Society, I table this petition today. Thank you, Mr. Speaker.
For Yorkton Melville.
I'm standing today with 2 petitions that are presented on behalf of constituents to the Minister for Indigenous Services. We have an issue with water in one of our lakes that is causing fish to die. And it is a very, very bad scenario, and we are asking her to use her authority to reestablish communication with the Chappuas and Piapot First Nations to work towards a resolution in a matter of the low water levels on Round Lake, Saskatchewan. Thank you.
Député.
The Honourable Member for Repentigny. Thank you, Mr. Speaker. On behalf of the Feminine Association for Education and Social Action, that I table this e-petition with 639 signatures, and other signatures will follow on paper as well. They call on the government to look at Bill C-452 against human trafficking and sexual exploitation. We're losing precious time here. This bill was unanimously adopted, and so we're asking the Prime Minister, because it's been 3.5 years, and a number of other petitions and a unanimous motion in the National Assembly, how much time will have to pass before the Prime Minister signs this petition? So that's the goal of this petition, to protect teenagers against criminal prostitution. Thank you, Mr. Speaker.
Member for Peace River Westlock.
Thank you, Mr. Speaker. Mr. Speaker, I have the honor of tabling a petition today, again, recognizing the scourge of human organ trafficking. The people that have signed this petition are looking for a quick passage of Bill C-350 and S-240. To that end, I'd like to table this petition. Thank you, Mr. Speaker.
Honourable Member for Vancouver East.
Very much, Mr. Speaker. I have 2 petitions to table today. The first one is a petition initiated by the Elizabeth Fry Society, who's done tremendous work in our community, and they are asking the House to recognize that the UN Convention of the Rights of the Child is a human right and to which Canada is a signatory to, and therefore they are calling on the Government of Canada to meet the standards of the UN Child for the Rights, sorry, the UN Child, let me try that again. The UN Convention on the Rights of the Child. Yay! All right, my apologies. And they're calling on the government to recognize the barriers within their own direct payments to family systems and remedy that, and that funded services like the Homelessness Partnering Initiative, and to provide funding for client supports for children, and that it provides Canada child benefits and child special allowances for all children, and that it needs to set standards within Canada, social transfer, to ensure that all children without discrimination in any form benefit from special protection measures and assistance, and to recognize children of parents with addictions and homeless children in need of special support to enable them to achieve improved life outcomes and receive equal benefit to their rights under the UN Convention for the Rights of Children.
Honourable member for Saanich Gulf Islands.
Oh, sorry, and then on my second petition,
Or the member for Vancouver East apparently hadn't finished. Member for Vancouver East.
No, all right. Okay. Thank you, Mr. Speaker. On my second petition, I have a petition with 1,596 signatures. And the petitioners are calling for the government to note that the Safe Third Country Agreement states only countries that respect human rights and offer a high degree of protection to asylum seekers may be designated as a safe third country, and that the President of the United States has purposely and premeditatively adopted practices including a Muslim travel ban and forcibly separating children from their parents seeking asylum, and that the United States no longer recognizes domestic violence or gang violence as a legitimate reason for asylum, and that the U.S. has adopted a zero-tolerance policy designated all irregular border crossers claiming asylum as having committed a criminal act subject to prosecution, and that under the Donald Trump administration, the United States has demonstrated it will continue to ignore international human rights and refugee laws. And so therefore, the petition is calling on the government to suspend the Safe Third Country Agreement.
I want to remind honourable members that the petition is the time to give a succinct summary of what the petitioners are calling for, not to read the entire petition or to engage in debate on the subject, but simply to summarize succinctly what the petitioners are calling for. The honourable member for Saanich Gulf Islands.
Thank you, Mr. Speaker. Succinctly, recognizing that time is not on our side, petitioners, being youth petitioners, want us in this Parliament to consider that time is not on our side in fighting the climate crisis. They are petitioning that we take meaningful steps to support the future of young Canadians by fulfilling all our obligations under the Paris Accord.
The honourable member for Langley Aldergrove.
Thank you, Mr. Speaker. I'm honoured to present a petition that highlights impaired driving and the concerns from Canadians. This petition is calling that the charge of impaired driving causing death should be a vehicular homicide. They are asking that a person convicted of impaired driving would have an automatic one-year driving prohibition. A person that causes bodily harm would have a minimum sentence of 2 years, and a person that kills somebody driving impaired would have automatic mandatory minimum of 5 years.
The honourable member for Port Moody Coquitlam.
Thank you, Mr. Speaker. I rise to present a petition from petitioners mostly on Vancouver Island in British Columbia called the Save Wild Salmon petition. The petitioners say Canada, BC in particular, is well positioned to become a world leader in closed containment salmon aquaculture, and they say that Canada needs to invest in safe, sustainable industry that protects Pacific wild salmon, maintains employment, develops new technologies, jobs, and export opportunities. They call on the Government of Canada to immediately transition this harmful industry to safe, land-based, closed containment industry. Thank you, Mr. Speaker.
Presenting petitions. Présentation de pétitions. Questions on the order paper. The Honourable Parliamentary Secretary to the Government House Leader.
Yes, Mr. Speaker, I would ask that all questions be allowed to stand at this time, please.
P. Agreed and so ordered. Ordre du jour.
Orders of the day.
The Honourable Government House Leader.
Mr. Speaker, I move, seconded by the Minister of Justice and Attorney General of Canada, that in relation to Bill C-75, an act to amend the Criminal Code, the Youth Criminal Justice Act, and other acts, to make consequential amendments to other acts, not more than one further sitting day shall be allotted to the consideration of the report stage of the said bill, and not more than one sitting day shall be allotted to the consideration of the third reading stage of the said bill, and that 15 minutes before the expiry of the time provided for government orders on the day allotted to the consideration at report stage and on the day allotted to the consideration at the third reading stage of the said bill, any proceedings before the House shall be interrupted if required for the purpose of this order, and in turn every question necessary for the disposal of the stage of the bill then under consideration shall be put forthwith and successfully without further debate or amendment. Thank you, Mr. Speaker.
Ms. Chager, seconded by Ms. Wilson-Raybould, moves that in relation to Bill C-75, an act to amend the Criminal Code, the Youth Criminal Justice Act, and other acts, and to make consequential amendments to other acts, not more than one further sitting day shall be allotted to the consideration of the report stage of the said bill, and not more than one sitting day shall be allotted to the consideration of the third reading stage of the said bill, and that 15 minutes before the expiry of the time provided for government orders on the day allotted to the consideration at report stage and on the day allotted to the consideration at the third reading stage of the said bill, any proceedings before the House shall be interrupted if required for the purpose of this order, and in turn every question necessary for the disposal of the stage of the bill then under consideration shall be put forthwith and successively without further debate or amendment.
Pursuant to Standing Order 67-1, there will now be a 30-minute question period. I invite the honourable members who would like to ask questions to rise so that the Speaker may have an idea of the number of members who would like to participate in this question period.
The Honourable Member for St. Albert, Edmonton.
Thank you, Mr. Speaker. Bill C-75 was introduced on the day before Good Friday in an effort to hide from Canadians what was in this bill, and now after just now 2 sitting days, the government is already bringing in time allocation at report stage. It is absolutely shameful. At the Justice Committee, Liberal MPs were right to back down from the reclassification of terrorism and inciting genocide. But shockingly, the Liberals have doubled down when it comes to the hybridization of what are currently serious indictable offenses, including human trafficking, impaired driving causing bodily harm, kidnapping a minor, to name just a few. Does the minister not agree that these are also serious offences? Does she not agree with the honourable member for Edmonton Centre when he said, let's be serious, we're talking about terrorism, we're talking about very serious offences? Why doesn't the minister treat impaired driving causing bodily harm, human trafficking, and other offences to be also serious offences?
The Honourable Minister of Justice and Attorney General.
Well, thank you, Madam Speaker, and I appreciate being able to rise to talk about Bill C-75 and the importance of C-75 and the intent behind C-75. There is absolutely nothing that our government is trying to hide with respect to the major, bold reforms that we're seeking in Bill C-75 to the criminal justice system to answer the call of the Supreme Court of Canada in Jordan and other decisions to create efficiencies and to promote the effectiveness of the criminal justice system. That is precisely what we're doing in Bill C-75. This has been considered
considered since we formed government through very robust consultations. I appreciate the discussions and the considerations and listening to 95 witnesses at the House of Commons Committee on Justice and Human Rights who provided very substantial feedback. In terms of the member opposite's question with respect to the hybridization of offences, serious offences will continue to be treated seriously. This does nothing, hybridization of offences, to change the fundamental principles of sentencing. Thank you, Madam Speaker.
Questions and comments? L'honorable député de...
The Honourable Member for Abitibi-Témiscamingue. Thank you very much, Madam Speaker. This bill is a fairly large one. It does correct some problems, but it also creates new problems. So currently, they're trying to improve the justice system to make it more effective, but unfortunately, although certain problems are being solved and some things are being improved, there are also new problems being created. So for each solution, there are two new problems. Does the minister not believe that they should take the time to ensure that all of the new problems being created would be appropriately resolved in the bill, so that when we move forward with this kind of bill, we really solve all of the problems instead of creating new ones that will only increase delays?
Justice.
The Honourable Minister of Justice.
Well, thank you, Madam Speaker, and thank you for the question from the honourable member across the way. I agree. This is a significant bill. This is a large bill. This seeks to amend the criminal code to answer the call of the Prime Minister to me in my mandate letter and our government's commitment to transform the criminal justice system and create efficiencies and effectiveness in that system. I would disagree with the member opposite's statement that this solves some problems and creates others. I disagree with that statement. This legislation and the lead up to the introduction of this legislation back in March of this year was the result of significant consultation right across the country through roundtables. I have personally engaged in 3 federal and provincial and territorial meetings with my counterparts in the provinces and territories, all of whom are supportive of the robust and bold changes in Bill C-75.
Questions and comments? The honourable member for Kitchener-Conestoga.
Thank you, Madam Speaker. We reflect back on the campaign of 2015, sitting in many of our all candidates debates and hearing so clearly that if this government was elected, they would not bring in closure or time allocation. They would get rid of the practice of introducing omnibus bills in Parliament. And Madam Speaker, here we have both of those things broken at the same time. But Madam Speaker, there are some serious offences in C-75 that will be downgraded to hybrid offences, which gives the discretion to prosecute as a summary conviction. Obstructing or violence or to arrest or officiating clergymen. Blood alcohol over the legal limit. Madam Speaker, we know the scourge of drunk driving and impaired driving on our streets. And this is unbelievable that we would actually reduce this. But Madam Speaker, I'm not as concerned right now about those particular items as I am concerned about the fact that this government is intent on shutting down debate on a very serious issue where all parliamentarians should have the option of giving their views and letting their constituents know their views, but instead we have a government that's shutting down debate. Why is she so intent? Why is this government so intent on shutting down debate on this important issue?
Minister of Justice.
Thank you, Madam Speaker. Our government is committed to working cooperatively with all members of this House. I would point out with respect to Bill C-75, there was a total of 7 hours and 45 minutes of debate in the House. This went to committee where there was major discussion among committee members, of which I thank them for that discussion, hearing from 95 witnesses at committee. A total of 27 hours of discussions and a debate happened at committee, and thank you for the suggested amendments that were, many of which were accepted by the government. I would say that we are putting forward a robust bill in C-75 to amend the criminal code. This is not an omnibus piece of legislation. This seeks to address the criminal code changes. And to the member opposite's comments around serious offences, under this legislation, serious offences will still be prosecuted in a serious manner. I'm glad that the member opposite raised impaired driving. I am very pleased that our government was able to pass in Bill C-46 very major legislation to create in Canada among the toughest impaired driving laws in the world. So I appreciate him bringing that up.
Questions and comments? Questions et commentaires. L'honorable député.
The honourable member. For Belleuil-Chambly. Thank you very much, Madam Speaker. I would like to thank the Minister for her answers. However, one point raised by several MPs from in this chamber with regard to time allocation had to do with the complexity of this bill. This bill covers so much territory. We also talked about what is not addressed by the bill, namely the fact that the government did not address the minimum sentencing provisions. The minister spoke about the work accomplished in committee, and that was very good. However, the reason why so much work was done on committee is because, as was just said, this bill is so complex. So my question to the minister is the following. Why impose time allocation on a bill which is so complex? I spoke on debate this bill for 10 minutes rather than 20. And then I saw that the speaker raised her hand saying that debate had been cut off. I know this happens in this House, but it shows that in 10 or even 20 minutes, we don't have time to cover everything contained in this bill. So why does the minister believe that with time allocation and such little debate for all MPs, how can we truly study this very important and complex issue?
Well, thank you, Madam Speaker, and I thank the member for his comments and questions. In terms of time allocation, but more importantly in terms of ensuring that Bill C-75 proceeds, again, we are committed to working with all members of this House. We appreciated the discussion and the debate that came from the Justice Committee and look forward to the discussion that will happen in the other place. Bill C-75 is about addressing delays in the criminal justice system, creating efficiencies and effectiveness. It's our responsibility to address the call of the Supreme Court of Canada to address the delays that exist in the criminal justice system. Bill C-75 is in response to that. Yes, this is a large piece of legislation. It has benefited from 27-plus hours of debate in committee and look forward to continued discussions in this regard. In terms of the member's question around mandatory minimum penalties, we are continuing to work on sentencing reform. This is a commitment that our government has made, and we will continue that discussion and bring forward changes in due course.
Questions and comments? The Honourable Parliamentary Secretary to the Minister of Justice.
Thank you very much, Madam Speaker. As an individual who sat in on those committee meetings, I would ask the Minister if she could elaborate on the extensive analysis that was done after that 27 hours of deliberation by the committee, and indeed, if she could comment to this House upon the committee amendments that were accepted, specifically in respect to paralegals and with respect to routine police evidence, two issues that I know are near and dear to the mandate of this government and the mandate of this minister in terms of increasing access to justice.
The Honourable Minister of Justice.
Well, thank you thank you, Madam Speaker, and to the my honourable colleague for the questions. And again, this gives me the opportunity to stand up and to acknowledge and appreciate the work that was done by all members of the Justice and Human Rights Committee in bringing forward many amendments. In fact, 50 motions to amend Bill C-75 were adopted. The amendment brought forward to remove routine police evidence by way of affidavit was something that our government recognized the testimony of many people that came before the committee. So we were able to accept that amendment. In terms of agent representation, some of the changes that are contained within Bill C-75 raised concerns among many stakeholders that came before the Justice Committee of the inability to have agent representation because of the increase of offence penalties. We have accepted amendments from committee to provide for that, to give provinces and territories the ability to determine agents in terms of representation of various offences. So again, appreciate the input on other amendments as well from the committee.
And comments, the member for Sandwich Gulf Islands.
Madam Speaker, and as this debate is on the issue of time allocation as opposed to the substance of the bill itself, I want to address this to the Minister of Justice, but of course it's pertinent to the government House Leader and all House Leaders. The use of time allocation, which used to be exceptional, and in the 41st Parliament, Liberals who were then in opposition joined everyone in opposition opposing the routine use of time allocation. It's remained routine. This is not healthy in a democracy, and I've put the blame squarely on poor relationships and lack of trust between the government House Leaders of the recognized parties in this place in being able to work together to properly assess what bills need more time and what bills could be gotten through more quickly. I believe that it would be a tonic and help solve the problem if this place returned to the rules we currently have that are in disuse, Madam Speaker, that say that no member of Parliament can read a speech. Those are our rules, but we no longer pay attention to them. If we did not have the ability to read a speech, then political parties in this place would not be able to line up their MPs, those who have no background on the bill, hand them a speech and tell them to read it in order to use up time. I would encourage the Minister of Justice to speak with the government House Leader and all people in this place and consider if we couldn't make Parliament work better by returning to our actual rules, that you can't just stand up and read a speech. You have to know the subject.
The Honourable Minister of Justice.
Well, thank you, Madam Speaker, and I thank my honourable colleague across the way for her comments. And I will say that it is the commitment of our government to work cooperatively with all members in this House to ensure that we have robust debate on bills that we're putting forward. There has been substantial discussion around this. Bill C-75 in this House and at committee, but I do recognize and acknowledge the members' comments and concerns, and understand and will follow up and speak to the House Leader.
Questions and comments? The Honourable Member for Richmond Centre.
Thank you, Madam Speaker. What a good day to celebrate the International Child Day, when human trafficking actually has no time allocation. No, so the way the minister presented that we have to really rush through without going through details, how to protect our seniors, how to protect our children, is just shameful. I believe that time allocation should not be used because we, as members of the Parliament representing our own ridings, have the right to speak and represent them. And rushing through this will only endanger all the communities. So I really question the minister's intention and the House Leader's intention in limiting our privilege to speak in a House to debate about this very complex and very important bill.
The Honourable Minister of Justice.
Well, thank you, Madam Speaker, and I appreciate the comments from the member across the way. I appreciate hearing of her appreciation of the importance of this legislation and having C-75 move through the parliamentary process and be passed in order for us to address the delays in the criminal justice system. To answer the call of the Supreme Court of Canada is a priority for this government, and I would hope a priority for all members in this House. There has been a lot of debate and discussion. As I said at committee, some 27 hours of debate and discussion. I very much, as does our entire government, appreciate the feedback and the amendments that came from committee. Additional amendments requested by stakeholders and voted on by committee members were to repeal vagrancy and the body house offences. Thank you to the committee once again for all of their input, for the amendments that were put forward that improve this legislation.
Questions and comments? The Honourable Member for New Westminster, Burnaby.
Thank you, Madam Speaker. This is another sad day in Parliament because, of course, we remember back in 2015 the Prime Minister making a commitment to change Parliament from the incredibly stubborn actions of the former Stephen Harper government and put into place provisions that actually allowed for democratic debate. Now, Madam Speaker, this is now close to 40 closure motions that have been brought forward in this Parliament by this Liberal government. Now, it's they call it time allocation, but that's basically splitting hairs. It's closure. It's shutting down the right to debate in this House of Commons. We're seeing, at the same time as closures being enacted in the House of Commons, in the Finance Committee, Liberal Liberal representatives systematically defeating all of the opposition amendments that are designed to improve the major flaws in the Budget Implementation Act, huge omnibus legislation that's been given scant hours of treatment, and where Liberal MPs are simply voting down any improvements to the legislation, which means it'll have to be tested by the courts, as we saw under the Stephen Harper government. The Liberals are coming right back to the kind of practices that Canadians deplored, and they're doubling down, Madam Speaker. So here we have a piece of legislation, and the minister admits that the vast majority of amendments were refused. Yes, there were witnesses, but they weren't listening to the witnesses. And my question is very simple. Why have the Liberals enacted all of the worst practices of the Stephen Harper government to ram legislation through without due consideration in this Parliament?
The Honourable Minister of Justice.
Thank you, Madam Speaker, and I'm happy to stand up and speak to the comments and the comments made by the member opposite, and I dispute his comments completely. In terms of not listening to witnesses, that is absolutely not true. My parliamentary secretary, all the members of the Justice Committee had the benefit of hearing from 95 witnesses at the Justice and Human Rights Committee, all of whom spoke about their passion for criminal justice reform, made very concrete suggestions about how the bill can be improved. We accepted many of those recommendations that I believe have very significantly improved Bill C-75. I look forward to continued debate and discussion as this bill goes to the other place. And on top of all the discussion that happened in this House, in committee, we engaged in discussions and consultations right across the country with criminal justice stakeholders. I engaged on an ongoing basis with my counterparts in the provinces and territories, all of whom are supportive of the bold reforms that we're proposing in Bill C-75.
Questions and comments. The honourable member for North Okanagan, Shuswap.
Thank you, Madam Speaker, and I rise today to strongly oppose this time limit on this bill. The minister is boasting about how there's been so much consultation and so much time allowed already. She talked about 7 hours of debate. Well, with over 300 members in this chamber, that breaks down to about 1 minute and 20 seconds per member. We know that the time for debate cannot be broken down that finely, so it'll mean that many members will not even have an opportunity to speak on this bill. I would have liked to have had a chance to speak on this bill because I lost a brother to a drunk driver. Yes, I lost a brother to a drunk driver, and this bill is going to cut back on the penalties for drunk driving. But I will not have a chance to speak in this House because of her time allocation today. I'd like to ask her, how can 1 minute and 20 seconds be considered fair debate for a bill of over 300 pages? Hear, hear. Thank you.
The Honourable Minister of Justice.
Thank you, Madam Speaker. And again, I will stand to speak to the nature of Bill C-75 and the substantial discussion and consultations that we've had on the very elements in Bill C-75 for the last 3 years. I understand and recognize the desire of members to speak to this important piece of legislation. I see many members from the party opposite that have risen in this House to speak to this legislation and the many hours of debate and discussion that occurred at the Justice and Human Rights Committee. We have an obligation as members in this House to move forward and answer the call of the Supreme Court of Canada to address delays in the criminal justice system. Bill C-75 does just that in a comprehensive way, and I look to all members of this House to support this important piece of legislation moving forward.
Questions and comments. The honourable member for Whitby.
Thank you, Madam Speaker. And as mentioned by the Minister of Justice, this piece of legislation is a comprehensive piece of legislation that will help to improve the criminal justice system. We have used time allocation, and it is an important component of allowing us to advance the work that Canadians have brought us here to be able to do. This legislation, along with the appointments that the Minister has made across the country, has helped to ensure that our criminal justice system will be efficient and will move forward in a very effective way. I'm wondering if if the minister could comment further on how this piece of legislation has been thoroughly reviewed by Canadians who have spoken to committee, who have debated in the House, and why this piece of legislation will help to improve the efficiency of our justice system.
The Honourable Minister of Justice.
Well, thank you, Madam Speaker, and I thank my colleague for her comments on the importance of answering the call of Canadians, the call of the Supreme Court to move forward with criminal justice reform that addresses delays in the criminal justice system. To speak to the member's specific questions about what has gone into Bill C-75, in the lead up to the introduction in March of this year, I conducted, my parliamentary secretaries participated in roundtables across the country. We had online surveys and requests for feedback, of which we received thousands of responses, and we produced a report of what we heard. We benefited from years ago and an ongoing discussion and reports from the Senate committee on what we can do to improve delays in the criminal justice system. Many of those recommendations from the other place we have incorporated into Bill C-75. And again, to highlight the discussions and debate that occurred in this House and the robust, again, discussion that happened at the committee in terms of the 95 witnesses that were heard and the 27 hours of debate and discussion of which we benefited from, and improving the bill through various amendments that came from the committee.
Questions and comments? The Honourable Member for Vancouver East.
Thank you very much, Madam Speaker, and I thank the Minister for her comments. As a new member, really, in this House of Commons, and I remember campaigning in 2019 at some of the campaign stops. And the minister actually was at some of those campaign stops where I was at. And we all talked about how we needed to see a government that's different from the Harper government, that would do things differently. The minister advocated for and campaigned on real change. Part of that change as a commitment by the Prime Minister of today is to say that we will no longer engage in the practice that the Harper administration embarked on, and that is to shut down debate. Surely the minister understands how fundamentally important that is to our democracy. That was something that she campaigned on and advocated for out in the public. Yet here we are as a new member. We've seen bill after bill after bill where the debate is in fact being shut down, this being another one of them. The minister talked about consultation before the bill was introduced, but now that the bill is here, I as a member have not had a chance to engage in this debate. I would very much like to. I'm not part of the committee that engaged in the discussion around that, as the minister knows. So only one member from the NDP would be allowed to be on that committee. And so many of us has been excluded from that process. So how is that a new way of business? How is that good for a democracy when the government consistently shut down debate, including this bill?
The Honourable Minister of Justice.
Well, thank you, Madam Speaker, and thanks to my colleague across the way for her questions. And I do remember going before the election on campaign stops, talking about doing things differently. And in fact, our government is doing things differently. We have engaged in consultation for the past 3 years. There was a lot of discussion at committee. There was a lot of discussion in this House. I would be very happy to sit down with the member opposite to talk more about Bill C-75 and the provisions that are contained therein. Again, we are doing things differently. We have fundamentally changed the way that we engage with Canadians, and I look forward to discussion and debate in the other place. But we also have a responsibility to ensure that our legislation moves through the parliamentary process, so we address the desires and the needs of Canadians. We address the delays in the criminal justice system. That is a commitment that we have made as a government to heed the call of the Supreme Court of Canada and address delays.
Questions and comments? The Honourable Member for Yorkton Melville.
Thank you, Speaker. It is really important to me that we are having this discussion, and I do wish that there would be a different outcome than is going to take place. But the reality is that time allocation in this circumstance, what is it achieving other than simply moving forward legislation that this government wants, that quite honestly Canadians are not in favor of? We represent the House of Commons, the common people who want to be heard, and quite honestly, in the course of the last 3 years, have engaged more in this process than they have considerably over time in the past, because of the frustration that we are not having opportunity to present in this House and to argue the scenarios the way that we should. The comments from the Minister indicate that this is to meet the desires of Canadians, to deal with delays and create efficiencies, when Canadians are saying over and over again, this is downloading to the provincial courts. It is not improving efficiencies. It's causing issues. Excuse me, Madam Speaker, a number of people have had significant opportunity to speak. I would like to finish.
So I just want to remind the member that I am looking at the clock and I am trying to give people individuals about a minute each to ask questions, and the same thing for the response. So I would ask, these are questions and comments. There was a lot of people that wanted to participate. I would ask the member to ask her question.
Madam Speaker, my question to this government is why they are choosing to not listen to Canadians. It is not enough to simply take notes and then do what you want to do regardless, when Canadians are incredibly unhappy with the direction that this is going on their behalf.
The Honourable Minister of Justice.
Well, I again thank you, Madam Speaker, and appreciate the comments and appreciate the opportunity to respond to the comments. The member opposite asked, what is this achieving? What is Bill C-75 achieving? It is achieving the necessity of addressing delays in the criminal justice system, achieving efficiencies and effectiveness. And again, I disagree with the characterization that Canadians aren't supportive of this. We have done substantial consultation right across the country, and in terms of the member opposite's comments about downloading to the provinces, I would like to inform the member opposite that I have been working with the provinces and territories on an ongoing basis for 3 years, and they are supportive of this. This is not a download on the provinces and territories. This is cooperative federalism at its best around the administration of justice to ensure that we do everything we can as actors in the criminal justice system to heed the call of the Supreme Court of Canada. This has robust support right across the country.
We have time for a very brief question. The honourable member for St. Albert Edmonton, a brief question.
Thank you, Madam Speaker. The Minister of Justice said that the hybridization has nothing to do with sentencing because the sentencing principles will remain the same. Well, no kidding, the sentencing principles will remain the same. But what is changing is that the maximum sentence would go from 10 years to 2 years less a day. So in light of that, how does the hybridization have nothing to do with sentencing?
The Honourable Minister of Justice has just 30 seconds to respond, please.
Well, thank you, Madam Speaker. In terms of the hybridization of offences, the reclassification of offences, again, this was supported by my counterparts in the provinces and territories. This has nothing to change the fundamental principles of sentencing. It does, serious offences still will be treated by the courts and prosecutors as serious. What this does is give the necessary discretion to prosecutors to proceed based on the circumstances of the individual case in the most effective way possible. This does not change how serious offences will be approached, and any characterization otherwise is a mischaracterization.
Il est de mon devoir d'interrompre maintenant.
It is my duty to interrupt the proceedings and put forthwith every question necessary to dispose of the report stage of the bill now before the House.
Move that in relation to Bill C-75, an act to amend the Criminal Code, the Youth Criminal Justice Act, and other acts, and to make consequential amendments to other acts, not more than one further sitting day shall be allotted to the consideration at report stage of the bill, and one sitting day shall be allotted to the consideration at third reading stage of the said bill. And que
that 15 minutes before the expiry of the time provided for government orders on the day allotted to the consideration at report stage and on the day allotted to the consideration at third reading stage of the said bill, any proceedings before the House shall be interrupted, if required, for the purpose of this order, and in turn every question necessary for the disposal of the stage of the bill then under consideration shall be put forthwith and successively without further debate or amendment.
of the House to adopt the motion? All those in favour of the motion will please say yea. All those opposed will please say nay. À mon avis, les oui l'ont pas.
In my opinion, the yeas have it.
La question.
The question is the following one. Ms. Shiger, seconded by Ms. Wilson-Raybould, moved that in relation to Bill C-65, an act to amend the Criminal Code, the Youth Criminal Justice Act, and other acts, and to make consequential amendments to other acts, not more than one further sitting day shall be allotted to the consideration at report stage of the bill, and one sitting day shall be allotted to the consideration at third reading stage of the said bill, and that 15 minutes before the expiry of the time provided for government orders on the day allotted to the consideration at report stage. Shall I dispense?
All those in favor of the motion will please rise.
Monsieur Trudeau.
Monsieur Trudeau.
Mr. Hare.
Mr. Hare.
Mr. O'Regan.
Mr. O'Regan.
Mr. Sajan.
Mr. Sajan.
Madame Joly.
Madame Joly.
Mr. Goodale.
Mr. Goodale.
Mr. Rodriguez.
Mr. Rodriguez.
Ms. Petitpas-Taylor.
Ms. Petitpas-Taylor.
Ms. Freeland.
Ms. Freeland.
Mr. Leblanc.
Mr. Leblanc.
Ms. Chager.
Ms. Chager.
Ms. Qualtrough.
Ms. Qualtrough.
Mr. Morneau.
Mr. Morneau.
Mr. Bryson.
Mr. Bryson.
Ms. Wilson-Raybould.
Ms. Wilson-Raybould.
Mr. Macaulay-Cardigan.
Mr. Macaulay-Cardigan.
Ms. Bennett.
Ms. Bennett.
Mr. Baines.
Mr. Baines.
Ms. Haidu.
Ms. Haidu.
Mr. Hussain.
Mr. Hussain.
Mrs. Philpott.
Mrs. Philpott.
Mr. Blair.
Mr. Blair.
Ms. Tassie.
Ms. Tassie.
Ms. Ing.
Ms. Ing.
Mr. Casey Cumberland Colchester.
Mr. Casey Cumberland Colchester.
Mr. Easter.
Mr. Easter.
Mr. McKay.
Mr. McKay.
Ms. Scrow. Mrs. Crow. Monsieur Lauzon, ajouter la petite nation. Monsieur Lauzon, ajouter la petite nation. Mrs. McCrimmon. Mrs. McCrimmon. Ms. Jones. Ms. Jones. Mr. Algabra. Mr. Algabra. Mr. Leslie. Mr. Leslie. Mr. Carr. Mr. Carr. Ms. Gould. Ms. Gould. Mr. Sohi. Mr. Sohi. Mr. Champagne. Mr. Champagne. Mr. Holland. Mr. Holland. Ms. Monsef. Monsef. Monsieur Garneau. Monsieur Garneau. Ms. Duncan Etobicoke North. Ms. Duncan Etobicoke North. Ms. McKenna. Ms. McKenna. Madame Leboutillier. Madame Leboutillier. Madame Bibeau. Madame Bibeau. Mr. Wilkinson. Mr. Wilkinson. Mr. Cuzner. Mr. Cuzner. Ms. Murray. Ms. Murray. Mr. Casey Charlottetown. Mr. Casey Charlottetown. Mr. Lemetti. Mr. Lemetti. Mr. Miller, Ville-Marie, le Sud-Ouest Île des Sœurs. Mr. Miller, Ville-Marie, le Sud-Ouest Île des Sœurs. Monsieur Schiffke. Mr. Schiffke. Mrs. Romanato. Mrs. Romanato. Monsieur Hébert. Monsieur Hébert. Mr. Eiking. Mr. Eiking. Mr. Bagnall. Bagnall. Mr. Paradis. Mr. Paradis. Mr. McGinty. Mr. McGinty. Mr. Hernandez Sangri. Mr. Hernandez Sangri. Mr. Fillmore. Mr. Fillmore. Mrs. Jordan. Mrs. Jordan. Ms. Goldsmith-Jones. Ms. Goldsmith-Jones. Mr. Oliver. Mr. Oliver. Mr. Lefebvre. Mr. Lefebvre. Mr. Mendocino. Mr. Mendocino. Mr. Lamour. Mr. Lamour. Mr. McKinnon-Gatineau. Mr. McKinnon-Gatineau. Mr. Lightbound. Mr. Lightbound. Mr. O'Connell. Mr. O'Connell. Mr. Varani. Mr. Varani. Mr. Poisson. Mr. Poisson. Mr. Fraser Central Nova. Mr. Fraser Central Nova. Ms. Young. Ms. Young. Mr. Schultz. Mr. Schultz. Monsieur Vandal. Mr. Vandal. Ms. Cara. Ms. Cara. Mr. DeCourcy. Mr. DeCourcy. Mr. Scarpalagia. Mr. Scarpalagia. Mr. Sims. Mr. Sims. Mr. Tansey. Mr. Tansey. Mr. Jesnevsky. Mr. Jesnevsky. Mr. Dollywall. Mr. Dollywall. Mr. Pesky-Solido. Mr. Pesky-Solido. Madame Mendez. Madame Mendez. Mr. Oliphant. Mr. Oliphant. Mr. Dubourg. Mr. Dubourg. Mr. Aldaig. Mr. Aldaig. Mr. Amos. Mr. Amos. Mr. Arsenault. Mr. Arsenault. Mr. Aria. Mr. Aria. Mr. Ayoub. Mr. Ayoub. Mr. Badaway. Mr. Badaway. Monsieur Bayless. Mr. Bayless. Mr. Boissonneau. Mr. Boissonneau. Mr. Bossio. Mr. Bossio. Mr. Bettina. Mr. Bettina. Mr. Breton. Mr. Breton. Mr. Cesar Chauvin. Mr. Cesar Chauvin. Mr. Biddle. Mr. Biddle. Madame Lapointe. Madame Lapointe. Mr. Bruson. Mr. Bruson. Mr. Moff. Mr. Moff. Ms. Dillon. Ms. Dillon. Mr. Drouin. Mr. Drouin. Ms. Zerowitz. Ms. Zerowitz. Mr. Assassi. Mr. Assassi. Mr. Khoury. Mr. Khoury. Mr. Ellis. Mr. Ellis. Mr. Erskine Smith. Mr. Erskine Smith. Mr. Ailson. Mr. Ailson. Mr. Fergus. Mr. Fergus. Mr. Finnegan. Mr. Finnegan. Mr. Fisher. Mr. Fisher. Mr. Fonseca. Mr. Fonseca. Mr. Fragascados. Mr. Fragascados. Mr. Fraser West Nova. Mr. Fraser West Nova. Mr. Fuhr. Mr. Fuhr. Mr. Gerritsen. Mr. Gerritsen. Mr. Graham. Mr. Graham. Mr. Greywall. Mr. Greywall. Mr. Hardy. Mr. Hardy. Mr. Harvey. Mr. Harvey. Mr. Housefather. Mr. Housefather. Ms. Hutchings. Ms. Hutchings. Mr. Yakino. Mr. Yakino. Mr. Jahari. Mr. Jahari. Mr. Levitt. Mr. Levitt. Mr. Long. Mr. Long. Mr. Longfield. Mr. Longfield. Ms. Ludwig. Ms. Ludwig. Mr. Maloney. Mr. Maloney. Mr. Massé Avignon Lametis Matan Metapédia. Mr. Massé Avignon Lametis Matan Metapédia. Mr. May Cambridge. Mr. May Cambridge. Mr. McDonald. Mr. McDonald. Mr. McKinnon Coquitlam Port Coquitlam. Mr. McKinnon Coquitlam Port Coquitlam. Mr. McLeod Northwest Territories. McLeod Northwest Territories. Mr. Morrissey. Mr. Morrissey. Madame Nessif. Madame Nessif. Mr. Peterson. Mr. Peterson. Mr. Picard. Mr. Picard. Mr. Rioux. Mr. Rioux. Mr. Robillard. Mr. Robillard. Ms. Rudd. Ms. Rudd. Mr. Rumi. Mr. Rumi. Mr. Rusnak. Mr. Rusnak. Mr. Hota. Mr. Hota. Mr. Saini. Mr. Saini. Mr. Sanson. Mr. Sanson. Mr. Sanga. Mr. Sanga. Mr. Sarai. Mr. Sarai. Mr. Seri. Mr. Seri. Madame Shanahan. Madame Shanahan. Mr. Sheehan. Mr. Sheehan. Mr. Cedar Mission Mascot Fraser Canyon. Mr. Cedar Mission Mascot Fraser Canyon. Ms. Cedar Brampton South. Ms. Cedar Brampton South. Mr. Tabera. Mr. Tabera. Mr. Sobera. Mr. Sobera. Mr. Spengeman. Mr. Spengeman. Mr. Tan. Mr. Tan. Ms. Vandenbeld. Ms. Vandenbeld. Mr. Whalen. Mr. Whalen. Mrs. Zaid. Mrs. Zaid. Madame Fortier. Madame Fortier. Madame Lambropoulos. Madame Lambropoulos. Mr. Hogue. Mr. Hogue. Mr. Rota. Mr. Rota. Mr. Rogers. Mr. Rogers. Ms. Yip. Ms. Yip. Mr. Tutu. Mr. Tutu.
All those opposed to the motion will please rise.
Ms. Bergen. Ms. Bergen. Mr. Nicholson.
Mr. Nicholson.
Ms. Finley.
Ms. Finley.
Ms. Gledoux.
Ms. Gledoux.
Mr. Bazan.
Mr. Bazan.
Mr. Kent.
Mr. Kent.
Mr. Reyes.
Mr. Reyes.
Mr. Poliev.
Mr. Poliev.
Mr. Deltel.
Mr. Deltel.
Mrs. Block.
Mrs. Block.
Mrs. McLeod, Camels, Thompson, Caribou.
Mrs.
Mrs.
McLeod, Cameron, Thompson, Caribou.
Monsieur Blaney, Bellechasse, Les Échemins-Lévis.
Monsieur Blaney, Bellechasse, Les Échemins-Lévis.
Mr. McColeman.
Mr. McColeman.
Mr. Nuttall.
Mr. Nuttall.
Mr. Barlow.
Mr. Barlow.
Mr. Bertud.
Mr. Bertud.
Mr. Martel.
Mr. Martel.
Mr. Albus.
Mr. Albus.
Mr. Chong.
Mr. Chong.
Mr. Richards.
Mr. Richards.
Mr. Workington.
Mr. Workington.
Mr. Strahl.
Mr. Strahl.
Mrs. Stubbs.
Mrs. Stubbs.
Mrs. Vecchio.
Mrs. Vecchio.
Mrs. Wong.
Mrs. Wong.
Mr. Abuteyev.
Mr. Abuteyev.
Mrs. Kuzi.
Mrs. Kuzi.
Mr. Kelly.
Mr. Kelly.
Mr. Generu.
Mr. General.
Mr. Tilson.
Mr. Tilson.
Mr. Warwalk.
Mr. Warwalk.
Mr. Sorensen.
Mr. Sorensen.
Mr. Reed.
Mr. Reed.
Mr. Lukiski.
Mr. Lukiski.
Mr. Nader.
Mr. Nader.
Mrs. Wagenthal.
Mrs. Wagenthal.
Mr. Broussard.
Mr. Broussard.
Mr. Sweet.
Mr. Sweet.
Mr. Carey.
Mr. Carey.
Mr. Anderson.
Mr. Anderson.
Madame Boucher.
Madame Boucher.
Mr. Lake.
Mr. Lake.
Mr. Calkins.
Mr. Calkins.
Mr. Falk-Provencher.
Mr. Falk-Provencher.
Mr. Gould.
Mr. Gould.
Mr. Kimmich.
Mr. Kimmich.
Mr. Macaulay Edmonton West.
Mr. Macaulay Edmonton West.
Mr. Lobb.
Mr. Lobb.
Mr. Kitchen.
Mr. Kitchen.
Mr. Jennis.
Mr. Jennis.
Mrs. Falk Battleford Floyd Minster.
Mrs. Falk's Battleford Lords Minster.
Mr. Albrecht.
Mr. Albrecht.
Mr. Dreeshen.
Mr. Dreeshen.
Mr. Hoback.
Mr. Hoback.
Mr. McGuire.
Mr. McGuire.
Mr. Cooper.
Mr. Cooper.
Mr. Arnold.
Mr. Arnold.
Mr. Clark.
Mr. Clark.
Mr. Godin.
Mr. Godin.
Mr. Stanton.
Mr. Stanton.
Mr. Van Kesteren.
Mr. Van Kesteren.
Mr. Shipley.
Mr. Shipley.
Mr. Iglinski.
Mr. Iglinski.
Mr. McKenzie.
Mr. McKenzie.
Mr. Yerdega.
Mr. Yerdega.
Mr. Diot.
Mr. Diot.
Mr. Leipert.
Mr. Leipert.
Mr. Shields.
Mr. Shields.
Mr. Vierson.
Mr. Vierson.
Mr. Waugh.
Mr. Waugh.
Mr. Motts.
Mr. Mott.
Back to Mr. Weber.
Mr. Weber.
Mr. Mr. Benzin.
Mr. Benzin.
Mr. Lloyd.
Mr. Lloyd.
Mr. Trost.
Mr. Trost.
Monsieur Caron.
Mr. Cahill.
Mr. Julian.
Mr. Julian.
Madame Brosseau.
Madame Brosseau.
Mr. Cullen.
Mr. Cullen.
Mr. Angus.
Mr. Angus.
Mr. Massey Windsor West.
Mr. Massey Windsor West.
Ms. Matheson.
Ms. Matheson.
Ms. Duncan Edmonton Strathcona.
Ms. Duncan Edmonton Strathcona.
Mr. Garrison.
Mr. Garrison.
Madame Boutin Suite.
Madame Boutin Suite.
Ms. Blaney North Allen Powell River.
Ms. Blaney North Allen Powell River.
Mr. Rankin.
Mr. Rankin.
Monsieur Dubé.
Monsieur Dubé.
Monsieur Bouleris.
Monsieur Bouleris.
Madame Laverdière.
Madame Laverdière.
Monsieur Dussault.
Monsieur Dussault.
Mr. Donnelly.
Mr. Donnelly.
Monsieur Aubin.
Monsieur Aubin.
Monsieur Nautel.
Nautel.
Ms. Malcolmson.
Ms. Malcolmson.
Ms. Ramsey.
Ms. Ramsey.
Ms. Kwan.
Ms. Kwan.
Madame Quash.
Madame Quash.
Mr. Blakey.
Mr. Blakey.
Monsieur Choquette.
Mr. Choquette.
Madame Moore.
Madame Moore.
Mr. Duval.
Mr. Duval.
Mr. Cannings.
Mr. Cannings.
Mr. Johns.
Mr. Johns.
Mr. McGregor.
Mr. McGregor.
Ms. Benson.
Ms. Benson.
Madame Trudel.
Madame Trudel.
Madame Sans Souci.
Madame Sans Souci.
Ms. Hardcastle.
Ms. Hardcastle.
Madame Hughes.
Madame Hughes.
Monsieur Beaulieu.
Monsieur Beaulieu.
Monsieur Plamondon.
Monsieur Plamondon.
Monsieur Sainte-Marie.
Monsieur Sainte-Marie.
Monsieur Thériault.
Monsieur Thériault.
Madame Posé.
Madame Posé.
Monsieur Fortin.
Monsieur Fortin.
Monsieur Barcelou Duval.
Monsieur Barcelou Duval.
Ms. May Sandwich Gulf Island.
Ms. May Sandwich Gulf Island.
Mr. Weir.
Mr. Weir.
Thank you, Jeffrey.
Yeas pour 168, 168. Nays contre 119, 119.
I declare the motion carried. Orders of the day.
Commons resuming report stage on motions in Group 1 of Bill C-75, an act to amend the Criminal Code, the Youth Criminal Justice Act and other acts, and to make consequential amendment to other acts.
Okay. Je désire informer la...
I would like to inform the House. Order, please. Order. It is my duty to inform the House that because of the debate on time allocation, government orders will be extended by 30 minutes.
Debate. L'honorable député d'Edmonton.
The Honourable Member for Edmonton Centre.
Mr. Speaker, I rise today to express my support for Bill C-75, an act to amend the Criminal Code, the Youth Criminal Justice Act and other acts, and to make consequential amendments to other acts. I would like to use my time today to discuss the proposed changes to this bill that affect the LGBTQ2 community, human trafficking, and the victim surcharge. As Special Advisor to the Prime Minister on LGBTQ2 issues, I am particularly proud of the work of our government on advancing the rights of LGBTQ2 Canadians and the work of the Standing Committee on Justice and Human Rights in making concrete, tangible, legislative changes that improve the lives of lesbian, gay, bisexual, transgender, queer, and two-spirit Canadians. Today, Madam Speaker, on the International Trans Remembrance Day, when we pause to reflect on the lives of transgender people here in Canada and around the world, lost to murder, suicide, hatred and discrimination, lives diminished due to overt transphobia and misogyny, the daily discrimination faced by trans children, siblings, parents and their loved ones, I am proud, as the first openly gay MP elected from Alberta to this House, that the Parliament passed C-16 to protect trans persons in the Criminal Code and in the Canadian Human Rights Act, and I'm particularly proud that our government led this charge. I'm also proud of the work of our government in passing legislation to enable Canadians who have criminal records for same-sex consensual activity to have these records expunged and I acknowledge the leadership of the Minister of Public Safety on this file. I would also like to thank the Minister of Justice and Attorney General for including in C-75 the removal of Section 159, which discriminates against young gay or bisexual men, which would now be removed from the Criminal Code with the passing of C-75. I also applaud the work of the committee and the ministry in responding to expert testimony for the repeal of body house and vagrancy provisions which were used by police forces to arrest gay men who frequented gay clubs and bathhouses, men arrested in these police raids, many now in their 60s, 70s, and 80s, who still face criminal records for these charges. We heard the testimony, and the committee and the ministry responded. And should C-75 pass, Madam Speaker, these odious provisions in the Criminal Code will be removed, and amends can thus be made. As it pertains to human trafficking and the victim surcharge, je pense que c'est très important d'annoncer que
I think it's very important to announce that human trafficking is unacceptable, and it's a very serious concern for the government, which is why we are still working in close collaboration with the provinces and territories and organized law enforcement agencies, victim services, organizations representing Indigenous peoples and other international groups in order to prevent any type of human trafficking in Canada and around the world, and to prosecute the authors of these crimes. The severity of the sentences will reflect the severity of the crime.
Its clandestine nature, and because of the victims' reluctance to report their situations out of fear of their traffickers. Madam Speaker, we heard this testimony across the country when the Committee of Justice and Human Rights traveled the country to listen to victims of human trafficking and to see how we could change the criminal code to provide more opportunities for police and to work with those organizations that work with victims. The legislative changes provided within Bill C-75 would provide police and prosecutors with additional tools for investigation and prosecution. And these measures would bring the perpetrators of human trafficking to justice so they can answer to the severity of their actions. The amendments proposed in Bill C-38 would bring into force amendments that have already been passed by Parliament but were not promulgated in the former parliamentary initiative Bill C-452. It would also strengthen legislation to combat all forms of human trafficking, whether through sexual exploitation of forced labor, while respecting the rights and freedoms guaranteed in our Constitution. Madam Speaker, we heard about heinous crimes being committed, not just to people that are unknown to the perpetrators, but to family members. Family trafficking exists in this country, and we must make sure that police forces are armed with the tools to be able to put an end to such heinous crimes. Plus précisément, les changements proposés face.
More specifically, changes proposed will help to prosecute those responsible for human trafficking. It will allow the Crown to determine that the accused had influence on the movements of a victim by showing that the accused lived with the victim or usually was with the victim. Human trafficking will be added to the list of offenses which will fall under the reversal of the burden of proof.
That affect the victim surcharge. Bill C-75 proposes to restore judicial discretion to waive the victim surcharge by guiding judges to waive the victim surcharge only when the offender is truly unable to pay. For certain offences against the administration of justice, where the total amount would be disproportionate in certain circumstances, the bill also provides for limited judicial discretion to not impose a federal victim surcharge amount per offence. The federal victim surcharge, which is set out in the Criminal Code, is imposed on a sentencing basis, and revenue is collected and used by the province or territory where the Criminal Act was committed to assist in the sentencing process funding for victim services. Bill C-75 maintains that the federal victim surcharge must be imposed ex officio and must apply cumulatively to each offence. However, in order to address concerns about the negative impact of current federal victim surcharge provisions on marginalized offenders, the bill provides limited judicial discretion regarding the mandatory and cumulative imposition of the surcharge under certain circumstances. Bill C-75 provides clear direction as to what constitutes undue hardship. These guidelines are intended to ensure that the mandatory exemption or waiver is applied consistently and only to offenders who are truly unable to pay the surcharge. In addition, the bill states that undue hardship refers to the financial ability to pay and is not simply caused by harm associated with incarceration. Madam Speaker, we're trying to avoid the criminalization and over-criminalization of people simply because of their inability to pay a federal victim surcharge. For certain offences against the Justice Administration, in the event that the cumulative surcharge is disproportionate to the circumstances, Bill C-75 contains provisions allowing an exception to the victim fine surcharge ratio. And this exception applies to two types of offences against the administration of justice: failure to appear in court and breach of conditions of bail by a peace officer or court order, and only when said breach did not cause any moral, bodily, or financial damage to the victim.
Studies have shown that marginalized offenders, including Indigenous offenders and those who suffer from mental health problems or addicts, are overrepresented amongst those who were found guilty of an offense against the administration of justice. It is not likely that these groups who cannot afford to pay the victim surcharge, or who can only pay part of it because of their life situation or because of cumulative offenses, would not contribute in any significant way to the victim surcharge monies sent to the provinces and territories.
Suffer undue hardship as a result of the mandatory victim surcharge are, by the current application of the provisions, hampered in the ability to regain financial stability. This places them in a situation where the surcharge does not allow them to successfully reintegrate into society after serving sentences or paying their outstanding fines, and they risk reoffending. These types of situations, Madam Speaker, do not help survivors or victims of crime or the provision of services to help them. This proposed exception is consistent with the principles of fairness and equity. I am confident that by maintaining a higher mandatory surcharge, this proposed legislation supports the objectives of the victim surcharge to provide a source of funding for the provincial and territorial victim services while strengthening offender accountability regarding victims and society in general. At the same time, it's in keeping with the principles of proportionality, fairness, and respect for the Canadian Charter of Rights and Freedoms. Madam Speaker, not having gone through law school, I can tell you it's an honour to serve in this committee and to be part of making C-75 appear in this House today. Thank you.
Well done. Questions and comments? The honourable member for Thorndale-Lambton.
Thank you, Madam Speaker, and I'd like to thank my colleague opposite for his intervention. I was wondering if he could explain why he thinks that forcible confinement or kidnapping of a minor and forced marriage is a minor enough offence that it should have a summary conviction of less than 2 years or a fine as laid out in C-75. Thank you.
L'honorable député de Edmonton Centre.
The honourable member for Edmonton Centre.
Remarks that I was speaking about the victim surcharge, what we're doing for the LGBTQ community, and those issues. And I can say very clearly that I'm going to answer the question if the heckling would stop. And so what I can say, Madam Speaker, very clearly is that the hybridization of offences is providing the courts with the tools they need to make sure that we respect our obligations under Jordan's principle. Nobody wants to see criminals on the street because they didn't get their time in court within 2 years. Principles of sentencing are not affected by C-75. That's Section 718 of the Code, and you can go look at it. That's why hybridization is another tool for prosecutors, and they will be able to use it.
Questions and comments? The honourable member for St. Albert, Edmonton.
Yeah, thank you, Madam Speaker. Sherry Arsenault lost her 18-year-old son at the hands of an impaired driver, along with 2 other young men from Edmonton. She came to the Justice Committee and she pleaded with Liberal MPs not to reclassify, not to hybridize the very serious offence of impaired driving causing bodily harm. The member for Edmonton Centre rightfully supported our amendments to not reclassify terrorism and genocide-related offences. The members said, in relation to those offences, let's be serious. We're talking about terrorism. We're talking about very serious offences, unquote. What does the honourable member have to say to Sherry Arsenault? Does he not consider impaired driving causing bodily harm to be a very serious offence?
The honourable member for Edmonton Centre.
Madam Speaker, if the member from St. Albert Edmonton were to go back in the tape, he would also see that I was very clear in his comments at the committee and said hogwash and poppycock to his politicisation of a very serious matter in C-75. I have met with Ms. Arsenault. I have met with George Mariner. They are constituents, and quite frankly, that member knows, as members on the other side know, this is not a sentencing question. We doubled the fines for impaired driving to 14 years, and I can tell you this is going to help us respect the Jordan's principle, and he can be upset about this just like I am. This is going to help us in the administration of justice.
Order! 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 The honourable member for Edmonton, St. Albert Edmonton, had an opportunity to ask the question. He may not like the answer, but he should be respecting the House and waiting if he wants to ask another question. Questions and comments. The Honourable Parliamentary Secretary to the Minister of Justice. A brief question, please.
Thank you, Madam Speaker. I'd compliment the member for his work on the Justice Committee and also in his role as Special Advisor on LGBTQ issues. On nearing the one-year anniversary of a historic apology made in this House to the LGBTQ2 community by the Prime Minister on November 28th of last year, the important component of that apology was the expungement of records. Could the honourable member explain why the Body House and vagrancy amendments that were passed at committee help inform and complete the work of that apology in terms of addressing LGBTQ discrimination?
The honourable member for Edmonton Centre.
Thank you, Madam Speaker, and I thank the Parliamentary Secretary for his leadership on this file. It's very clear the Prime Minister was clear in his apology that we had work to do on the Body House provisions. The committee unanimously agreed to repeal that from C-75, and including vagrancy provisions. The gay men were charged, arrested, and now have criminal convictions for simply going to meet other men in bathhouses or gay clubs. This change would allow future additions to happen to expungement legislation so that those records could be expunged.
Resuming debate, the honourable member for Elmwood Transcona.
Well, thank you very much, Madam Speaker. I'm pleased to rise and put some thoughts on the record with respect to Bill C-75, which is the government's response, we're told, to the Jordan decision, which had to do with lengthy delays in the criminal justice system in Canada, and of course the ruling maintained that cases had to be dealt with within a certain amount of time, or the people accused of committing the crime would be off the hook. And we've seen across the country instances of people accused of very serious crimes not being tried in court because of a failure to meet the deadline. So it is quite important, I think, that both the government but also Parliament take action to, and it's a long-standing, it's a long-standing complaint, not just with some of the most serious crimes and trials, Madam Speaker, but we hear often from Canadians who have had occasion in one way or another to deal with court proceedings, often, especially if they're victims or they're families of the victim, to be outraged at the amount of time that it takes to get justice. And of course, justice delayed too often is justice denied. The Jordan decision emphasizes that even more so and raises the stakes in terms of being able to deal with issues in a timely way, because if we don't now, we face the situation of people never being tried for the crimes that they're accused of having committed. So our responsibility as parliamentarians is to judge whether, on balance, this piece of legislation presented by the government and not amended greatly at committee, I have to say. I know the honourable member for Victoria and the NDP caucus did a lot of great work on this bill and made a lot of proposals at committee that were not accepted by the government, and so this really does remain a government package of reforms, and our duty as parliamentarians is to decide whether, on balance, this is going to address the issues that were raised in the Jordan decision and expedite our legal processes so that Canadians can expect to get justice through the courts. I have to say at the outset that one of the ways that the government could have done that prior to presenting any legislation in this House would have been to act swiftly to appoint federal judges. And it's been an ongoing story of this Parliament in terms of the failure of the Justice Minister to ensure that the roster of judges is full. And so we've heard it many times in this House that the government ought to have been acting more quickly. Vacancies remain on the bench, and the fact of the matter is, even if you had perfect laws, and we don't now, and we won't after Bill C-75 passes, Madam Speaker, if you don't have judges to hear the cases, then it matters very little what the laws on the books are, because it's the judges that hear the cases and the judges that make decisions. So it is incumbent upon the government to move more quickly on that than they have. It's been 3 years now. Surely the government isn't going to make the case that Canada doesn't have people qualified to hold those positions. So the people are out there, and it's a matter of the government making it a priority to actually get those appointments happening. Saying it's a priority isn't enough. They have to actually appoint those judges. So I don't want to hear government members get up and talk about how important it is to them. I'll wait and see when those positions get filled. That's the true test and testament as to how important this is for the government, and so far it hasn't been very important. The other thing that we know in terms of justice reform, if this is the government's signature justice reform, and it certainly appears to be, and this is also a contributing factor when we talk about what's at stake in the Jordan decision, is the issue of mandatory minimum sentences. That was something that was very popular with the previous government. For a wide range of criminal charges, they brought in mandatory minimum sentences. We know that those are problematic in a number of ways. I think they're problematic in principle, because the fact of the matter is that no two crimes are the same, and there are different circumstances depending on the particular crime and who's involved, and the people best qualified to make decisions about what is an appropriate amount of time to serve, along with other measures like addictions treatment and whatever else that factor into sentencing, are the people who hear the case. And I don't think it's for Parliament to prejudge for any particular case or set of cases in advance what the appropriate punishment is. That's why we have judges, people who are trained in the legal profession, people who have seen many different cases and are able to discriminate between different cases. And so I think it's appropriate to entrust that work to judges for whom it's a profession, and mandatory minimum sentences is about taking that away. One of the side effects of that is that when people, and particularly on smaller charges like minor drug possession and charges of that nature, when they know that if they plead guilty, there's going to be a mandatory 2, 3, 4, 5 years in jail, it really disincentivizes them to plead guilty. And so one of the tools that we have in order to make sure the most serious cases are heard in a timely way, and that murderers and gang members aren't getting off easy because of the Jordan decision, is to take some of those smaller cases around drug possession or something else and plead them out. And people aren't going to do that if it means serious jail time. And again, there are people in the courts who and police as well who are involved in those kinds of decision making when they have that discretion. And I think it's important to leave it to judges and prosecutors and the police to prioritize those cases, exactly to make sure that the worst ones are tried, and the ones that they have the best case of getting a conviction on are tried, so that those people get justice and the courts aren't bogged down with other kinds of cases without any ability to make a judgment call about what's relatively more important or relatively less important. So that was a major problem with changes to the justice system we saw in the last Parliament. Outside of the Conservative Party and people who supported them in the last election, I think there was a pretty broad consensus that those things had to be repealed, and we don't see that here. So that's an obvious thing that would have helped with respect to the Jordan decision that's not in this legislation, and I think would have been important to do on principle anyway. One of the other things that this bill does, Madam Speaker, as well as it establishes hybrid offences between the provinces and the federal government, and there is real concern that what this is going to mean is that, you know, we're going to improve federal court wait times at the expense of provincial court wait times. And this is, I mean, this is kind of classic Liberal in a certain way, Madam Speaker. I don't want to be too partisan about it, but I remember the 90s when the federal government decided they were going to balance their budget at all costs. And so they made deep cuts to the health and social transfer. And where did that end up? That ended up on the ledger of provincial governments, who now didn't have the same funding for the health services and other services that they were providing to their population. So those governments went into deficit or had to take other measures, whether it was cuts to services or raising taxes, in order to be able to maintain what had heretofore or theretofore been supported by the federal government. But for as much as the federal books looked better, there was only one taxpayer, and those people paid it at the provincial level instead of paying it at the federal level. So what looked good on the federal government didn't ultimately make a difference to Canadians. They paid for it either through higher taxes at the provincial level or through serious cuts to service. And unfortunately, we had a Conservative government in the 90s, and we paid for that in terms of serious cuts to services. We lost nurses, we lost teachers, and the federal government here sat pretty, pretending as if it wasn't responsible for that. But at the end of the day, their budget cuts did that. And what we're gearing up for here, Madam Speaker, is the potential for something similar, where the federal government will say, oh, look at us, the wait times for federal court are way down, but we have the potential to see those same waits happening at the provincial level, because people who at one time would have faced a charge at the federal level are now instead facing a similar charge at the provincial level. So you haven't got rid of the wait times, you've just shifted the burden from the federal books to the provincial books. And I think for anyone paying close attention, Madam Speaker, they're not fooling anybody. And so I think it's really important that if our job is to make sure that those wait times go down and that justice is served in a timely way, that we do it in a way that actually accomplishes that and doesn't just give the federal government a talking point at the expense of the provinces. I'm out of time, Madam Speaker, but I look forward to questions. Thank you.
Questions and comments? The Honourable Parliamentary Secretary of the Government House Leader. To the Minister of Justice.
Madam Speaker, thank you very much, and I appreciate the comments from the member from Elmwood-Transcona. I do take issue a little bit with his comments with respect to judicial appointments. The track record of this government is that we've appointed 238 new judges. We have appointed, last year, the minister appointed 100 in a single year, the most in 2 decades. That process, because we had to overhaul the Conservatives' old non-merit-based process, took a great amount of time. In overhauling that process, what we've done is taken the stats from 30% women being appointed to 56% women being appointed. We've taken the stats and making a bench that actually reflects the diversity of our country. 20 of the new appointees represent racialized persons, 13 of them represent LGBTQ2 communities, and 3 identify as persons with disabilities, as well as over 8 being Indigenous persons. What I would say to the member is, do you agree that the important goal is ensuring that the bench reflects the community that it serves, and in ensuring that goal, we've taken the absolute appropriate measures to overhauling the process?
I just want to remind the member that he's to address the questions to the chair and not to the individual members. The Honourable Member for Elmwood-Transcona.
Well, thank you very much, Madam Speaker, and thank you to my colleague for the question. I mean, what I would say in response to that, Madam Speaker, is of course we want a bench that's reflective of the Canadian population in general. But the idea that it would take 3 years in order to be able to develop that is something that I don't agree with. So I mean, I don't think it ought to have taken as long as it did for them to appoint the judges that they have. And the other side of that is to look at vacancies, Madam Speaker, because for as much as they want to talk about the number of judges they've appointed, the fact is there's still a great number of vacancies and judges that have to be appointed in order to fill the bench. So if I'm hosting a dinner, for instance, Madam Speaker, and I need 500 plates, and the caterer delivers 150, and I say to him, hey, there's 350 people without a meal here, and he comes back to me and says, well, I'd like to focus on the 150 people that do have a meal. That's all well and good, and I can understand why the caterer might want to do that, but it's not an acceptable answer, Madam Speaker.
Questions and comments? The honourable member for St. Albert Edmonton.
Thank you, Madam Speaker, and I thank the member for Elmwood Transcona for his speech. And I want to ask him a question about hybridization, and he made mention of it in terms of the download that that will have on our overburdened provincial courts, which account for 99.6% of criminal cases in Canada. In addition to that, in terms of the timeline to prosecute cases before a delay is deemed presumptively unreasonable, you're going from 30 months to 18 months, Madam Speaker. So perhaps the honourable member could comment on that. It seems that on top of downloading cases onto provincial courts, it's actually going to increase the risk of having more cases thrown out rather than less.
The honourable member for Elmwood Transcona.
Well, thank you very much, Madam Speaker, and thank you, my colleague, for the question. He'll know I don't have the same legal background as he does, but I think even without a legal background, if you're looking at this bill and these measures, especially from the point of view of whether or not this is ultimately going to reduce delay, what I'm having a hard time understanding is the fact that we're still dealing with the same number of charges. They're just being dealt with in a different place. And so I don't see how that in and of itself contributes to a reduction in delay. He's quite right to point out that the standard for provincial courts is, or the timeline for having things dealt with under the Jordan decision is shorter with the provincial courts than it is in the federal courts. So if the test is whether or not this is actually going to, like, what is it? It doesn't diminish the amount of cases that need to be heard. It doesn't diminish any of the work that goes into the trial. And if it's shortening the timeline on top of that, then the question is, how does this contribute to reducing the delay and ensuring that cases aren't thrown out because they haven't been heard in a reasonable amount of time? And I just don't see how this meets that test.
Resuming debate. Resuming debate. The honourable member for Willowdale.
Thank you, Madam Speaker. It's my honour to address the House today to discuss Bill C-75. Bill C-75, as the members are aware, represents our government's commitment to ensure that the criminal justice system continues to serve Canadian citizens in the most efficient, effective, fair, and accessible manner possible. Through Bill C-75, our government is fulfilling its promise to move forward and modernize the criminal justice system and address court delays. Due to the failures of the previous government, court delays have persisted within the criminal justice system. Court delays are not new problems. However, our government recognizes that we must and can do better. Since 2015, we have heard from countless stakeholders, community members, lawyers, and other individuals regarding the need to reform the criminal justice system. In fact, the Supreme Court's ruling in Jordan and Cody further support this rationale. As such, through collaborative efforts identified by the federal, provincial, and territorial governments, Bill C-75 seeks to remedy these significant gaps and inefficiencies. Among other reforms, Bill C-75 proposes to limit the use of preliminary inquiries for offences carrying maximum penalties. It modernizes bail practices and procedures in order to improve access to justice. It better protects victims of intimate partner violence. It provides judges with greater discretionary tools to manage cases and efficiently bring criminal matters to resolution. And it hybridizes offences that are punishable by a maximum penalty of 10 years or less and increases the maximum penalty for all summary offences to 2 years less a day. Today, I'll be focusing on the hybridization aspect of Bill C-75. Bill C-75 introduces legislation which provides Crown prosecutors the discretion to elect the most efficient mode of prosecution evaluated on a case-by-case basis. This system of reclassification will reduce court time consumed by less serious offences while allowing limited resources to be redirected to more serious offences. Moreover, this legislation will prevent indictable cases from being dismissed or stayed due to the system's inability to try the accused within a reasonable time frame. Bill C-75 amended over 115 offences punishable by either an indictable offence or summary conviction. Since the proposal hybridizes all straight indictable offences punishable by a maximum of 10 years or less, criminal offences relating to terrorism and genocide were subsequently captured, namely causes referring to Section 8302 of the Criminal Code, providing or collecting property for certain activities, Section 8303 of the Criminal Code, providing, making available, etc., property or services for terrorist purposes, Section 8304 of the Criminal Code, using or possessing property for terrorist purposes, Section 8318(1) of the Criminal Code, participating in activity of a terrorist group, Section 83181 of the Criminal Code, leaving Canada to participate in activity of terrorist groups, Section 83221(1) of the Criminal Code, advocating or promoting commission of terrorism offences, and Section 83231, 83232 of the Criminal Code, concealing person who carried out terrorist activity and concealing a person who is likely to carry out terrorist activity. Finally, there is Section 318(1) of the Criminal Code, which relates to advocating genocide. Madam Speaker, Canada is a leader among nations in the fight for universal human rights and the international rule of law. We were one of the first countries to sign the Rome Statute and the first country to ratify our membership within the International Criminal Court. Moreover, on a number of occasions, Canada has publicly denounced the actions of other governments due to their harsh treatment of their citizens and urged their cases to be referred to the International Criminal Court for investigation, such as in the case of Myanmar and Venezuela. Canadians are proud to live in a country that is diverse with a global reputation as a defender of human rights. Given the very few times that genocide and terrorism-related charges have been invoked in Canadian courts, the extremely serious nature of the issues, as well as Canada's moral obligation to continue to serve as international promoters of justice, I'm proud to inform the House that all 8 clauses referred to above relating to genocide and terrorism-related offences were removed from the hybridization list. Specifically, all genocide and terrorism-related offences will continue to remain as straight indictable offences with a maximum penalty of 10 years less a day. In its witness testimony, the Centre for Israel and Jewish Affairs expressed their strong support for such amendments. They stated, quote unquote, terrorism is a heinous and potentially catastrophic phenomenon. Today, terrorist groups around the world, some of which actively seek to inspire recruits in Canada, are often motivated by ideologies infused with anti-Semitism. Far too many Jewish communities around the world, from Argentina to Denmark and from France to Israel, have suffered from deadly terror attacks. Additionally, B'nai B'rith Canada expressed its concerns regarding the hybridization of offences relating to genocide and terrorism, stating that it is inappropriate to allow these offences to be prosecuted in a summary fashion. To be treated with the seriousness which they deserve, they should continue to be prosecutable by way of indictment only. Following the proposed amendments to remove all 8 genocides and terrorism-related clauses from Bill C-75, our government will continue to send a clear, symbolic, and moral message rebuking the offensive crimes mentioned above. However, Madam Speaker, I'd like to strictly emphasize that the reclassification of offences does not affect basic sentencing principles exercised by courts. Depending on the severity of the case, Crown prosecutors will be required to consider a multitude of factors and ultimately decide to prosecute either as an indictable offence or summary conviction. Before I conclude as a member of the Standing Committee on Justice and Human Rights, I'd like to take this opportunity to offer my sincerest thanks to all witnesses for submitting their testimonies and appearing before the committee to present their expert opinions regarding Bill C-75. I can assure everyone that all recommendations and appeals put forward were carefully considered and taken into account. Although there is no simple solution to resolve the issues of court delays, our government is taking action to introduce a cultural shift within the criminal justice system to address its root causes. We are taking important steps forward to act on what we have heard. Moreover, we are taking full advantage of this opportunity to create a criminal justice system that is compassionate and timely, a system that reflects the needs and expectations of all Canadian citizens. Thank you, Mr. Speaker.
Questions and comments. The Honourable Member for Sarnia-Lambton.
Well, thank you, Mr. Speaker, and I'd like to thank the member opposite for his speech. I noted in his speech that he was clear that acts of terrorism and advocating genocide have been taken off the list of offenses that are being reduced to a less than 2-year summary conviction or a fine. My question is this: what made this government think in the first place that acts of terrorism and advocating genocide was a minor enough crime to be on the list in the first place?
The Honourable Member for Willowdale.
Thank you. I'd like to thank the Honourable Member for her question. As she is well aware, there were many consultations that took place when this bill was first being considered. There was considerable outreach to stakeholders, experts, and the like. In addition to that, as she is likely fully aware, there were also consultations that took place between the federal government, the provinces, and the territories. So we thought that was an important step forward. But in addition to that, we thought it was important to hear from various experts and, to the best of our abilities, to incorporate any concerns they would have in the final bill. Thank you.
Questions and comments. The Honourable Member for St. Albert, Edmonton.
Thank you, Mr. Speaker, and I want to thank the member for Willowdale, who I enjoy serving on the Justice Committee with, and he did appear before the Justice Committee to provide evidence about why genocide and terrorism-related offences should not be reclassified, and his testimony was certainly helpful to the committee. But the members spoke of consultations that took place in the lead-up to Bill C-75. The fact is that what the government simply did is took a whole series of offences that were at a 10-year maximum and said we're reclassifying them, including terrorism and genocide, which the member, I think, would agree had no business being reclassified. But the members spoke a few moments ago about the fact that they shouldn't be reclassified because they need to be treated seriously, and prosecuting them by way of summary conviction wouldn't do justice. I was wondering if the honourable member could speak then to why the government doesn't seem to also take seriously offences such as impaired driving causing bodily harm or administering a rape date drug.
The Honourable Member for Willowdale.
Thank you, Mr. Speaker. I'd like to thank the Honourable Member for his question. I have to say it's been a great honour serving with him on the Justice Committee. As he is well aware, we have many opportunities to exchange views. One of the issues that actually did set aside and distinguish these terrorism provisions and the genocide provision is, as he is fully aware, there have been very, very few cases dealing with these provisions. And that obviously was something that was considered by the committee, and ultimately that really weighed on our decision to make sure that these were removed. Thank you.
Questions and comments. The Honourable Member for Whitby. We'll make it a short question, hopefully a short answer.
Thank you, Mr. Speaker. And I wanted to come back to some of the comments that were made earlier when it comes to the seriousness of offenses. When we're talking about kidnapping, for example, a child who leaves a parent's house to go to another versus someone who is luring someone into a car, those are two different offenses, and the seriousness of those two offenses are quite different. Bodily injury causing bodily harm, where arm is broken or someone is placed into a coma, Mr. Speaker, the seriousness of those two offenses are quite different. So I'm wondering if my honourable colleague could emphasize again what the classification, the hybridization classification does, and what it doesn't do. And it doesn't take away the ability for a prosecutor to look at the seriousness of an offence and apply the applicable sentences. I'm wondering if my honourable colleague could reiterate that in the time he has left.
The honourable member for Willowdale in 45 seconds or less, please.
Thank you. Yes, I would like to thank my honourable colleague for making that very significant point. As you know, court delays have been a very significant challenge and problem, and we thought that it was imperative that we take the necessary steps to address this. And the important thing to bear in mind is the system of reclassification will certainly reduce court time consumed by less serious offences, while at the same time allowing us to redirect limited resources to the more serious ones. Thank you, Mr. Speaker.
Resuming debate, reprise de débat, the honourable member for Sarnia-Lambton.
Well, thank you, Mr. Speaker. It's a pleasure to rise in the House and to speak about C-75, which is an act to amend the Criminal Code, the Youth Criminal Justice Act, and other acts, and to make consequential amendments to other acts as well. Now, the first thing I want to say is it's disappointing to see the Liberal government again coming with a 300-page omnibus bill after specifically saying in their campaign promises that they weren't going to do that. But a broken promise a day seems to be the order of this government. That said, let's think about what we're trying to accomplish in our judicial system and then look at how C-75 may or may not fit into that. So I think what we want to do in our criminal justice system is, first of all, define the behavior that's criminal. We want to say which things are not acceptable in Canadian society, and that would be goal number one. Goal number two would be to make sure that appropriate punishments are established to deter people from perpetrating these crimes. So we want to make sure that we have those appropriate punishments defined. We want to make sure that victims' rights are protected, that we're not just focused on the criminal, but we are also focused on making sure that victims' rights are protected. And then we want to make sure that whatever rules we decide, that we actually are enforcing them in a timely way. And so I think that's really what we want to get out of the criminal justice system. If you look at the Conservative record, you would see that everyone in Canada well knows that Conservatives want to be tough on crime, that we want to make sure if people are doing crimes, that we want them to do the time, that we want to make sure that people are not just let off the hook. If we look at the Liberal record on this, it's not quite so clear. In fact, I would argue that the criminals seem to be making out very well under the Liberals. The first thing that has happened under this government is their lack of appointing judges so that cases could actually be tried in a timely way. According to the Jordan Principle, if they're not tried in a timely way within 2 years, those people go free. And so we started to see murderers and rapists having their cases thrown out of court because there were not enough judges being appointed. So clearly, that is a failure of this government because we are in the 4th year of a 4-year mandate, and still there are vacancies, and this is causing cases to continually be thrown out. Now, at some point, the government, if they were responsible, should have taken the look to see perhaps that there were more minor crimes if they thought, for example, that they were going to legalize marijuana. Perhaps any of the charges about possession of marijuana that were in the system should have been punted in order to focus on prosecuting more serious crimes like murder and rape. But that wasn't done. The other thing that we saw with this government was that they are continually trying to soften the penalties for crime. And I know that when C-51 came forward, this was a bill where today in Canadian society, it's a crime to disrupt a religious ceremony or to threaten a religious official, a cleric. And the Liberal government tried to bring Bill C-51 in place to take away those protections for people's worship and the clerics. And there was a huge outcry across Canada. I know in my riding that all the churches wrote letters. There were many petitions that were brought. There was a huge outcry from Canadians. And so the government backed off on that. But now we see that they've brought this back again under C-75 as one of the things that they want to reduce sentences on to a summary conviction, less than 2 years in prison, or a fine, obstructing or violence to or arrest of an officiating clergyman. So it seems a little bit sneaky, if I could say, Mr. Speaker, that the government heard a clear message from Canadians to back off, and then they try to slide it into another bill. That is not a good thing. If we look at some of the other crimes that are in C-75 that are now considered to be minor and going to be subject to a judge's decision on whether or not they get a fine or whether they get a summary conviction up to two years maximum, breaching prison. Really, somebody breaks out of prison and you're going to give them a fine? It shouldn't even be an option. Municipal corruption, another thing on the list. Influencing or negotiating appointments or dealing in offices, obstructing or violence to the clergyman, we talked about that one. Impaired driving offenses causing bodily harm. This is unbelievable that at this particular moment in time, when we talked about how they've just legalized marijuana and every other jurisdiction has seen a tripling of traffic deaths due to impaired drug driving, that they would choose this opportunity to decide that this crime is less serious and people might be able to get off with just a summary conviction or a fine. Abduction of a person under the age of 16 or abduction of a person under the age of 14. Seriously, what is a more serious crime than kidnapping a child? I can't imagine. And to give that person a fine or a summary conviction just seems like there's no moral compass whatsoever. I think polygamy being on the list is another interesting one. We have not had a lot of trouble. Polygamy has always been illegal in Canada. Why are we now saying that we're going to reduce the penalty for polygamy and make it a fine? What about forced marriage? You know, I was at the Foreign Affairs Committee yesterday, and we had testimony from the Congo and Somalia and South Sudan about the dire situations there and 50% of girls being forced into child marriage and what horrendous impact that had on their life. And, the Liberal members of the committee were sitting there thinking, oh, this is a terrible thing. But here in our own country, we've taken forced marriage and we've decided that the penalty is going to be a fine or a less than 2-year summary conviction. It's ridiculous. Also, arson, for a number of reasons, is now on this list and is not considered that serious when, in fact, that drives up the cost of insurance. It takes people's homes. It's obviously a serious crime. And participating in the activities of a criminal organization is now on here as not being that serious. Really, when the government has been standing up day after day talking about trying to eliminate organized crime from Canada, and now if you are part of organized crime, apparently that's not a serious offense. So I think C-75 does not meet what we said we wanted to meet originally in our justice system, right? We wanted to talk about the appropriate punishments that need to be established to deter crime. Well, that's not what's happening here. Now, in addition to all of those things, we see that there are other changes that are recommended in this bill. The repealing of the victim surcharge changes that were brought by the Conservatives. And again, I think it's important that we do protect victims' rights and that there is a fund that will help victims in some way after they've suffered a crime. Removing the power to have a youth tried as an adult. That is a bit concerning to me. There are some very heinous crimes where I think the judges still need to have the ability to do that. And delaying sentencing, consecutive sentencing for human traffickers. You know, that was an important law that was brought into place under the Conservative government. We have a huge issue with human trafficking, and especially from my riding to Toronto, there is a huge ring. And so if someone was caught human trafficking, it wouldn't be just one life that was impacted. There would be hundreds of girls involved. And so the consecutive sentence allowed you to be sentenced for each one of those and not get out of prison for a very long time for what is, in fact, a heinous crime. Now, I do like to always say, what is the good thing? What are the things I like about the bill as well as the things that I don't like? And so I see in here that the only increase in penalties are for repeat offenders on intimate partner violence. And I am glad to see that, because I do think that the government has been totally inadequate in their response to violence against women. As the former chair of the Status of Women Committee, we studied and found that 1 in 3 Canadian women suffer from violent acts in their lifetime. And it's been disappointing to see that this government, while pledging $400 million in the last budget for StatsCan to steal your private information, they gave $20 million a year to address the problem of violence against women. So that's been totally inadequate. At least they've done something in this bill to try to move forward on that. So again, in summary, I would say that this bill has not met the objectives. It has not helped put penalties in place. In fact, I would argue that it has eroded the penalties that they will receive. And I really call on the Justice Minister to do her job and to appoint the justices that are missing, and to put in place punishments that fit the crime. I've brought numerous petitions to the House on Bill C-75 to just eliminate it, because, if we talk about trying to get wait times down, you could get wait times down by not trying any criminals and not putting any of them in prison. That will get your wait times down, but that is not going to achieve what we want in our justice system, which is to define the crimes, to define adequate punishment, and to ensure that those are enforced in a timely way. Thank you, Mr. Speaker.
Excuse me. Questions and comments. Questions et commentaires. The honourable member for Whitby.
Thank you, Mr. Speaker, and I'd like to thank my honourable colleague for her speech. Mr. Speaker, my honourable colleague talked about hybridization, and she named a number of different offences and talked about them being reduced to only a fine or less than 2 years. And Mr. Speaker, I want to sort of clear the record that hybridization does not take away the authority or the ability of the prosecution to look at the seriousness of a crime. She mentioned kidnapping. For example, when a child leaves a parent, if they're in a custody battle, they leave one parent's house, they go to another, that parent calls and says, that the child is missing, that is kidnapping. It is also kidnapping when a child is lured into a van or into a vehicle away and kidnapped for ill intent. Those are 2 kidnapping offenses. One, I would leave it to the lawyers to decide, that is less serious than another. That is what hybridization is doing, is looking at the totality of that crime and deciding and allowing the justice system to decide whether the seriousness of the crime and whether it should be summary or an indictment. So, Mr. Speaker, my question to the honourable colleague is, does she not trust the justice system and the professionals therein to assess the seriousness of a crime and apply the appropriate conviction and therefore keep our communities safe?
Honourable member for Sarnia-Lambton.
Well, thank you, Mr. Speaker, and I'd like to thank the member from Whitby for her question. Do I trust the criminal justice system? Well, we've just seen an example where a convicted child killer was moved to a healing lodge with no fence, and where children were present. And so, no, I don't trust the criminal justice system to make adequate decisions. And I think we've seen where a lot of times criminals are being let out on the weekends on weekend passes and reoffending. So I don't think that the protections that are in place are actually being enforced properly. And I certainly don't want to see them weakened even further. I don't think we want to get into an argument about whether this type of kidnapping of a child is minor compared to that type of kidnapping of a child. I think kidnapping of a child at every level is offensive, and it's a crime. It should be punished to the maximum.
Questions and comments. Questions et commentaires. The honourable member for Kitchener-Conestoga.
Thank you, Mr. Speaker. I want to thank my colleague for her comments today and for her good work on standing up for victims in Canada. On this side of the House, Mr. Speaker, our priority is to stand up for victims. And in my writing, and I'm sure in hers and others here in the chamber, we've all heard from MAD Canada, Mothers Against Drunk Driving. And they have major concerns, Mr. Speaker, about the incidence of drunk driving on our roads and that resulting often in bodily harm, in fact, in death. In fact, Mr. Speaker, within the last few weeks in this House, we've heard of family members who've died as a result of drunk driving. This is something that we need to take seriously. So I'm wondering if my colleague would just comment on the application of the reduction of the penalties for impaired driving causing bodily harm in Bill C-75 and what the negative impact of that could be. And then maybe if she has time, she could comment on whether or not she's hearing the same thing from MAD Canada in her riding, in her district, or from other constituents who've expressed concern about the weakening of this provision. Thank you, Mr. Speaker.
The member for Sarnia-Lambton.
Thank you, Mr. Speaker. I'd like to thank the member from Kitchener-Conestoga for a great question and for the way he always stands up for victims and their rights. And certainly when it comes to impaired driving, whether it's from alcohol impairment or from drug impairment, absolutely Mothers Against Drunk Drivers are outraged, but I think even beyond that, Canadians are outraged. We know that with the legalization of marijuana, that we expect to see a doubling or tripling of traffic deaths due to impaired drug driving. There was just a poll from Ipsos that came out yesterday that talked about how 30 or 40% of Canadians who consume cannabis have admitted that they drive right after that. This is totally unacceptable. The government has abdicated their responsibility in terms of providing sufficient public education to make sure people don't drive while high. And I think reducing the penalty reinforces the message that it's okay because you're just going to get a fine. Thank you, Mr. Speaker.
Reprise du débat, resuming debate, l'honorable député de Dorval.
The honourable member for Dorval-Lachine-LaSalle. Thank you, Mr. Speaker. It is an honour and a pleasure for me to speak today to Bill C-75. There is no doubt that we must modernize our legal system, and to reach this goal, important changes must be made to the Criminal Code, to the Youth Criminal Justice Act, and to other acts. Problems such as long court delays, changes to the administration of justice, changes to the law, as well as the legal case management system are all issues which must be reviewed. However, in my humble advice, the most pressing issue is the way the legal system deals with certain offenders, groups such as Indigenous peoples, minorities, and persons suffering from mental health problems or addicts are disproportionately represented in our legal system, and these people are the most vulnerable in Canada. Despite that fact, when they have to deal with the legal system, they are often not treated fairly. We could almost go so far as to say that the system is hostile towards them, and we cannot have a legal system which applies inconsistently depending on who you are. This is unacceptable, and this situation has been going on for far too long. Bill C-75 will allow us to iron out these inconsistencies in our legal system. Plaintiffs who wait for many years to testify and victims who want to turn the page and go on with their lives have no other choice but to wait because of long court delays. Their need to feel safe, combined with the fact that the legal system exists to maintain the public order, are undermined by these delays. Then there are the cases of accused persons who wait for years to be declared innocent, or persons who have committed odious crimes but who get off anyway because of the inefficiency of the system. Because of the lack of time, I will focus on the issue of bail. This is one of the issues in criminal law which is directly related to the presumption of innocence, and this basic concept is protected under Section 11D of the Canadian Charter of Rights and Freedoms. The Charter guarantees any accused the right to be presumed innocent until he or she is declared guilty by an impartial and independent court. Section 11E of the Charter states that no person shall be deprived of bail without just cause, and Section 7 of the Charter states that each person has the right to life, liberty, and security of the person. These rights cannot be breached under the principles of basic justice. Therefore, any bail provisions must be aligned with the Charter. Each and every one of us must be treated equally in accordance with the Charter of Rights and Freedoms and other laws. Unfortunately, this is not always the case. For example, accused persons who live in isolated areas are disproportionately affected by the existing bail system. Statistically, those who live on reserve are affected by poverty, by high unemployment, and by problems of substance abuse. Therefore, they own very few belongings, if any. We also require bail to be posted by people who must travel from far away towards big cities because the legal system does not service their isolated communities. So how can they possibly post bail? When the burden is so costly, does this not represent a violation of the Charter of Rights? This is why Bill C-75 is so important. It would impose less onerous bail conditions on those who are more vulnerable in our society. It would also help to break the cycle of disproportionate representation of the most vulnerable in our legal system. I would also add that Bill C-75 is extremely important because it also addresses the issue of remote hearings. This bill will see modern technology applied to the best advantage of the legal system. Using video conferences will allow all parties involved in the legal system, including judges, to participate in the process, and this is priceless. Instead of spending a great deal of money to fly in accused from isolated communities, they will be able to testify using the technologies I've just mentioned, and this will be less costly to society and provide better access to the legal system to the accused. Further, the plaintiffs would not have to leave their isolated communities because they will be able to seek justice with the help of these channels. With the discretional authority of the tribunal, which will take into consideration all of the facts unique to each case, these new technological means will make it easier to remotely testify at each step of the legal process, and this will contribute to the good administration of justice, which will make the legal procedures more just and efficient, will respect the rights of the accused and the accused's rights to a fair trial, and to a fulsome defense as guaranteed under Sections 7 and 11D of the Charter. With regard to plea bargains, a lot can go wrong, and it happens often enough that an accused will plead guilty to avoid mounting legal bills. Those who have few financial means often plead guilty, and this is where Bill C-75 brings about changes. Section 270 of this bill underscores an important issue. Indeed, many vulnerable persons, such as teenagers who are not always aware of the ramifications of their acts or decisions, as well as Indigenous peoples and minorities who wish to avoid the stress of living through long delays, are more likely to plead guilty. Apart from Section 60611 of the Criminal Code, the change would require that a judge be satisfied with facts as presented to justify the charges even before a guilty plea is entered.
It is unfortunate that not until recently the matter of intimate partner violence was not given the attention it warranted. The changes to the criminal justice system in this aspect are in keeping with our government's commitment to give more support to those who have faced domestic violence. Statistically, intimate partner violence is the most common form of violence reported to the police. 1 in 2 women faces intimate partner violence. This is a dire statistic. This means that 50% of our female population has been victimized while in an intimate relationship. Those who already are vulnerable, such as the elderly, trans, people with disability, the indigenous population, are very, very facing these things in a difficult way. One time is one time too many when people who are accused of intimate partner violence are given bail and go attack that very same partner. This reason alone demonstrates to all of us the urgency in having intimate partner violence directly addressed during bail hearings. The amendments I have mentioned above are crucial for the protection of those facing such a form of violence. For all these reasons, I support Bill C-75, an act to amend the Criminal Code, Youth Criminal Justice Act, and other acts, and to make some consequential amendments as such. Thank you very much, Mr. Speaker.
Questions et commentaires?
Questions and comments.
Member for Edmonton St. Albert.
Thank you, Mr. Speaker. And the honourable member spoke about the reverse onus for offences related to intimate partner violence. And let me say that I believe that that is a step in the right direction, and we on this side of the House fully support that aspect of Bill C-75. But it seems like for every step forward that this government makes, they take 2 steps backwards. And on the issue of violence against women, I was wondering if the honourable member could speak to the fact that under Bill C-75, offences such as forced marriage or administering a date rape drug are now being reclassified as hybrid offences, in other words, less serious offences. So yes, 1 step forward, but it seems many steps backward when it comes to standing up and defending the rights of women.
The honourable member for Dorval-Lachine-LaSalle.
Thank you, Mr. Speaker, and I thank my honourable colleague for his question and his passion regarding our justice system. It is always with great fascination that I listen to him speak. Regarding intimate partner violence and violence against women, our government has taken a very, very, very strong stance against this. And it's very important that these procedures, when it comes to bail hearings, go through. Our Minister of Justice has listened to during many consultations and has taken part in many consultations with experts. And therefore, she has the tools she needs to push this legislation through, because the problem of intimate partner violence, very unfortunately, has not decreased, and it's very sad to see a woman living in fear of her life every single day. And therefore, these parts of our legislation, our amendments, are going to be very helpful to women in the future.
Questions and comments, the honourable member for Parkdale High Park.
Thank you very much, Mr. Speaker, and I thank my colleague for her important contribution to the debate that is taking place on Bill C-75. She outlined an important component, which is about the access to justice component about this bill. And what this bill also does, I want to invite her to comment on another component of this bill, which is addressing things such as, for her community she represents in Montreal, the community that I represent in Toronto, but that is curing the overrepresentation of certain groups in the justice system. We know that Indigenous Canadians, we know that Black Canadians, we know that other racialized groups are overrepresented in the justice system. This bill will treat differently administration of justice offences. So offences such as breaching a curfew when that curfew doesn't allow someone to get to their place of employment because they have to work at night, for example. I would want to know, could the member please comment on how we're changing the administration of justice offences so that people are no longer criminalized for things such as breaching a bail condition, and how that assists the marginalized communities that exist in Montreal and in other cities around the country?
The honourable member for Dorval-Lachine-LaSalle.
Thank you, Mr. Speaker, and I thank my honourable colleague on his work regarding the justice system. His question is a very important question, because it's true that when it comes to administration of justice charges, it is mostly the vulnerable communities who are, again, disadvantaged, those who are poor, those who are suffering from mental illness, those who are suffering from substance abuse. They go to work and by accident they break their curfew. For example, they're waiting for a bus and the bus doesn't arrive, or the bus is late, or they've missed the bus and there's no other way for them to get home, and so they're stuck outside. They cannot afford to take a taxi. They're barely making ends meet. So this is very punitive on them to have an administration of justice that is going to penalize them for the circumstances of their life, such as being poor or suffering from substance abuse or mental illness. And this is one of the reasons why Bill C-75 is so important in touching our criminal justice system. Thank you.
Resuming debate, the honourable member for Yellowhead.
Sorry, Mr. Speaker. Me and gadgets don't work sometimes. Mr. Speaker, I'm pleased to speak on Bill C-75, an act to amend the Criminal Code, the Youth Criminal Justice Act, and other acts to make consequential amendments to the other acts. This is an omnibus bill. It's over 200 pages, Mr. Speaker. It includes major reforms to our criminal justice system. With a concerning level of rural crime in my riding, the safety of my constituents is a high priority to me, and I believe the safety of Canadians should be the #1 priority of any government. While there are some aspects in this bill that I agree with, it will help to reduce delays in the court system. There are several problems associated with this bill that I have concerns with. First, I want to talk about the bill itself. As I mentioned, this is a 204-page omnibus bill. I want to remind the Liberals that during the last election, they promised they would never table omnibus bills. Yes, but they did. Here it is. But, you know, there was 80 other promises that haven't been started or broken. This is a quote that is still up on the Liberal webpage. I looked it up the other day. They state that omnibus bills, quote, prevent Parliament properly reviewing and debating the government's proposals. We will change the House of Commons standing orders to bring an end to this undemocratic practice. End of quote. That's right on their webpage. Here we are today discussing an omnibus bill. Yet, it's a mixed bag that amends a total of 13 different acts in various ways, Mr. Speaker. This bill needs to be split into more manageable portions so we can properly study it. What's more, the government also threw in 3 bills that have already been tabled, Mr. Speaker. Bill C-28, victim surcharge, Bill C-38, consecutive sentencing for human traffickers, and Bill C-39, repealing unconstitutional provisions. Perhaps this government could manage their legislative agenda a little bit more effectively. They would not need to retable these bills, push through on an omnibus bill, and repeated forced time allocation and limited debates. Mr. Speaker, the Liberals are failing to take criminal justice issues seriously. In March, they tabled this bill the day before a 2-week break period in our sitting schedule. Then they spent a half a year and returned it now when there are only a few weeks left before a 6-week break period. That doesn't give the image that justice is a high priority with the Liberal government. As you may know, Mr. Speaker, the government lack of judicial appointments have resulted in violent criminals walking away without a trial. As of November 2nd, 54 federal judicial vacancies remain. Appointing judges is an effective solution that is much faster than trying to force an omnibus bill through Parliament. And Mr. Speaker, I remember in April the minister talking about 54 more federal judges to go, and here we are, almost the end of the year, and still no action. I also want to talk about what's actually in the bill. Again, there are some parts of the bill that I can support. For example, I agree with efforts to modernize and clarify interim release provisions and provide more onerous interim release requirements for offences involving violence against intimate partners. Modernizing and simplifying interim release provisions is an important step that will assist many rural communities across the country that do not have the resources to navigate lengthy procedures and paperwork. For that reason, I support that, Mr. Speaker. However, I wish the stricter release requirements were not limited to offences involving domestic abuse. With an alarming rate of rural crime in my riding and across Canada, which is often carried out by repeat offenders, I believe we need to make it more difficult for all violent criminals to be released. Otherwise, we have a revolving door where they commit a crime, get arrested, get released, and start all over again. Mr. Speaker, I was at a rural crime seminar in the city of Red Deer last Friday, and a former police officer came forward from Calgary City Police and reported to us on one of the cases that he worked on just recently, where they charged a Alberta offender with 130 offenses ranging from B&E, car thefts, equipment thefts, possession of stolen property. At the last sitting in Alberta, the judge released him. Out the door he went. So where'd he go? He took off to BC. Now we understand that they're looking for him in British Columbia, where they have 100 similar outstanding charges in a very short period of time. This person should not have been released. These criminals prey on farmers and elderly people. They know that RCMP resources are lacking in these areas and take full advantage of this. What this government needs to do is provide our law enforcement agencies with the tools they need to stop revolving door criminals in and out of the courts, and that is happening at a constant time. Mr. Speaker, victims should be a central focus in the Canadian criminal justice system rather than a special treatment for criminals, which is why our party introduced Victims of Bill Rights, while the government, unfortunately the Liberals, don't agree, since Bill C-75 will repeal our changes to the victim surcharge and reduce the overall use and effectiveness of the victim surcharge. I believe in protecting the victims of crime, which is why I introduced my own private member's bill, Bill C-206, that would ensure that criminals who take advantage of vulnerable people, specifically adults who depend on others for their care, are subject to harsher punishments. Mr. Speaker, last month, a gentleman from my riding of Yellowhead was the witness before our Public Safety and National Security Committee. He shared with us firsthand his experience. It was a terrible story. This gentleman, who I consider a friend, is age 83. He heard his truck start up one day when he was having lunch with his wife. He walked outside to see his truck driving out of his yard. He lives about 70 kilometers from the town of Edson, where the local police office is. He picked up his phone and was about to call when his vehicle returned to his yard. Two youths, one age 18 and one age 17, came out, knocked him to the ground, repeatedly kicked him in the face, in the chest, in the ribs. Remember now, he's 83, Mr. Speaker, and then attempted to slash his throat, then drove off again. They're still dealing with this in the courts. That's been a year, Mr. Speaker. This gentleman has had to attend court 10 times so far, and the matter is still not over. On our side of the House, we will always work to strengthen the Criminal Code of Canada and make it harder for criminals to, Mr. Speaker, I'm concerned that portions of Bill C-75 will weaken our justice system. Through the bill, the Liberals are reducing penalties for the following crimes: participating in criminal organizations, various acts of corruption, prison breach, impaired driving, abduction, human trafficking, forced marriage, and arson, just for a few of many in that bill. Participation in terrorist activities and advocating genocide were deleted from this list only because of our government, the Conservative opposition. We made amendments which was accepted by the committee. Mr. Speaker, that is just a few examples of more than hundreds of serious crimes that could be prosecuted by summary conviction and result in lighter sentencing or even fines. This government is failing to take criminal justice issues seriously. It's reducing penalties for serious crimes sends the wrong message to victims, law-abiding Canadians, and to criminals. I'm also concerned about the wording used in the section that increases maximum sentences for repeat offences involving intimate partner violence. I support increasing these sentences. However, I do not support replacing the language of spouse with intimate partner. I believe both should be in there, Mr. Speaker. 1 minute. Thank you, Mr. Speaker. I understand that not all domestic abuse is within a spousal relationship, so there is a need to have intimate partner included. However, it should not replace spouse. Rather, both terms should be introduced. Another problem I have with Bill C-75 is the reversal of protection for religious officials, Mr. Speaker. When Bill C-51 was referred to in the Standing Committee on Justice and Human Rights in January, there were two amendments from my Conservative colleagues. The first amendment kept Section 176 of the Criminal Code of Canada, while the second amendment modernized the language of this section of the code. The Liberals agreed to that, and that was good, but they need to listen more. You can imagine my disappointment when I read in Bill C-75 that Section 176 of the Criminal Code is once again under attack. Assault on officials during a religious service is a very serious and should remain an indictable offense, Mr. Speaker. Thank you for the opportunity to present my views.
Questions and comments? The honourable member for Parkdale Hyde Park.
So I thank the member from Yellowhead for his contribution to today's debate about Bill C-75. I offer two comments and one brief question. The first comment is that the term intimate partner is used in this legislation for a deliberate reason. It is a more expansive term than just simply the term spouse. Violence occurs, as we've heard in today's debate, for half of all of the women in this country, and that violence is perpetrated in couples that are married, but also in couples that are unmarried or indeed just dating. The second point is that there was an actual factual error that was mentioned in the comments by the member opposite when he indicated that a reduction in penalties has been provided for a list of offences, and he listed them. Hybridization does not ipso facto reduce a penalty. Hybridization allows a crowd to proceed by way of summary conviction or by way of an indictable proceeding. It is not a predetermination of the sentence. What I would ask the member opposite, the member from Yellowhead, is that he is convinced about the need to ensure that there need to be tougher penalties for people who are convicted of crimes. On this side of the House, we agree. That is why we're taking the summary conviction limit from 6 months, traditionally, to 2 years less a day. I would invite his comment on that provision and whether he approves of that change, increasing the penalty for summary conviction offences to 2 years less a day.
The honourable member for Yellowhead.
I'd like to thank the honourable member, Mr. Speaker, for that question. And yes, increasing that penalty is definitely one of the ways to go. But we must also ensure that if we are changing the legislation, is that our prosecutors and our court systems abide by the new regulations and follow through with that. It's no use changing these regulations if the courts will not follow them, the prosecutors will not follow them. It'll again be on the revolving door system, just as it is today. Won't change the matter much.
Questions and comments? Questions et commentaires. The honourable member for St. Albert, Edmonton.
Thank you, Mr. Speaker, and I want to thank the honourable member for Yellowhead, who has a great deal of knowledge about Canada's justice system, having spent a few decades as an RCMP officer. I'm glad the member brought up the victim surcharge, which is an important source of funding to support victims of crime. We on this side of the House at the Justice Committee brought forward an amendment to increase the victim surcharge by $25. It seems like a very modest amount that could go a long way to supporting victims. Yet, shockingly, Liberals over there shot it down. Would the honourable member agree that our amendment was quite reasonable and that the failure of government to support our amendment is just another example of the government putting victims last?
The honourable member for Yellowhead.
I'd like to thank the honourable member for that question, and you know, it's very appropriate. Yes, surcharges should be raised. We had a witness appear from Saskatchewan 2 weeks ago at the Justice Committee, a farmer, and he says, you know what, I really don't care if that guy goes to jail for 2 months or 6 months, but when he steals my combine and causes $100,000 damage to my combine, just driving it around the field, running it through the ditches, I should be able to sue that person, or the court should be able to place a penalty on that criminal to repay that thing. And if it takes him for the rest of his life to pay back that $100,000 damage to my combine, that would be justice. The victims in Canada are the ones that are suffering. The criminals are not suffering. We must make the criminals responsible for their actions, and that is one way we could do it. Thank you, Mr. Speaker.
Questions and comments? Questions et commentaires. The Honourable Parliamentary Secretary to the Government House Leader. A very brief question, and hopefully we'll have a very brief answer.
Very brief, Mr. Speaker, would be recognizing that The federal minister has actually worked diligently over the last couple of years, 2-3 years, with provincial counterparts, territorial counterparts, Indigenous people, and many other stakeholders, and was gone through the committee, and it is overwhelmingly perceived as good, solid legislation, something that is long overdue. And I'm wondering if my friend from across the way would, at the very least, recognize that many of the changes that are incorporated within this legislation is, in fact, something that should be put into place as soon as possible, because we have so much at stake here.
The honourable member for Yellowhead in 30 seconds or less, please.
Well, as I stated earlier, Mr. Speaker, I mean, this thing was originally brought to us early in the year. It was brought to us a day before we were going on a 2-day break. There was 3 sections that I mentioned, I think 38 and 39, that were previous bills that they've thrown into this one. Why weren't they done with? Why weren't they dealt with? If it's so important that they get done, why did they wait so long to do it?
Reprise du débat, resuming debate. The honourable member for Surrey Centre.
Thank you, Mr. Speaker. I'm pleased to participate in the third reading debate of Bill C-75, an act to amend the Criminal Code, the Youth Criminal Justice Act, and other acts, and to make consequential amendments to other acts. I intend to focus my remarks on sentencing-related issues. At the outset, I think it's important to address the continuing criticism from the opposition that hybridizing all straight indictable offences punishable by a maximum penalty of 10 years imprisonment or less to allow the Crown to proceed by summary conviction in appropriate cases minimizes the seriousness of these offences. These concerns reflect a lack of trust to the judiciary and Crown prosecutors who already make these decisions every day. They also represent a profound misunderstanding of what Bill C-75 aims to achieve by reclassifying certain offences. The proposal to hybridize offences is procedural in nature and is intended to allow the prosecution by summary conviction of conduct that currently does not result in a sentence of more than 2 years. For instance, it's a mischaracterization of the reclassification amendments to assert that by hybridization, Section 467.11 of the Criminal Code, i.e. participation in activities of a criminal organization, Bill C-75 is sending a message not to take organized crime offenses seriously. The proposed amendment simply recognizes that this offense can, by virtue of the range of conduct captured, include circumstances where an appropriate sentence falls within the summary conviction range. Proceeding summarily in these circumstances allows for more expeditious proceedings without either undermining public safety or impacting sentence ranges for this offense. In fact, in 2011-2012, there were 49 guilty verdicts entered pursuant to Section 467.11 of the Criminal Code. Of these 49 cases, only 34 were given a custodial sentence. Of those ones, only 1 received 1 month or less, 6 received 1 and 3 months, between 1 and 3 months, 10 received between 3 and 6 months, 9 received from 6 to 12 months, 4 received from 12 to 24 months, and the 4 remaining received a custodial sentence of 24 months or more. Mr. Speaker, at the time these sentences were imposed, Section 467.11 of the Criminal Code was a straight indictable offense, and yet the overwhelming majority of sentences imposed were in the summary conviction range, including 15 non-custodial sentences. It is clear that keeping Section 467 of the Criminal Code as a straight indictable offense will not in any way prevent the Crown, in appropriate cases, from seeking non-custodial sentence or a sentence of imprisonment that is in the summary conviction range. Let me be clear, there's absolutely nothing in Bill C-75 that suggests to prosecutors and courts that hybridizing offenses should result in seeking or awarding lower sentences than what is currently sought or awarded under the law. Prosecutors will continue, as they already do, to assess the facts of each case and the circumstances relating to the offender and previously decided cases, in order to determine which type of sentence they should seek. Sentencing judges will continue to impose sentences that are proportionate to the severity of the crime and the degree of responsibility of the offender, as mandated by the fundamental principle of sentencing in Section 718 of the Criminal Code. Mr. Speaker, the misapprehensions about the proposed reclassification amendments also unnecessarily detract from other notable reforms. For example, the bill proposes to toughen criminal laws in the context of intimate partner violence, IPV, thereby increasing public safety and enhancing victim safety. Bill C-75 includes a proposal to impose a reverse onus at bail for an accused charged with an intimate violence offense if the accused has a prior conviction for violence against an intimate partner, regardless of whether it's the same partner, a former partner, or a dating partner. In this context, to enhance the safety of victims of this type of violence, the accused, not the prosecutor, would have to justify their release to the court and the public. What this means is that the presumption that the accused should be released pending trial no longer applies. This proposal is targeted and reflects what we know about the heightened risk of safety that victims of intimate partner violence face. Victims of the intimate partner violence tend to experience multiple victimizations before reporting it to the authorities or police. Based on StatsCan data from 2014, 17% of victims of spousal violence indicated that they had been abused by their current or former partner on more than 10 occasions. I understand that one of the criticisms raised at committee was that reverse onus could be problematic in jurisdictions where dual charging occurs, a practice whereby both partners are criminally charged, sometimes because self-defense on the part of the victim is confused with assault. I also understand that it is often not the law that this is the problem in the context, but how it is applied. Dual charging is an operational issue that provinces and territories have been addressing through the development and implementation of training and policies. For example, in March 2016, the Canadian Association of Chiefs of Police released a national framework for collaborative police action on intimate partner violence, which addresses dual charging and provides guidance for cases where charges against a victim are being contemplated. Knowing that research shows that victims are at an increased risk of violence in the aftermath of reporting to police, especially in cases where there is an ongoing history of violence in the relationship, I am confident that the reverse onus proposed here is carefully tailored to address the concerns raised. Bill C-75 will also require courts to consider whether an accused is charged with an IPV offense prior to making a decision to release or detain the accused during a bail hearing. In addition, Bill C-75 would clarify that strangulation, choking, and suffocation are elevated forms of assault and also define intimate partner for all criminal code purposes, clarifying that it includes a current or former spouse, a common law partner, as well as dating partners. Moreover, Bill C-75 proposes a sentencing amendment to clarify that the current sentencing provisions, which treat abuse against a spouse or common law partner as an aggravating factor, apply to both current and former spouses, common law partners, and dating partners. What's more, Bill C-75 would also allow prosecutors the possibility of seeking a higher sentence penalty, max penalty, in cases involving a repeat intimate partner violence offender. I think we can all agree that allowing for the imposition of the higher than applicable maximum penalty in cases of repeat intimate partner violence offenders is a concrete example of Parliament sending a clear message to prosecutors and the courts that repeat intimate partner violence offenders should receive strong denunciatory sentences. In these cases, where the Crown serves notice under Section 727 of the Criminal Code that a higher maximum penalty is sought, a sentencing court would be given additional discretion to impose a sentence that exceeds the otherwise applicable maximum penalty. This will better reflect the severity of the conduct in question and assist courts in imposing sentences that better protect victims. I urge all members to support this very comprehensive legislation, which will reduce delays and make the criminal justice system more efficient and effective on the basis of evidence and not ideology. Thank you.
Questions and comments? Questions et commentaires. The honourable member for St. Albert, Edmonton.
Thank you, Mr. Speaker. And to the member for Surrey Centre, he made reference to the fact that there are certain offences where, in his words, it's appropriate to give the Crown discretion to prosecute the offence by way of summary conviction. Of course, there are many offences in the criminal code that are hybrid offences that are left to prosecutors to make that decision. He noted that in that regard, there are certain offences where the range of conduct of the individual might justify, in fact, a summary conviction prosecution and the imposition of a non-custodial sentence. This bill hybridizes the very serious indictable offense of administering a date rape drug. We're talking about people who administer a drug to rape an individual, a female. And I was wondering if the member could explain in what circumstances he sees there being a range of conduct that would justify the imposition of a non-custodial sentence in that case.
The honourable member for Surrey Centre.
Well, the data is evident, and it's clear that 92% of indictable offences under this new legislation, or even under the previous act, given sentences under the 2-year in the summary conviction range. So these would be the appropriate sentences that the Crown and the judge found in that time. So it clearly shows that even where the offence was considered indictable, the sentencings were in the summary conviction range in the past. And this is where we actually trust our prosecutors and we trust our judiciary to make the sentencing, to make the appropriate choice in which offence and which methodology they wish to charge. And if they feel they can take it into a summary conviction and the offence is not as severe or the range they expect, they can expedite that conviction as opposed to taking it into an indictable trial. Thank you.
Questions and comments? Questions et commentaires. L'honorable député.
The honourable member for Rosemont, La Petite Patrie. Yes, thank you, Mr. Speaker. Thank my colleague for his speech. But a number of people have doubts about this bill's ability to meet its objective of clearing up the justice system and having more appropriate timelines. For example, Michael Spratt, the former director of the Criminal Lawyers Association, said in committee that the proposed reforms will probably lead to more delays, racial inequality, and unfair trials. So, if his government is proposing measures that don't even impress the people who know how this works, and if his government isn't appointing more judges and filling vacant seats, then how can they reach the desired objectives?
Honourable member for Surrey Centre.
Thank you to my colleague for the concern and the question. I think that's an assumption or a statement by one stakeholder or one witness. I think there's been more appointments to federal appointments to judicial vacancies than there have been in the past, and those vacancies were left by a Conservative government under Harper who really stalled and delayed this judicial process, which we have been victims to, and the Minister of Justice has been actively and profoundly and in a very diverse manner been fulfilling those vacancies, and I'm very proud in British Columbia we've had numerous vacancies filled, and I trust that those delays will not be there in the future going forward, and I think this bill will actually make the judicial system much more efficient, contrary to the concerns of my colleague.
Questions and comments? Questions et commentaires. The honourable member for Whitby, 30 seconds or less, and I'll hope for the same amount of time for an answer. Thank you.
Thank you very much, Mr. Speaker. My honourable colleague very eloquently talked about the 92% of cases which, within the current circumstance, fall outside of indictable offences. And he also, in his response to the last question, talked about the number of appointments that our Minister of Justice has made, over 230 so far. Last year, the most that has ever been appointed. Those two combinations create efficiency within our system, allow the system to move faster. I'm wondering if my honourable colleague doesn't agree that the appointments to date, as well as this particular piece of legislation, increases the efficiency of our justice system and allows for more cases to be going through our justice system in a quicker manner.
Honourable member for Surrey Centre in 30 seconds or less, please.
I want to thank the member, and I think absolutely the 230 appointments have been probably some of the most progressive appointments that this Parliament or this House has seen in decades. More women have been appointed than ever before. More diverse members of the bench have been appointed than before. I think now claimants are people that go before the judges will see more of themselves when they appear before the judiciary as opposed to those days of the past. So I'm very confident that the new judicial appointments, the record number of judicial appointments, will be a robust system that will reduce the delays in our judicial system and bring our criminal justice system to a more efficient manner. Thank you.
Resuming debate, reprise du débat, the honourable member for Saanich Gulf Islands.
Merci, Monsieur le Président.
Thank you, Mr. Speaker. I'm honored to speak today on the report stage of Bill C-75, an act to amend the Criminal Code, the Youth Criminal Justice Act, and other acts, and to make consequential amendments to other acts. It's an omnibus bill that deals with criminal issues in Canada. Now, first off, I think that everyone who deals with these important justice issues in our society can be optimistic about what the Justice Minister said, because it's clear that we need reform. But unfortunately, the hopes of many lawyers and organizations calling for real reform have been disappointed.
Appointment. The longer we work with Bill C-75, the more the disappointment deepens. Michael Spratt's been quoted in this debate before, the former chair of the Canadian Criminal Lawyers Association. But as he put it, quote, "It all sounded so good, but it has all gone so wrong." Well, I did attempt to make improvements to the legislation. Members of this place will know that while my status as leader of the Green Party of Canada does not allow me to sit on any committees, through the work of the PMO, first under former Prime Minister Harper and now under our current Prime Minister, I have some might think of it as an opportunity. I have to say, Mr. Speaker, it's an enormous burden. It increases my workload and is rather unfair, because if it wasn't for what the committees had done, I could have been presenting substantive amendments here at report stage. That is my right as a Member of Parliament and not one of the three big parties. But that right, and I have very few rights as a Member of Parliament with one seat for the Green Party, but one of those rights was to be able to make substantive amendments at report stage. And my rights have been subsumed into what, as I said, was done first by the Conservative government, now by the Liberals, to say that I have an opportunity to present amendments at not at report stage. I have an opportunity to present amendments in clause by clause in committee. Although I'm not a member of the committee, don't have a right to vote, but get a chance to speak to my amendments. Well, it was under that committee motion that I was able to present 46 amendments and participated vigorously in clause by clause of Bill C-75. And I have to say it was a very discouraging process, as very few amendments from opposition parties were accepted. Most of my amendments went directly to testimony from many witnesses who wanted to see the bill improved. And I'm disappointed that none of my 46 amendments made it through. I should say that some of the worst parts of Bill C-75 were changed on the basis of government-proposed amendments. One of the ones that had worried me a great deal was the idea that evidence in a criminal trial from the police could come in the form of a written statement without proffering the police officer in question for cross-examination. That was amended so that they cannot use what they call routine police evidence without having someone put forward to be cross-examined. There was also the repeal of the Vagrancy Act and repeal of the law about keeping a common body house. But many other sections of this bill cry out for further amendment. So at this point, I want to highlight those sections that really need to be amended and hope that when the bill leaves this place, as it inevitably will, we're at report stage, third reading will come in short order, we're already under time allocation, that when this bill gets to the Senate, that at the other place will pass amendments that are needed. Because it's quite clear that this bill in some key areas does the opposite of what the government has promised, particularly in relation to disadvantaged people, particularly in relation to the status of Indigenous peoples within our prisons, particularly in relation to access to justice and fairness, which has actually been worsened in this bill. It's not something I expected to be standing up and saying at report stage, but there it is. It's massively disappointing, and I do hope that the Senate will improve it. Now, one of the things that was done, and I'm not sure if it was the best solution, but it was clearly a response to the Stanley case, where of course, it was a massive sense of a miscarriage of justice. But the courts, after that, when you have a jury, you're supposed to have a jury of your peers. And if you're an Indigenous youth and your jury is entirely Caucasian, it's not exactly a jury of your peers. One of the reasons that this happens was the use of peremptory challenges. So I do appreciate the effort in Bill C-75 to eliminate peremptory challenges. But I do want to go over the ways, Mr. Speaker, in which this bill actually takes us backwards. The effort here, of course, as many other members have pointed out, honourable members have pointed out, this bill is a direct response to the Jordan decision of the Supreme Court of Canada in 2016, in which the delays could be so profound that the case could not proceed. So it was very clear that the new trial timelines for provincial courts of 18 months and of 30 months for Superior Court, I think all Canadians feel the same sense of concern. No one wants someone to be freed who, at this point, of course, still has the presumption of innocence because they haven't gone through their court case. But if the evidence was good enough and the prosecutors brought that person forward, the idea that they're just let out of jail because the trial times and the processing of that person took too long, that offends our sense of justice. I think it offends all of our sense of justice. So the Government of Canada, the Parliament of Canada, was given a very quick, I would have to say, jab towards justice by the Supreme Court of Canada. But have we gotten it right? Now, in the effort of speeding up trials, I'll mention one thing first, which is the issue of eliminating preliminary inquiries. There was a great deal of evidence before our committee that we didn't have, and the Government of Canada did not have, and Justice Department did not happen to have good data to tell us that preliminary inquiries were a source of great delay. In fact, and I just want to quote from one of the legal experts who did testify before the committee, Mr. Trudel, who is the current chair of the Canadian Council of Criminal Defense Lawyers. And he described preliminary inquiries like this, quote, "They're like x-rays before an operation." Well, that is a very useful thing to have, and they don't happen all the time. But when you remove them without good evidence as to why you're removing them, you could, in fact, end up having innocent people convicted. And in fact, Bill Trudel, who I just quoted from the Canadian Council of Criminal Defense Lawyers, has said that as difficult as it is for him to say it, he thinks more innocent people will be convicted because we've taken out preliminary inquiries without quite having the evidence that that was a good thing to do to speed up trials. We also have the problem that having changed the range of sentencing, we've heard a lot from my friends in the Conservative caucus about the question of hybridization, but the effect of C-75 is also to increase the sentencing for a summary conviction from 6 months to 2 years. They've also added in C-75 provisions that I don't think were thoroughly thought through about the use of agents. Now, to give a better sense of agents, and this goes to the question of access to justice. Suppose you're not quite poor enough to get a legal aid lawyer, but you're trying to navigate the legal system and you can't afford a lawyer. And in many of those cases, for a very long time, criminal defendants have had the benefit, particularly if they're low income, they've had the benefit of law school clinics young lawyers in training, student lawyers working as a clinic to provide legal services to people charged with lesser offenses. Now, if we don't amend this, now of course it's too late to amend, here we are at report stage, we needed to amend this. I hope the other place will amend this to ensure access to legal aid clinics out of law schools in order to be able to get help to marginalized groups navigating the legal system. This, I think, is an unintended consequence. I'm certain that people in the Department of Justice didn't ponder this and say, oh, one of our problems is too many poor people are getting help from law students. That wasn't a problem that wanted solving. That was a very good and ongoing process, which has been, I think, recklessly compromised in this bill. And I have to hope that when it gets to the other place, we can fix this and make sure that by the definition of agents, we exclude law students and law schools running clinics. There are other aspects of this bill where we just failed altogether to deal with the issue of the disproportionate number of Indigenous people behind bars. We've taken into some aspects of taking things into account, but one of my amendments that I really regret wasn't accepted was we have no definition of vulnerable populations. And a lot of the evidence that came before the Justice Committee suggested we needed such a definition. I tried one, it failed. Maybe the other place can try again. I know my time is up, Mr. Speaker. I hope that Bill C-75 will see more improvements in the other place before it becomes law. Thank you.
Questions and comments? Questions et commentaires. The honourable member for Parkdale High Park.
Thank you, and I thank the member for Saanich Gulf Islands for contribution to today's debate and for all of the debates in this chamber, and for her contributions at the committee deliberations. A couple of comments and then a question, Mr. Speaker. The member commented on the lack of amendments that were accepted. Almost 50 amendments were accepted at the committee stage, including several from members of Her Majesty's official opposition. With respect to paralegals and agents, there was a significant amendment that was made to the criminal code at the committee stage that addresses the very problem that was outlined by the member opposite in respect of ensuring that law societies and provincial regulatory bodies would indeed be able to empower agents to continue to appear on summary conviction offences, even ones that carry a penalty of up to 2 years. The important point about peremptories, I think, needs to be re-emphasized is that peremptory challenges were advocated, a change to peremptories was advocated for by Jonathan Rudin, a distinguished member of the bar who deals with Aboriginal clients and Indigenous clients, who said this indeed will make a substantial impact on ensuring that you don't have homogenous juries dealing with racialized accused. But what I would ask the member opposite, and my question is this, is that for her comment on, with respect to the changes to administration of justice offences, what we've sought to do is ensure that Indigenous accused and other overrepresented communities are not overly penalized and recriminalized for simply violating something like breaching a curfew or breaching bail. That is being taken out of the criminal procedure, put into the administrative procedure. Is that a step in the right direction from the member's perspective?
The honourable member for Saanich Gulf Islands.
Thank you, Mr. Speaker. And to my honourable colleague, first briefly on the other point, I do recognize the amendment, but it kicks it to the provinces to act, and the question is, will they act to deal with the question of making sure law students can participate in the hearings? The bail issues and not recriminalizing people for things over which they really don't have control goes directly back to the Supreme Court of Canada decision in R versus Morales. I think we've done a partial job in C-75. I think we could have done more. As you'll as my honourable colleague will remember, a number of my amendments went to that question of making sure that we really thought through the levels of conditions of addictions or poverty that would make it virtually impossible to meet certain bail provisions. I think we could have done more, but I agree there are steps in the right direction in C-75 to respond to R versus Morales.
Questions and comments? The honourable member for Sarnia-Lambton.
Thank you, Mr. Speaker, and I'd like to thank the member for Saanich Gulf Islands for her speech and for her very hard work. She's on her own coming to all these different committees with all these different bills that come before, and she does do a thorough job of bringing amendments. I'm specifically interested to understand in all of the amendments that she brought, which are the ones that she considers to be the most important that should be included when it goes to the other place.
The honourable member for Saanich Gulf Islands.
I'm so grateful to my friend for Sarnia-Lambton for those generous comments. I think I'll go back to the amendment about defining a vulnerable population. I think that would be very helpful. And I think there are a series of amendments, and not to quote them all, but the ones that leave a lot of discretion to police officers to decide which track a potential accused is going to go to. The question of whether or not our police officers who are wonderful professionals, but do they have the training to assess the socioeconomic conditions, issues of trauma? I think it's putting too much on police. That there should have been a provision to ensure that that was left to prosecutors, the justice system, with the advice of people in what we might think of as the caring fields.
Questions and comments? The honourable member for St. Albert, Edmonton. Very briefly, please.
Mr. Speaker, and I thank the member for Saanich Gulf Islands for her contribution to Bill C-75, and she did make reference to the limitation of preliminary inquiries only to those cases where the maximum sentence is life behind bars. Now, she's quite right that the evidence before the committee overwhelmingly was that it will not reduce delay, that in fact it might increase delay because preliminary inquiries help weed out cases, particularly weak cases. But in addition to that, I was wondering if you could speak to this life criteria. It seems to be quite arbitrary because there are certain offenses where the maximum sentence may be life and others where it's not, but in terms of the sentencing guidelines or the case law, one would expect a similar sentence to be imposed, but yet in one case a preliminary inquiry would be available, in the other case it wouldn't. It seems not to make a lot of sense.
The honourable member for Saanich Gulf Islands in 30 seconds or less.
Well, I appreciate my friend from St. Albert, Edmonton, bringing us back to the question of preliminary inquiries. There is that question around whether that is a proper sentencing threshold, but it allows me to raise another point about how the bill discriminates against marginalized people. Someone who's got a lot of money, to put it in brief, without a preliminary inquiry, can hire a private detective and try to figure out what were the facts that they would have been able to discern had there been a preliminary inquiry. They can go out and get a private detective and find out a lot about the other facts of the case. But someone without income who's not going to be able to hire a private detective will have unequal access to justice as a result of eliminating the preliminary inquiry when they're not sentenced to an offence that has a sentence up to life.
Resuming debate, reprise du débat. The honourable member for Edmonton West.
Thank you, Mr. Speaker. I rise on C-75, which is officially called an act to amend the Criminal Code, the Youth Criminal Justice Act, and other acts, and to make consequential amendments to other acts. So once again, we have before us another omnibus bill. Now, just 2 weeks ago, I spoke on the Budget Implementation Act Part 2, which was an omnibus bill as well, which of course follow up to the BIA 1, which is also an omnibus bill. Now, those bills had sections inside of sections making legislative changes. Now, of course, the Liberals, when they were in opposition, railed against omnibus bills, so much so they actually put it into their campaign pledge. If you go to liberal.ca, it's actually still there, and this is what it says about omnibus bills. Now, it starts, of course, with attacking Stephen Harper, and what Liberal talking point would be complete without blaming Prime Minister Harper. Now, what it says is, Stephen Harper has used omnibus bills to prevent properly reviewing and debating proposals. We will bring an end to this democratic practice. Now, when you say that, of course, put your hand over your heart. And yet, here we have, despite their pledge, another omnibus bill. Now, maybe that pledge meant they'll prevent others from bringing in omnibus bills, but not the Liberals. Now, if you go to the famous Liberal mandate tracker, what does it say on this promise? Well, it says under the unfair and open government part, it says we will end the use of omnibus bills. Now, funny enough, we have an omnibus bill here, the Budget Implementation Act Part 2, Part 1, omnibus bills. Despite that, under the Liberal mandate tracker and the use of omnibus bills, it says completed, fully met. Now, of course, this is the same mandate tracker that is judging balancing the budget by 2019-2020. It says underway with challenges. The government has stated, their own finance department said, we won't see it balanced at 2045, but somehow 2019 promise, 2045, it's underway with challenges. It makes me think if the Liberal was ahead of the Titanic, after hitting the iceberg and it was going down, the cutter line reaches out to the captain and says, how are you making out on your trip? Well, we're underway with challenges. Now on to C-75. Now I agree with a few items on this omnibus bill. Mind you, with over 300 pages of changes, one has to be able to find a few good things. Now C-75 will repeal unconstitutional provisions in the criminal code. Fair and good. It increases the maximum prison term for repeat offenses involving intimate partner violence. And it will provide that abuse from a partner is an aggregating factor in sentencing. We agree with that, fully support it. And it will provide more onerous interim release provisions. Again, we can get behind that. Now, it makes some efforts to reduce delays in the judicial system by restricting the availability of a preliminary hearing, increased use of technology to facilitate remote attendance, and to provide for judicial referral hearings to deal with administration of justice, offenses involving failure to comply with the release conditions or failure to appear. Now, that being said, I have many grave concerns with this bill, mostly around how it waters down penalties for crime. Now, the Liberals are claiming they want to push through C-75, use time allocation, to speed up the court process, and also because of the Jordan ruling. Now, the big problem is the Liberals are unable to get their act together and appoint judges. It's one thing to make small steps in this way, but until they get their act together and appoint the judges, we are going to continue with justice delays and people released under the Jordan ruling. Now, there's been hundreds of cases have been tossed due to delays because this government has been unable to do their job and appoint judges. There's about 2,000 more applications before the courts to dismiss cases because of delays. Now, we had a gang hitman in Alberta, in Calgary, been accused of 3 murders, suspected by the Calgary police of committing 20 murders. That's correct, 20 murders. His trial for the 3 murders he was charged with was released because of delays, because we don't have enough judges. We had a man accused of murder and charged in Edmonton, released because of delays, because this government cannot get its act together and appoint judges. We had a killer in Quebec, released because of delays. And possibly the worst, there was a gentleman, actually I shouldn't even call him a gentleman, a monster in Nova Scotia, took a baseball bat and broke the ankles and broke the shins of his baby. And this man was released because this government is too incompetent to do their job and appoint justices. This is an issue that they have to get hold of, and they're failing Canadians. Now, I'm actually pleased that the Liberals did listen to the Conservatives and other opposition members in committee and backed away from lighter sentences for some crimes, such as terrorism-related offenses and advocating genocide. And it makes you wonder, why does it take us in committee to force the government to back away from lightening the sentence for advocating genocide? Just 2 weeks ago in the House, we heard the Prime Minister, we heard the opposition leader, we heard the leader of the NDP, the leader of the Green Party and other parties stand up and make wonderful speeches and apologizing for the disgrace that was turning away, or not accepting the St. Louis, the genocide that happened. The same week, we had a concurrence report about the genocide against the City women that, to the credit of my colleague from Calgary Nose Hill, dragged the government kicking and screaming into the light of it, recognizing this was genocide. Despite everything ISIS was doing, slaughtering these people, the government stood up and said, member after member stood up and said, well, you know, the UN hasn't decided it's a genocide. You know, we can't call it a genocide. So at least the government has recognized this, and it's not watering down the sentences for advocating genocide. But I have to ask, why does it take the opposition to demand the government make this change? Now, as I mentioned, I have serious concerns about the watering down of serious crimes in this bill, reducing many serious crimes to lighter sentences, sometimes just a monetary fine. I want to go through a few of them. Prison breach, municipal corruption, influencing municipal official. Now, I do recall a couple ex-Liberal cabinet ministers who went on to pursue careers in municipal politics were charged with fraud. Maybe they're just doing a favor to their compatriots. Influencing or negotiating appointments or dealing in offices. Well, actually, we've got the Minister of Intergovernmental Affairs who's being looked at for the clam scam. Perhaps they're trying to do him a favor. Obstructing or violence to or arrest of officiating clergymen. This one is especially egregious. Liberals tried to suspend this under Section 176. There were special protections for clergymen performing ceremonies, whether it's church ceremonies, funerals, religious ceremonies. Liberals tried to take that protection away. Opposition fought back. They promised they would not do that, and yet here in this bill, they're reducing that crime. Think about it. This is just, again, 2 weeks ago after we heard about massive anti-Semitism, issues that caused the genocide of the Jewish people. This is 2 years after the massacre at the mosque in Quebec, just a month after the Talmud Torah, the Jewish school, in my writing, was defaced with swastikas. And here we have the government saying, it's okay, we don't need special protection for religious figures and clergymen. Other crimes are watering down, keeping a common body house. Now, that may be great for parliamentarians, but certainly not for Canadians. Punishment for infanticide. As I mentioned earlier, we had a gentleman, again a monster in Halifax, released after breaking the bones of his baby. And here we have in this bill allowing the reduction of sentencing for infanticide, concealing of a body of a child, impaired driving offenses causing bodily harm. And again, we've just legalized marijuana. We don't have proper way to measure the impairment. Police departments have said they're not ready. And here we have the government going out of its way to reduce possible penalties for that. Material benefit for trafficking, abduction of persons at the age of 16, abduction of persons at the age of 14, forced marriage. Just in committee yesterday, we heard about in Sudan, Somalia, and the Congo, something like 50% of young girls are being forced into marriage. And we have the government saying we need to do more to prevent that, and we do overseas, but why are they reducing the crime here? Again, to wrap up, this bill, it has, I'm sure, wonderful intentions to try to speed up the system, but the government should look at fulfilling the responsibility of filling the judicial appointments, and they need to focus on victims and society and on making things easier for criminals. Thank you.
Questions and comments. Questions et commentaires. The honourable member for Parkdale Hyde Park.
So a comment, then a question, Mr. Speaker. So the first comment would be in respect to the honourable member's opposite's references to our reduction in penalties for body house. In fact, that shows a lack of understanding of the bill. The bill actually repeals the body house provisions, and that's because we take seriously discrimination, current and past discrimination, against the LGBTQ2 community. And that's an important facet of this bill. Perhaps it's not a priority for the member opposite, but it's certainly a priority for us. He's mentioned in his comments that we ought to get our act together and appoint judges. I put it to him that, in fact, there are currently more federally appointed judges in the province of Alberta, the province that he represents, than at any time in Canadian history. We've appointed 238 members. We've appointed 238 members to the superior courts and federal courts in this country under this government's watch, and that process includes diversifying the appointments, because we take seriously the issue of ensuring that the bench reflects the community that they serve. So whereas the previous government's record was appointing 32% women to the bench, we've appointed 56% women to the bench. Including this are 8 Indigenous people, 20 people who are visible minorities, 13 people who are LGBTQ2, and 3 persons who identify as persons with disabilities. My question, ergo, is this. For his constituents in Edmonton West, do they deserve to appear before a bench that actually looks like the community of Edmonton, or should we continue the old format of simply appointing homogenous people to the bench of the superior courts in this country? Thank you.
The honourable member for Edmonton West.
Thank you, Mr. Speaker. The honourable gentleman asks if the people of Edmonton West deserve certain things. Well, you know what they do deserve? They deserve not to have murderers winding the streets because this government is too incompetent and too busy playing around with virtue signaling than appointing judges. People in BC do not need a murder walking free. People in Nova Scotia do not need a father who's breaking the ankles and shin bones of a baby to be walking free because of this government's incompetence. That's what Canadians deserve, not this government.
Questions and comments. The honourable member for St. Albert, Edmonton.
Thank you, Mr. Speaker, and I thank my good friend from Edmonton West for his very well thought out speech. The Parliamentary Secretary to the Minister of Justice just stood up and patted the government on the back on the appointment of judges. I would remind this House of this government's record when it comes to the appointment of judges, including the fact that it took the minister a full 6 months before appointing a single judge. Under this minister's watch, we have seen on more than one occasion records set for the number of judicial vacancies, and we have seen judges themselves speaking out, including the former Chief Justice of the Court of Queen's Bench in the province of Alberta, Neil Whitman, begging and pleading the minister to take action. Does the honourable member agree that that doesn't sound like a record of action when it comes to appointing judges? It sounds like, from this government, it's too little, too late, resulting in a lot of serious cases that have been thrown out as a result of their inaction.
The honourable member for Edmonton West.
Thank you, Mr. Speaker. My colleague from St. Albert Edmond makes a lot of great results. I actually want to direct them to the Minister of Public Safety's department plan. Now, these are the plans set out at the beginning of every year. They're released with the estimates, beginning of the fiscal year, stating all of their goals and objectives and what they're going to achieve. And you know what it says about Canadian communities are safe? Under the Liberal government, their goal for the crime severity index is to actually go up from the Harper era. The question for a percentage of Canadians who think that crime in their neighbourhood has decreased, their goal is to have a 50% reduction in Canadians who believe that the crime in their neighbourhood has decreased. This shows the priorities of the Liberal government as not with Canadians, it's not with citizens, it's with virtue signalling, and certainly not with competence. Thank you.
Resuming debate, reprise du débat, the honourable member for Charleswood St. James, Assiniboia, Headingley.
Thank you, Mr. Speaker. Gives me pleasure to participate in today's debate of Bill C-75. I would like to use my time today to discuss some of the aspects of amendments to juries, the selection of juries. As we know, jury reform is an area of shared jurisdiction, and Parliament is responsible for the criminal law and the rules in the criminal code, setting out the framework for in-court jury selection. The provinces and territories are responsible for determining, for example, who is eligible for jury duty and the process by which the jury roll is compiled. Bill C-75 proposes several reforms with respect to the in-court jury selection process. First is the abolishment of peremptory challenges. The Standing Committee on Justice and Human Rights heard from several witnesses who testified on jury reforms. Several legal experts and advocates expressed strong support for their elimination, which would finally put an end to the exclusion of jurors on a discriminatory basis. From Kent Roach from the University of Toronto, the proposed abolition of peremptory challenge in Bill C-75 is the most effective and efficient way to ensure that neither the Crown or the accused engages in discrimination against Aboriginal people and other disadvantaged and identifiable groups when selecting a juror. Toronto attorney Brent Kettles. Having peremptory challenges cannot help but lower public confidence in the administration of justice when members of the public and prospective jurors watch prospective jurors excluded on the basis of no reason, on the basis of no evidence, and without any information. When those exclusions are based basically on the gut feeling of who is likely to be sympathetic to one side or the other, then that doesn't give the public or prospective jurors a feeling that jury selection is happening in a way that is fair and impartial and also represents the community. From legal expert Vanessa MacDonald, it is important to recognize that these challenges have historically been and can be used against persons to their detriment. We have to balance the perceived benefit of having the peremptory challenge in your pocket to challenge someone that defense counsel doesn't feel quite right about against the very real risk that these challenges are going to be used in a way that disadvantages the accused person. My view is that the potential harm, not only to the system, but to accused persons, is greater than any benefit that accrues. Discrimination in the selection of juries has been documented for decades. Concerns about the discriminatory use of peremptory challenges and its impact on Indigenous people being underrepresented on juries were raised in 1991 by Senator Murray Sinclair, then a judge, in the Manitoba Aboriginal Justice Inquiry. More recently, we heard from retired Supreme Court Justice Frank Akabuchi, who studied these issues in his 2013 report on First Nations representation on Ontario juries. Having read these reports and after hearing from many experts on the topic, I am confident that Bill C-75 proposes the right approach in abolishing peremptory challenges. It is a simple and effective way to prevent deliberate discrimination and the arbitrary exclusion of qualified jury members. Furthermore, to bring greater efficiencies to the jury selection process and to make it more impartial, the bill proposes to empower a judge to decide whether to exclude jurors challenged for cause, for example, because they are biased to one side, by either the defense or prosecution. Currently, such challenges are decided by two laypersons called triers who are not trained in the law. This process has been problematic, causing delays in jury trials even before they begin, and appeals resulting in orders for a new trial. The proposal would shift the responsibility over such challenges to judges who are trained adjudicators and therefore better placed to screen out impartial jurors. The proposed change reflects a recommendation made in 2019 by the Steering Committee on Justice Efficiencies and Access to the Justice System, a group established by the Federal, Provincial, Territorial Ministers of Justice and comprised of judges, deputy ministers of justice from across Canada, defence lawyers, representatives of the bar associations, and police. It is also consistent with what is done in other common law countries, such as England, Australia, and New Zealand. I am confident that this change in procedure will make improvements to the overall efficiency of our jury trials. There are also several proposed changes to modernize and update the challenge for cause grounds. Notably, the proposed change to reduce the number of jurors with criminal records for minor offences from being challenged and excluded for jury duty will help address concerns that excluding individuals with minor criminal records disproportionately impacts certain segments of society, including Indigenous persons, as noted by Justice Iacobucci. It will also assist in improving broader participation on juries and thus jury representativeness. In conclusion, the jury reforms in Bill 75 mark critical progress in the area of promoting fairness, diversity, and participation in the jury selection process. These improvements will also enhance efficiencies as well as public confidence in the criminal justice system, and I call upon all members of the House to support this transformative bill. Thank you.
Questions and comments? The Honourable Member for St. Albert, Edmonton.
To my colleague from Charleswood, St. James, Assiniboia, Headingley, who did speak a lot about jury reform, he did talk about the elimination of peremptory challenges. And this is something that we on this side took very seriously and were open to on the committee. I heard from the various witnesses. He did cite Professor Roach, but I would also note that I think uniformly every member of the defense bar who appeared before our committee said, don't eliminate peremptory challenges. In that regard, I would quote Solomon Friedman, criminal defense lawyer from Ottawa, who said, given the over-representation of Aboriginal persons and racialized minorities as accused in our criminal justice system, at present, the peremptory challenge is often the only tool counsel can use in order to ensure that the jury, even in some small way, is representative of the accused. Moreover, Michael Spratt, the former president of the Canadian Criminal Trial Lawyers Association, was very outspoken in his opposition. So I was wondering if the honourable member could comment, given the uniform opposition from the criminal defence bar.
The Honourable Member for Charleswood, St. James, Assiniboia, Headingley.
Okay. Thank you, Mr. Speaker. I'd like to thank the honourable member from Edmonton, St. Albert, for his question. It is correct that there are many members of the defence lawyer community that have made this assumption. However, we have a system right now in which we know drastically underrepresents Aboriginal people and racialized people on our jury system. So the system we've had up till now does not work, and this is a valuable means of helping to correct this imbalance.
Questions and comments? Questions et commentaires. The Honourable Member for Whitby.
Thank you, Mr. Speaker. And I would like to, I've been participating in this debate quite a bit throughout the day, and the member from St. Albert, Edmonton, sent out a message via social media that thought it was incredible that I and others were defending hybridization of serious criminal offences in Bill C-75 by trying to distinguish which was serious and which was less serious, and he went on to talk about kidnapping and said, newsflash, kidnapping is always serious. We're not saying that kidnapping is not serious, Mr. Speaker. What we're saying is there is a range of ways offences can be committed, and therefore a range in ways in which we could look at the seriousness of offences. And we leave it to the prosecution to be able to make that determination. It's not up to a politician to look from here within this chamber and then decide what is the range of seriousness within an offence that happens within a courtroom. That is up to the prosecution and to the judges to then make that determination. So the question to my honourable colleague when he talks about hybridization is, does he think that it is fair that we are leaving it up to the prosecution to decide the range in which offences can be committed and therefore apply the correct sentencing to those offences within our justice system?
The honourable member for Charleswood St. James, Assiniboia Headingley.
Thank you, Mr. Speaker, and I'd like to thank the honourable member for her intervention. I would agree that when we are setting public policy in Parliament, that much of the policy has to be administered at its levels where you need expertise in those levels. You wouldn't ask a physician to follow the law in what antibiotics they would prescribe. You wouldn't ask a judge to have no discretion in a sentence that they would give in court. We have to leave this to the experts in their fields, and the judges and the Crown attorneys are the experts in these fields.
Reprise du débat, resuming debate, l'honorable député.
The honourable member for Rosemont-la-Petite-Patrie. The member will have 10 minutes, and then there will be question period, and questions and answers will come after that. Thank you very much. Mr. Speaker, it's a pleasure for me to take the floor today to speak to this important bill, which has to do with fundamental questions about our criminal justice system and how we organize ourselves as a society. But I have a bitter taste in my mouth, and that's because of this time allocation motion. The Liberal government is once again imposing time allocation. It's been more than 50 times now in the past 3 years that the Liberal government has used this tool to prevent parliamentarians from debating legislation in depth. This bill will have consequences for our justice system and on the rights of victims as well as accused. And once again, the Liberal government is not allowing us to take all the usual time to thoroughly examine a bill. So history repeats itself. The Liberals had promised to rebuild confidence in our institutions and to bring parliamentarians back into the conversation, but once again we're being silenced. Bill C-75, which is before us today, is the government's reaction or response to the Jordan decision. The Jordan decision was a Supreme Court decision. The Supreme Court looked at the very lengthy delays at times which crop up in certain complex trials, and those delays led to a denial of justice, or they made it impossible to deliver justice in a credible way because it was taking years and years and years for trials to wrap up. So in the Jordan case, there was an 18-month delay between charges being laid and the trial, and in some, the legislation makes allowances for extensions in certain cases. So we understand the Jordan decision. It's about a denial of justice from undue delay. But that decision also had collateral effects because it wasn't initially anticipated that a lengthy trial could, in fact, allow the accused person to escape justice, because in some cases, accused people were released and they didn't have to face justice. They didn't have to face up to the charges that had been laid against them because of undue delay. So that said, the government's response has to be, what are we going to do to alleviate the burden, alleviate the backlogs in the system so that accused people can't escape justice and be released? Because if you consider public safety, that wouldn't be a very good thing. So we want to avoid this happening again. So we agree with Jordan. There was a good decision, but there are some dangerous consequences for society, some unintended consequences. And is the government's response adequate? And that's where we disagree with the Liberal government. We don't think the solutions that they've put on the table with C-75 will actually make it possible to achieve the objective of accelerating the justice system so that accused people are tried properly within a reasonable amount of time. And why? Well, because the most simple and effective solution would be to better fund the system, to provide more resources so that more cases could be heard more quickly. And in order to do that, there's a lot of things that could be done. One of the simplest things would be to appoint more judges. If there were more judges, there would be more trials. If there are more trials, they can be quicker. But we have a Liberal government that's dragging its feet and has done for 3 years. There are a number of vacancies for federal judges that still haven't been filled. And once again, we're waiting for those decisions to be made. So for us in the NDP, as long as the government isn't really doing something about it, isn't really investing, isn't really funding, isn't appointing judges, isn't hiring court clerks, so that these deadlines can be met, well, we're just stuck with half solutions, half measures, which might even aggravate the current situation. Before I talk about pre-trials or routine evidence adduced by the police, I'd like to spend a couple of minutes to once again condemn another broken promise by the Liberals. One might have expected the Liberal government to take this opportunity, as long as they're overhauling our criminal justice system with a bill that's over 300 pages long, one might have expected them to take the opportunity to keep the Liberal Party's promise to put an end to mandatory minimum penalties or mandatory minimum sentences, which the Stephen Harper government was a big fan of. The Prime Minister said they were going to put an end to mandatory minimums. It was a bad system. It tied the hands of judges. It made it impossible for them to do their job and use their discretion. So that was going to be done away with, and it would allow judges the leeway to exercise their discretion or their judgment, because there are never two identical cases, two identical fact situations. And so you can never treat two cases identically. So the Conservatives were populists, and they loved to use mandatory minimums. But of course that ties the hands of judges, and it makes it impossible for them to assess the facts of each case and decide what's the best decision and the best sentence for the case. So it was very disappointing and upsetting to see that not only did the Liberals promise to do away with mandatory minimums, it was also in the Justice Minister's mandate letter. In that letter, it said that mandatory minimums were a priority for the Liberals, but the Liberals did not include that important element in their justice reform. So they missed the opportunity to significantly overhaul the criminal justice system. They're going to keep going with these mandatory minimums, and judges will not have any discretion. And the number of cases brought before the courts might even go up. So they missed the boat. They could have come up with a solution that would have dealt with the problem. I'd like to take the time to quote from a few people: Emily Hill, Kent Roach, and others who in the Globe and Mail of this year said, and I think it's important to point this out, mandatory minimums are a bad idea. It's impossible for lawmakers to appreciate all the circumstances of an offense. They don't know whether the accused lives in poverty, has mental health issues or deficiencies, is a victim of racism or previous assaults. They don't know whether they have any dependents. Mandatory minimums do not allow the judge to determine whether incarceration is necessary for deterrence or for rehabilitation or to punish the offender in question. I think that's a major point. The Liberals should have included that in this bill, but they missed the boat because the courts, Mr. Speaker, let's remember, are a reflection of social problems in our communities. They reflect social realities, and this bill offers solutions that don't really meet the problem head on. And it's important that the courts be able to recognize the root causes of social issues like poverty, drug addiction, mental health issues, and so on and so forth. Investment and social support is urgently needed to reduce the burden on the courts and deal with the root causes of crime. And this is especially so in racialized and Indigenous populations. I think I still have a bit of time left. I just wanted to point out that the NDP is particularly concerned about the clause which would allow police evidence to be adduced by way of affidavit. If it's considered routine evidence, it can be submitted by affidavit, and at trial there will be no opportunity to cross-examine the police officer on that evidence. And in our view, there's a danger that that will limit an accused's ability to defend themselves. Thank you, Mr. Speaker.
For Les Patriotes Verchères, Mr. Speaker, the Auditor General has confirmed that for ordinary people, if you owe $5 to the CRA, they will follow you to the ends of the earth. However, that's not the same for others. You know, there are big clients, and for those big clients, Ottawa lets them get away with it on no grounds whatsoever. For those who have the means to hide their money abroad, there's no problem whatsoever. The problem with that is that we will never know how much we need to recover because the CRA hopes to recover that money, but that's not what actually it tells us about. It tells us about the money that it actually has recovered. Now, we have deficits here. And these deficits are caused by people who are not paying their taxes, and Ottawa is complicit.
Newton.
Mr. President, Assalamu alaikum. Muslims around the world are celebrating Milad-un-Nabi, commemorating the birth, life, and message of Prophet Muhammad, peace be upon him, and his teachings, which many Canadians hold dear and will celebrate over the coming days. Many Surrey-based masjids and organizations are holding prayers and celebrations. In my riding of Surrey Newton, I have and continue to look forward to joining all those in honoring Prophet Muhammad, peace be upon him, and his message of harmony, peace, and love. On behalf of all members in this House, I would like to extend my best wishes to all Muslim sisters and brothers celebrating Eid Milad-un-Nabi. Merci beaucoup. Thank you. Allah Hafiz.
The Honourable Member for Calgary-Midnapore.
Mr. Speaker, the Trilateral Commission was established in 1973 to foster closer cooperation amongst Japan, Western Europe, and North America. It is a non-governmental, policy-oriented forum that brings together leaders from the worlds of business, government, academia, media, and civil society. It offers a global platform for open dialogue, aiming to find solutions to the great geopolitical, economic, and social challenges of our time. Members share a firm belief in the values of the rule of law, democratic government, human rights, freedom of speech, and free enterprise. At last week's meeting in Silicon Valley, the focus was on issues such as privacy and security, election interference, and how to strengthen democracy in the world. As a new member, I was honored to spend time among some of the brightest minds in the world, and I look forward to continuing to contribute to this significant entity, helping further democracy both home and abroad.
L'honorable député de Sudbury.
The honourable member for Sudbury.
Sudbury, an area rich in mining history, I am pleased to highlight the importance of the minerals sector in Canada. This is a global industry, and Canada is an undisputed leader. In 2017 alone, Canadian mines produced over 60 minerals and metals worth nearly $44 billion, and the broader minerals sector directly employed more than 420,000 people. It is the second highest proportional employer of Indigenous peoples among the natural resources sector. That is why we are working diligently with provinces and territories, Indigenous communities, and industry from coast to coast to develop a Canadian minerals and metals plan. Le Plan Canadien pour les minéraux.
The Canadian Minerals Plan.
Ambitious goals and clear actions enabling Canada to remain a global mining leader while reflecting today's realities: climate change, sustainable development, social acceptability, advancing reconciliation with First Nations, and the transition to a modern economy. I ask all honourable members to join me in recognizing the importance of Canada's mineral sector to our economy and to communities across our country.
The honourable member for Esquimalt Saanich Sud.
Mr. Speaker, today I rise to mark the Trans Day of Remembrance and call attention to the 368 trans and gender diverse people who were murdered this past year and the more than 3,000 killed over the last decade worldwide. While Canada has explicitly recognized trans and gender diverse rights, policy changes on the ground and social acceptance lag far behind. Still, most places around the world remain much less safe than here. One of the highest rates of violence against trans and gender diverse people is found in Central America. And we learned last week that within the caravan headed toward the U.S. border was a mini caravan of LGBTQ people, primarily made up of trans women. Due to the extreme threat of violence facing this group, we call on Mexico to ensure their safety. We call on the U.S. to allow these asylum claims to be heard, and we call for international monitoring of the continued safety of this group now at the U.S.-Mexico border. On this Trans Day of Remembrance, while we mourn lives lost, let us also salute and find strength in the bravery and resilience of this community.
The honourable member for St. John Rothsay.
Mr. Speaker, last week I was proud to attend the unveiling of a Parks Canada plaque commemorating the national historic importance of the founding of the St. John Labourers Benevolent Association in my riding of St. John Rothsay. St. John's ship labourers were amongst the earliest groups of day labourers or casual workers in British North America to organize when they formed the St. John Labourers Benevolent Association in 1849. After its merger with the International Longshoremen's Association in 1911, the strength of this union continued into the early 20th century when its members helped to form and found the New Brunswick Federation of Labour and shape provincial legislation establishing a workmen's compensation system. The founding of the union defied conventional views towards casual labourers, proving that it was indeed possible for casual labourers to successfully organize and lobby for their rights. Indeed, the precedent set by this union was instrumental in empowering workers across the Maritimes and indeed across Canada. Thank you, Mr. Speaker.
The honourable member for Lambton, Kent, Middlesex.
Mr. Speaker, Remembrance Day, November the 11th, 2018, has passed, but the work of our local Royal Canadian Legion and Ladies Auxiliaries continues. Mr. Speaker, the Legions are an integral organization in many of our communities. In my riding in Lambton, Kent, Middlesex, we have 19 Legions. Through the well-known Poppy campaign and other fundraising events, they provide support to veterans, our Canadian Forces and RCMP members in active duty, as well as their families. They keep alive the memory of the courage and the sacrifice of those who served our country. The Legions are also involved in community activities, including support for youth and seniors. And all of this, the Ladies Auxiliary provide vital financial and volunteer assistance. The work wouldn't get done without them. So, Mr. Speaker, to the Legion and the Ladies Auxiliary members in Lambton, Kent, Middlesex, and across Canada, thank you for all that you do.
Honourable member for Mission Matsqui Fraser Canyon.
Mr. Speaker, agriculture is an exciting and dynamic industry that is full of opportunities, but it is not without challenges. I rise today to recognize both the Minister of Agriculture and Agri-Food and Farm Credit Canada for raising mental health awareness within the farming industry. My riding, Mission Matsqui Fraser Canyon, has a high concentration of farmers, and it is important that both individuals and families receive support throughout stressful situations. I'm pleased that farmers will have improved access to wellness resources with the FCC launching their mental health strategies guide. Mental health issues can affect anybody. It is important to have these discussions. I'm proud to join my colleagues and the agriculture community in removing the stigma surrounding mental health. Thank you, Mr. Speaker.
Honourable member for New Brunswick Southwest.
Mr. Speaker, I rise in the House today to talk about an important issue facing Canadian farmers, mental health. I am the granddaughter of a cattle farmer and well know the pride, strength, and independence demonstrated by our farmers. I've heard firsthand from farmers in my riding of New Brunswick Southwest of the uncertainty, the unpredictability, the stresses of weather, market forces, and wanting to pass the family farm on to new generations. The feelings of anxiety, stress, depression, isolation are not easy to share. It's time to break this barrier of stigma. There is no question we need our farmers. And I am pleased that the Agricultural Committee is completing the investigative study of the mental health and physical well-being of our farmers. Thank you, Mr. Speaker.
The Honourable member for Thornhill.
Mr. Speaker, today is Navy Day, a day dedicated to the men and women of the Royal Canadian Navy, the Canadian Coast Guard, and the Exceptional Sailors Program. Our senior service traces its roots back to Tudor times in England, where a standing navy was established long before a standing army, and of course an air force was still a theoretical Da Vinci dream. The Royal Canadian Navy's beginnings date back to 1910, growing quickly during the First World War, and by end of the Second World War, Canada had the third largest navy in the world. The Canadian Coast Guard, formed in 1962, now boasts a fleet of more than 100 vessels of various purposes and sizes. Now, challenges do remain with procurement, the shipbuilding program, and partisan interference. Bravo Zulu, Admiral Norman. But, Mr. Speaker, today we salute the men and women who have served in war and peace and who serve now in Canadian waters and around the world. Paratai, Viro, Paratai. Ready, I ready.
The Honourable member for Guelph.
Mr. Speaker, mental health is a growing concern for Canadians, but few would put farming on the list of most stressful careers. According to testimony heard at the Agriculture and Agri-Food Committee, farmers are one of the groups that is most at risk of suicide due to climate change, the stressful work environment, isolation, and growing misconceptions about the nature of farming and the food that farmers produce. La semaine dernière,
Last week, Farm Credit Canada sent its first edition of a brochure to help in resilience of producers.
Mental health and agriculture. I'd like to thank the witnesses who have had the courage to come forward to provide us with testimony that will help our committee to develop recommendations. Thank you, Mr. Speaker.
The Honourable member for Kildonan St. Paul.
Thank you, Mr. Speaker. I rise today in solemn commemoration of the 85th anniversary of the Ukrainian famine and genocide known as the Holodomor. In 1932, Joseph Stalin and the Soviet Union set a horrific policy to confiscate food and resources from Ukraine. This resulted in the intentional starvation and death of millions of people. At the height of Holodomor, 28,000 people died per day, and over 30% were children under 10. For over half a century, the Holodomor was denied and covered up by the Soviet regime. Today is Holodomor Memorial Day, and we remember the victims of this senseless crime against humanity. As leaders across this country, let us commemorate this act of genocide and stand up against the prejudice and hate that will seek to divide us. Thank you.
Honourable member for Bow River.
Thank you, Mr. Speaker. Last week, our Alberta Conservative Rural Crime Caucus Task Force reported its findings. They should be cause for significant alarm. We found that rural residents are afraid and angry. They're afraid and angry because the RCMP cannot respond to crimes in a timely manner. They're afraid and angry because our justice system is a revolving door. They're afraid and angry because this government has done little about it.
Pay attention, Trudeau.
We need serious leadership from this government to shape a multi-jurisdictional approach that will address rural crime. We need to keep dangerous repeat offenders behind bars. We need to bolster rural RCMP detachments. Rural crime levels have risen, but staffing levels have not. This situation is only getting worse, but the Liberals continue to introduce bills that punish law-abiding gun owners and make serious offences punishable by a mere fine, while doing nothing to combat gun violence and illegal handguns. They're completely out of touch with rural Canadians. Thank you.
The Honourable Member for Edmonton Centre.
This Trans Day of Remembrance, a day to honour those whose lives were lost through systemic violence because they were transgender. It is a day to reflect on the abuse and hatred still faced by transgender people around the world simply for being themselves. Nous nous sommes engagés de
We committed to protecting the rights of all Canadians. We made certain that non-binary individuals would be protected under the Criminal Code and the Canadian Human Rights Act, and we have provided support to marginalized communities around the world.
Despite this protection, trans people still remain targeted, harassed, assaulted, and discriminated against every day, stopping them from living their lives and being loved and participating in our communities. En tant que pays,
as a country, we must pay tribute to the incredible lives of the many transgender people we have lost, and we must acknowledge that much remains to be done.
Today, by remembering those lost due to bigotry and hate, we're continuing the fight for justice, for equality, and for a better future for all.
The Honourable Member for Port Moody Coquitlam.
Each year during Waste Reduction Week, elementary students in Port Moody Coquitlam participate in my annual Litterless Lunch Challenge. The challenge encourages students to pack litter-free lunches and make waste reduction part of their everyday routine. This year, more than 600 students participated, and today, I'd like to congratulate the winning class, who went an amazing 98.6% litter-free. Miss McKay's grade 1-2-3 class at Miller Park Community School in Coquitlam. Congratulations. Mr. Speaker, an average elementary school produces more than 20,000 pounds of lunch waste annually, and in the 7 years that we've run this challenge, more than 2,600 students and 45 schools have participated, diverting over 1,200 kilograms of waste. Thanks to all the students, teachers, and parents who participated. I hope you continue to work on your waste reduction efforts all throughout the year. Thank you.
The Honourable Member for Oshawa.
Mr. Speaker, I rise today to join this House in solemnly remembering the Ukrainian Holodomor of 85 years ago. The systemic starvation of a region, then considered Europe's breadbasket by Stalin's communist regime, cost the lives of millions of Ukrainians. As communities across Canada gather to honor these victims, my own community of Oshawa shall do the same. Oshawa has a vibrant Ukrainian presence that began with Julian Falinko in 1907, the first documented Ukrainian to arrive in Oshawa. More Ukrainians began arriving during the First World War and following the Holodomor, and by 1941 the number of people of Ukrainian origin only trailed those of English, Irish, and Scottish origin. As their numbers grew, they built churches, such as St. George the Great Martyr and St. John the Baptist, as well as community halls like Dnipro, Lviv, and Odessa. They are all places where members of our community celebrate, experience Ukrainian culture, dance, and of course, Ukrainian food. However, this Sunday, the 25th, we will gather at St. John the Baptist Ukrainian Church to remember those lives that were lost during the Holodomor. We will not forget.
The Honourable Member for La Prairie. Mr. Speaker, agriculture is a dynamic industry full of opportunities. However, psychological distress on the farm is an issue that concerns me both as a member and as a former producer. Earlier today, we announced a partnership with 4-H Canada to raise awareness amongst 24,000 young people and 7,700 monitors about the importance of mental health. This week, Farm Credit Canada is launching an initiative to reduce stigma around mental health by delivering a bilingual pamphlet to all agricultural addresses in the country. This brochure will contain testimonies, advice, and tools to help manage the stress of agricultural producers, and it will also include contact information for resources. Furthermore, we have announced that we will be collaborating with Farm Management Canada to study the connection between mental health and decision-making on the farm. Ensuring the psychological health of producers also contributes to the economic health of our regions. Thank you, Mr. Speaker.
Oral questions, questions orales. The Honourable Member for Milton.
Thank you, Mr. Speaker. Tomorrow, Mr. Speaker, the Minister of Finance will present to the House his fall economic update. But let's recap with a couple of things that we already do know. We already know that in the election campaign of 2015, this government promised no more than a $10 billion surplus or $10 billion deficit per year. I only wish it was a surplus. $10 billion deficit per year that would be balanced by the time we reach the next election in 2019. We know that both of those are untrue, but perhaps the Prime Minister can tell us today, has he set a date for us on which the budget will be balanced?
Right, Honourable Prime Minister.
Mr. Speaker, in 2015, Canadians had a choice. There were two parties that believed in cuts, while we promoted investments in the middle class and in people working hard to join it. We lowered taxes for the middle class and raised them on the wealthiest 1%. We delivered a more generous, fair, and tax-free Canada Child Benefit that gives more money to 9 out of 10 Canadian families and is lifting hundreds of thousands of kids out of poverty. We now have some of the lowest unemployment rates in 40 years. While Conservatives continue to defend their wealthy friends, we'll continue to stay focused on the...
The Honourable Member Order. The Honourable Member from Milton.
This from the Trust Fund,
well,
baby.
Mr. Speaker, I don't know. Maybe some of his friends from Cape Breton are rich. I can tell you not a lot of mine are.
That's right.
So I'll continue to talk to the people in Milton who certainly don't share the same set of friends that this Prime Minister does. But to the point that the Prime Minister indicated, which is this, he said that Canadians made a choice. You know what that choice was, Mr. Speaker? That choice was to keep deficits to $10 billion a year, and that choice was to return to a balanced budget by the time we got to the next election. That was the fundamental promise this government broke. He can fix it. Tell us when the budget will be balanced.
Right Honourable Prime Minister.
Mr. Speaker, the member opposite, and I don't blame her for it, seems to be forgetting the last years of the Harper government, where they nickeled and dimed their veterans, where they shut down veteran services offices, where they demonstrated tax breaks for the wealthiest and boutiques tax cuts, while not creating the kind of growth that Canadians needed from their economy. There was a choice in the 2015 election. We committed to put more money in the pockets of the middle class. We committed to invest in infrastructure in a way that would grow the economy, and that's exactly what we delivered, what they couldn't.
Honourable Member for Milton.
Mr. Speaker, Canadians certainly understand that this Prime Minister knows how to spend, but the question is whether or not he knows how to balance the budget, and we still don't have a date. If he wants to compare records in terms of what we did in order to ensure that middle-class and struggling Canadians did well, I might invite him to take a look at the education tax credit, the tuition tax credits, the children's fitness tax credits, the children's arts tax credit. All those things mattered immensely to my riding constituents in Milton, Ontario. He took that away, and he's going to pay for it.
Right Honourable Prime Minister.
Mr. Speaker, Those measures that the member opposite put forward were not available to low-income Canadians, Mr. Speaker. That is the difference between us and them. They keep putting forward non-refundable tax credits. We knew that directly delivering money to families with the Canada Child Benefit, tax-free, unlike the taxable benefits that they put forward, was the best way to help the Canadians. And it's not just the best way to help the middle class. It was actually the best way to grow the economy, because the confidence, the jobs created, and the economic growth is thanks to Canadians.
The Honourable Member for Richmond-Athabasca. Mr. Speaker, in 2015, the Prime Minister committed to posting modest deficits. These modest deficits are now more than $20 billion a year. It's as if this PM thought he was governing with monopoly money. Completely false, Mr. Speaker. This money has been earned by Canadians the hard way, and it comes out of their pockets. My question to the Prime Minister, for the fourth time in 2 days, when will we return to a balanced budget? The Right Honourable Prime Minister. Mr. Speaker, Canadians had a choice in 2015. They could have chosen the Conservatives or the NDP, who could have caught at all costs to not have a deficit or commit to investing in communities. They knew that that's how we would create the economic growth that was so sadly lacking during the Harper years. We have the lowest unemployment rate in 40 years, the greatest growth rate in the G7. We brought in the Canada Child Benefit, which will lift the Honourable Member. Mr. Speaker, while this Prime Minister is reciting the same lines day in, day out, we have racked up an $80 million deficit. For people who are listening, what does this mean? It means 470 arenas, like the ones where the one where the Senators play, these Canadian Tire Centres, 470 of them. Now, it is enough. When are we going to return to a balanced budget? The Right Honourable Prime Minister. Mr. Speaker, the Honourable Member was not here at the time, but Prime Minister Harper added $150 billion to our debt. We have created growth because we trust Canadians, because we have invested in infrastructure, community infrastructure, public transit, which is making a difference in the lives of people. We're going to continue to do this, as Canadians asked us to do in 2015. The Honourable Member for Rimouski, Neja-Témiscouata-les-Basques. Mr. Speaker, it's been months now that the CRA has been persecuting ordinary Canadians and being ever so delicate with the rich and big corporations. Now, who agrees with us, Mr. Speaker? The Auditor General. While the CRA was persecuting single mothers in Saskatchewan, the Auditor General's report confirmed that they were giving more time playing buddy-buddy with the richest among us and big corporations in particular. Why this double standard? The Prime Minister. Mr. Speaker, I thank the Auditor General for his advice, and we are resolute that the things be done justly and uniformly so that everyone pays their fair share. They will be examining their internal processes to make sure that things are done uniformly with respect to the tax system. Because of our unprecedented investments, we will be able to look at people who are evading, engaged in tax evasion, and they will have to face the consequences. The Right Honourable Member. Now,
your agency is that when you are not a rich Canadian, you're presumed guilty until you can prove you're innocent. But if you're a wealthy Canadian or part of corporate Canada, you're innocent until the CRA can prove your guilt. And because that's way more difficult than to go after people who can't defend themselves, then the wealthy go scot-free. As a result, in the last 5 years, Canada has forgone $16 billion. $16 billion in unpaid taxes. I'm asking the Prime Minister again, when will Liberals put an end to this unacceptable double standard in CRA operations.
Right Honourable Prime Minister.
On the contrary, Mr. Speaker, we've made historic investments in the CRA for the fight against tax evasion. We've fully adopted the international standard for automatic information exchange with our partners in the OECD. We've provided resources so that the CRA is better able to identify taxpayers who participate in aggressive tax avoidance schemes. With respect to offshore tax evasion, the CRA has more than doubled the number of completed offshore audits since we've taken office. Unlike the Harper Conservatives, fighting tax evasion in Canada is and abroad.
L'honorable député de Rosemont.
The honourable member for Rosemont Petite Patrie.
Of climate bad guys, Russia, China, Saudi Arabia, and guess who? Canada. A study confirms that the Liberal policies will drive the world above a catastrophic 5-degree warming. The Liberals aren't doing enough, and everybody knows it. In Quebec, more than 200,000 people signed the pact and pledged to reduce their pollution. Nobody's buying the Liberal delusion that everything is fine. Does the Prime Minister really believe that he can fool all people all the time?
Right Honourable Prime Minister.
On the contrary, Mr. Speaker, everything is not fine, and that's why we're moving forward with a historic plan to fight climate change in this country. We're working to reduce emissions across the Canadian economy, to create jobs and meet international commitments. Our actions include pricing pollution across Canada, accelerating the phase-out of traditional coal power, making historic investments in cleaner infrastructure like public transit and charging stations for electric vehicles, adopting regulations to cut methane emissions from oil and gas by 40 to 45% by 2025, and more. Canadians know this government is serious.
L'honorable député de Rosemont.
The honourable member for Rosemont Petite Patrie. Mr. Speaker, yes, we have to put a price on pollution, but it's not enough. According to a study, the present policies of the Liberal government would lead to a catastrophic warming of 5 degrees Celsius. We're in the exclusive club of the bad guys with Russia, China, and Saudi Arabia. Everyone knows this, but the Prime Minister in Quebec, more than 200,000 people signed the Pact for a Transition. They walk the talk. They're serious about the environment. When will the Prime Minister walk the talk? The Right Honourable Prime Minister. Mr. Speaker, we are walking the talk. Contrary to the NDP, we put a price on pollution across Canada. We have helped Canadian families be able to succeed in this transition. We are investing in renewable energies, in the green economy, in new technologies. We are delivering on an ambitious plan to fight climate change for today and for future generations. The honourable member for Mégantic-L'Érable. Here's a little fable. The Prime Minister had spent recklessly and then was unprepared. When there was a crisis, not one little dollar left, only holes in the budget. They asked him, what did you do when we had a strong economy? You just kept spending. When will the Prime Minister realize that this is not a fairy tale nugget, and tell us when he'll balance the budget? The Honourable Finance Minister. Thank you, Mr. Speaker. I thank my colleague for his question and his poetry. Mr. Speaker, it's important to remind Canadians that in 2015, Canadians wondered whether we were moving into a recession. And there was very little growth. What we did was to spend and invest in Canadians, and our growth rate is the strongest in the G7. The honourable member from Mégantic-L'Érable, Mr. Speaker. The Prime Minister says that the budget will balance itself. This is a poor example for Canadians who are piling up credit cards and debt. Will the Prime Minister say continue to spend one day by magic, this will happily end? Canadians can't say to their banker one day, I don't know when I'll be able to pay. When will the budget balance? What is the day?
The Honourable Parliamentary Secretary. Thank you, Mr. Speaker. In 2015, Canadians had a choice, either austerity and cuts or the Liberal Party plan. And Mr. Speaker, we decided to invest in Canadians, and now Canadians have $2,000 more in their pockets than when the Conservatives were around. Whereas the Conservatives were giving cuts to those who were the richest. Now, what we're doing is working. Our economy is working full throttle, and we are doing far better than they did. Thank you, Mr. Speaker.
There this millionaire trust fund prime minister goes again. While he forces taxpayers to fund his nanny services, he had the audacity to attack soccer moms and students as too rich as justification for taking away tax credit for kids' sports, arts, textbooks, and education. The average middle-class family is paying $800 more in taxes since this government took office. And even with all the extra revenue from those tax hikes, the deficit is almost $20 billion. When will the budget finally balance itself?
Honourable Parliamentary Secretary to the Minister of Finance.
Mr. Speaker, the member for Carleton keeps on quoting a study by the Fraser Institute that fails to take into account the Canada Child Benefit. In fact, the author of that study say that the Canada Child Benefit is a disincentive to hard work and independence because it fosters dependence on government. I would argue that the 18,000 children whose family receive more because of the Canada Child Benefit are hardworking Canadians, that the Canada Child Benefit is helping to make ends meet, and we stand by that policy that's lifting 300,000 kids out of poverty. And by the end of by next year, Canadian families will have $2,000 more in their pocket than they had under the previous government. Thank you, Mr. Speaker.
The honourable member for Carleton.
Well, Mr. Speaker, those same kids to whom we were the first party to actually directly fund child care benefits are also, we did it. The difference is we did it with a balanced budget. When we introduced child care benefits, we balanced the budget. When we boosted those child care benefits, we also had a balanced budget because we wanted those kids to benefit today and for the rest of their lives instead of having to pay interest to wealthy liberal bondholders and bankers in the sum of billions of dollars a year. The Prime Minister said the budget would balance itself. When?
The honourable member, Parliamentary Secretary.
Mr. Speaker, it's a creative vision of history. They added $150 billion to the debt, Mr. Speaker. The one thing they did with their form of Canada Child Benefit was tax it and take pictures next to the printing machine with a nice blue polo Conservative shirt. That's what they did. We've taken a different approach, Mr. Speaker, with a tax-free child benefit that's lifting hundreds of thousands of kids out of poverty in this country. That's helped grow the economy, and the results speak for themselves. Thank you, Mr. Speaker.
The honourable member for Carleton.
Well, he got me there. I did wear a Conservative T-shirt, but the Prime Minister can appreciate that at least I kept my shirt on. That is what helps me with my re-election chances, Mr. Speaker. But the Prime Minister promised the budget would balance itself. Will he stand now, keep his shirt on, and tell us when that will finally happen?
Honourable Parliamentary Secretary.
Thank you, Mr. Speaker, and I just want to correct the member for Carleton. Not just the Prime Minister thanks him, I think 35 million Canadians thank him. But all jokes aside, Mr. Speaker, when you look at the economic record of the Conservative Party in the decades that they were in power, we've seen the lowest levels of growth in 69 years, the lowest employment job creation since 1946. I mean, compare and contrast, and you'll see that our Liberal record is strong, and we stand by it. Thank you very much.
Honourable member for Carleton.
Well, Mr. Speaker, this Prime Minister famously promised that the budget would balance itself. He said that would happen just next year. We only have about 40 more sleeps until next year comes. And only one more sleep until this fall economic update in which we're supposed to find out about the finances of the nation. So a very simple question. If the budget will balance itself, then when will the budget balance itself?
Honourable Parliamentary Secretary.
Mr. Speaker, just to remind the member for Carleton, in the 2015 election, Canadians were debating whether Canada was in a recession or heading into a recession. We had slow growth, slow job creation, and Canadians decided to take the approach of investing in infrastructure, giving more money to the middle class to help grow this economy. We've had the fastest growth in the G7 in 2017. We've seen over 500,000 full-time jobs be created in the last 3 years, Mr. Speaker, and we see at the same time our debt-to-GDP ratio steadily going down, Mr. Speaker. This is fiscally responsible, and this is growing our economy. Thank you.
The honourable member for Nanaimo, Ladysmith.
Today, over 100 advocates are here calling for universal affordable childcare. Costs here are among the highest in the world. Some families pay more for childcare than they do for rent, and our system barely serves 1 in 4 kids. Canada is investing a fraction of what's needed to solve the childcare crisis. After voting down every progressive fix to pay equity in committee this morning, when will this government take some real action on gender equality and invest in affordable, universal childcare?
Honourable Parliamentary Secretary to the Minister of Social Development.
I remind the member opposite that this government has invested in childcare, $7.5 billion over the next 10 years, a direct investment partnered not only with the provinces and territories, but we also have the first distinction-based Indigenous childcare policy in the history of this country. We didn't stop there, though. We also provided the Canada Child Benefit, which, as my colleague has said, is now being indexed. Additionally to that, a $40 billion national housing strategy. We are heavily focused on reducing child poverty, supporting families, and making sure we build the most resilient generation of Canadian children in this country's history.
The honourable member for Saint-Hyacinthe, Bagot. Mr. Speaker, today is the International Day of the Child, but we can't celebrate when 1.4 million children are living in poverty throughout the country. Sending a check to a family and saying, that's it, it's solved, is just not enough. We need affordable daycare, we need pharmacare, we need dental care, we need programs to help the 38% of Indigenous children who live in poverty. I'm calling on the government. When will you bring in ambitious measures to really lift children out of poverty? The Honourable Parliamentary Secretary.
Ambition. In their campaign platform, they promise not to spend any money on anything unless they balance the budget first. That is not an ambitious program, nor is it ambitious to spend provincial and territorial money and not stand up as a federal government. This government has invested $7.5 billion in childcare, invested in a national housing strategy, EI reforms that have supported families as well. This government is committed to lifting children out of poverty. 300,000 so far, 600,000 Canadians. Our work is not done, and our investments haven't finished either.
The honourable member for Portneuf-Jacques-Cartier. Mr. Speaker, yesterday the minister responsible for StatsCan said he'd learned about the harvesting data project in the media. And yet the Act stipulates that the minister must be informed before the statistician-in-chief undertakes new projects. What is the minister doing to protect Canadians' privacy? What sanction will be levied against the statistician-in-chief for having broken the law? When will the minister put an end to this project? The minister, Mr. Speaker, our government takes Canadians' privacy very seriously, and we understand their concerns. The chief statistician was clear that he would pay careful attention to concerns about privacy. No data has been shared by StatsCan within the framework of this project. We will always protect Canadians' privacy.
People want to know that this minister cares about privacy, and yesterday we learned that he learned about this plan to collect personal financial data from over 1 million Canadians only after it was reported in the media. Now, the law says clearly that the minister must be informed before the chief statistician can move forward with any mandatory data collection. Can the minister clearly state to this House, was he or his office informed about this project to harvest the personal financial information of millions of Canadians after it was reported? Yes or no?
Honourable Minister of Innovation.
Mr. Speaker, one of the key issues the members opposite have raised are issues around privacy and data protection. We understand those concerns, and the chief statistician in committee, both in the House of Commons and the Senate, said he will only proceed when those issues around privacy and data protection are dealt with. With regards to personal information, no personal information will be shared with any private entities, no government agency, the CRA, RCMP, even the Prime Minister can compel Statistics Canada for this information. Privacy and data protection are absolutely essential, and our government supports that position.
Honourable Member for Central Okanagan, Similkameen Nicola.
Mr. Speaker, notice he didn't answer the question. The minister stated yesterday at committee that he learned about the plan to collect personal financial data from over 1 million Canadians when it was reported in the media. Now, the law says he must be told before any request can be made. The government has already told the banks that they must provide this information. Is the minister suggesting that Statistics Canada violated the law by not notifying him?
Honourable Minister of Innovation.
Mr. Speaker, this is a pilot project. With regards to the next steps, the chief statistician has been very clear. He will only proceed if issues around privacy and data are dealt with in a meaningful way. The member opposite knows no information has been obtained, no information has been shared. With respect to privacy, we've been very clear that no government, no agency, no authority can compel any personal information from Statistics Canada, and we've been very clear. We also share the concerns around privacy and data protection, and we welcome the work the Privacy Commissioner is doing.
The Honourable Member for Central Okanagan, Similkameen Nicola.
I see the minister is getting ready for skating weather because he's skating around this issue and won't address it. Now, the law says he must be notified, but the minister says he wasn't. The minister is either incapable of managing his own department or officials were hiding things from him. Now, we know that StatsCan makes over $100 million a year selling data to corporations. Did Statistics Canada choose not to tell the minister their plans because they want to sell this data to large international businesses, Mr. Speaker?
The Honourable Minister.
Again, Mr. Speaker, the member opposite is making up his own facts. He doesn't believe in good quality, reliable data. He doesn't understand the fact that no personal data is ever shared by Statistics Canada. That's what he's implying when he asked that question. Let's be very clear. This was a pilot project. No information was obtained. And Statistics Canada is working with the Privacy Commissioner to deal with issues around privacy and data protection. The fundamental problem here is that the members opposite do not support Statistics Canada. They do not support good quality, reliable data. And that's the real issue here, Mr. Speaker.
Order. The Honourable Member for Timmins, James Bay.
Monsieur le Président.
Mr. Speaker, the project to establish a Francophone university in the largest city of Canada is a symbol of pride for Ontario and for Francophone communities across the country. But the decision by Mr. Ford to attack the Franco-Ontarian community was to satisfy the Conservative base, and there are many national implications involved in that. Can the Prime Minister, or is the Prime Minister rather, prepared to work with the Franco-Ontarian community, prepared to ensure the future of this institution? Thank you, Mr. Speaker. I'd like to thank my colleague opposite for his excellent question. 5 days since the Black Thursday, when the Conservative government in Ontario and the Conservatives generally decided to launch this attack on Franco-Ontarians, 5 days since the leader of the Conservative Party has not denounced what's happening in Ontario. We are going to work with all members of the House to bring pressure to bear on the Conservative Party to ensure that they defend the rights of linguistic communities and Franco-Ontarians.
Honourable Member for Edmonton Strathcona.
Doug Ford n'est pas le seul.
Doug Ford isn't the only one to abandon Francophone universities. The government abandoned Saint-Jean campus at the Francophone University in Edmonton. But the Francophone population in Alberta has increased and the number of students has doubled. Funding can't keep pace, and the Liberals aren't spending the funds. At least the NDP in Alberta has taken over. Why aren't the Liberals supporting Campus Saint-Jean?
Alors.
Order.
L'honorable ministre de bilinguisme.
The Honourable Minister. Thank you, Mr. Speaker. The Campus Saint-Jean is very important. I've been there several times, including with my parliamentary secretary and the member for Edmonton Centre. It's an extraordinary institution, and that's why we have decided to increase funding for linguistic minority groups. We've increased budgets for all linguistic communities, and we are going to continue to support them. We've invested $2.7 million in official languages, the largest investment in the history for official languages. And francophones outside Quebec and anglophones in Quebec, no.
The
Honourable Member for Vimy.
Monsieur le Président, cette semaine est la...
Mr. Speaker, this week is GBA Plus Awareness Week, and an opportunity for us as parliamentarians to participate in events and activities and learn more about this issue.
Decision-making affects diverse groups of people is key to achieving gender equality. Can the Minister of Status of Women tell this House what the government is doing to enhance implementation of GBA Plus across federal departments?
Honourable Minister.
I thank my honourable colleague, Mr. Speaker, and she knows, as we all do, that the impact of government decisions are felt differently by Canadians depending on a variety of factors, including where they live, how they identify, and or their official language of choice. Our government relies on GBA Plus to assess and to mitigate for any differential impacts, and our approach is working. The economy is growing, and we are advancing equality. This week at the GBA Plus Forum, our government will be sharing our successes and looking for ways to further collaborate with leaders from across sectors so that together we can grow the middle class and support those working hard.
The Honourable Member for Grand Prairie Mackenzie.
Thank you, Mr. Speaker. Canada's oil is being liquidated at $17 a barrel, while our international competitors are getting $54. This discount is costing the Canadian economy $80 million each and every day, and is a direct result of the Liberals' cancellation of the Northern Gateway, the Trans Mountain, and the West to East pipeline projects. Now, the Liberals have proposed something new. It's called the No New Pipelines Bill C-69. This is going to make this discount permanent. Will the government kill Bill C-69 and allow pipelines to be built, or are they prepared to allow this discount to continue?
The Honourable Minister of Natural Resources.
Mr. Speaker, the challenges experienced by the energy sector are real, and we're working with the energy sector as well as province of Alberta to deal with them. But let's look at the facts. What we are seeing today happening in Alberta is the result of a decade of inaction by the previous government to build a single pipeline to take our resources to non-U.S. markets. 99% of Alberta's oil is sold to only one single customer, which is the United States. We are focused on reducing that dependency by moving forward on the pipelines in the right way.
The Honourable Member for Grand Prairie Mackenzie.
Well, Mr. Speaker, Stephen Harper never cancelled one pipeline. That minister has cancelled 3. Yeah. Today, Canada Action has initiated a campaign to inform Canadians of what the Liberals' failures are costing the Canadian economy. Tens of billions of dollars are lost as discounted Canadian oil flows to the United States. And this Prime Minister is making it worse with Bill C-69. So the question is simply, will he kill his No New Pipelines Bill C-69, or is he going to continue to allow the energy sector to fail and everybody who works in it fail as well?
The Honourable Minister of Natural Resources.
Well, Mr. Speaker, Stephen Harper's government failed to build a single pipeline to take our resources to non-U.S. markets. That's the result that we are seeing today. And we are also seeing the increased investment in the energy sector, despite the opposition beating down on the energy sector. Close to $500 billion of new investment is being planned for Alberta's energy sector, including $40 billion LNG project investment that we saw, the single largest private sector investment in Canada's history. Thank you, Mr. Speaker.
Honourable Member for Lakeland.
In reality, the Liberals killed the only new options for exports to the Asia-Pacific and to Europe. They drove away more than $100 billion in energy projects, the worst loss in more than 7 decades. Over 100,000 Canadians lost their jobs. The pipelines and discount crisis harms other sectors in all provinces. ATP's chief economist says, quote, "This is a national problem, and we could see layoffs in early 2019. It could spawn, if not a recession, at least another slowdown for the Canadian economy." So other than more empty words, what will this minister actually do to fix the crisis the Liberals caused?
The Honourable Minister.
Mr. Speaker, when energy workers needed help, we stood with them. We were the government that extended EI benefits for struggling energy sector workers, which the Conservative government voted against, Mr. Speaker. This
Order. 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 We need to hear from both sides, and members, including the Honourable Opposition House Leader, need to listen to both the questions and the answers. The Honourable Minister of Natural Resources has the floor.
Well, Mr. Speaker, I think they can't accept the reality that they failed the energy sector, and that's why they make so much noise. We were there to stand with them when energy workers needed our support, and we will continue to support them in a way by building the pipeline capacity, by supporting them in the time of need. Thank you, Mr. Speaker.
The Honourable Member for Lakeland.
Well, clearly the Liberals want EI checks, but Conservatives want paychecks for Canadians. But last year, the Prime Minister, he said he wants to phase out the oil sands. And last spring, he said he regrets Canada can't get off oil, quote, tomorrow. The Prime Minister killed the only 2 pipelines meant for export to new markets. It's a travesty. Canada's the most responsible oil producer, with the 3rd largest reserves and the 4th largest exports. The Liberals' sabotage of Canadian energy caused this crisis and now even calls for decreased production. Can the Liberals be honest for once? Isn't this actually exactly what the Prime Minister wants?
The Honourable Minister of Natural Resources.
Well, Mr. Speaker, it's really disappointing to hear from the member from Alberta that when workers need EI extension and benefits they deserve, that they don't deserve those benefits. That's very, very disappointing to see that kind of attitude to
Order. The Honourable Members for Battle River, Crowfoot, and perhaps Brant Airdrie seem to think that they can speak without having the floor. I remind them that's not the case. The Honourable Minister. Order. The member for Signal Hill, Calgary Signal Hill, will also come to order. The Honourable Minister of Natural, unless he wants to exit. Order. The Honourable Minister of Natural Resources.
Mr. Speaker, as I have stated earlier, we are focused on building the pipeline capacity because we understand that reducing the dependency on our single customer, which is the U.S., should be our focus in order to support our energy sector the right way. Thank you, Mr. Speaker.
The Honourable Member for Esquimalt Saanich Soup.
Mr. Speaker, a year ago in Vancouver, the Defence Minister made modest promises to recommit Canada to UN peacekeeping. But last weekend, the Minister announced that the only concrete part of that promise that he actually kept, providing Canadian medevac support for the UN mission in Mali, will come to an abrupt end in July. That's after just 1 year and with no other nation lined up to fill that gap. Will the Minister demonstrate Canada's firm support for UN peacekeeping by extending our Mali mission by at least 6 months or until a replacement can be found?
Minister of National Defence.
Mr. Speaker, we're very proud of our government's support to the United Nations and the announcement that we made last year in support of the United Nations. We're very proud of the work that our Air Task Force are doing in Mali. Our government support to the United Nations is far broader than the Air Task Force. It's about a whole-of-government approach. It's about providing and focusing on smart pledges that the United Nations had asked for. We will be looking at other support as well in terms of a quick reaction acts for. It's about increasing the number of women on peace support operations, which we are also supporting on, and also reducing the number of child soldiers that will help reduce conflict. Thank you, Mr. Speaker.
The Honourable Member for Laurier-Sainte-Marie. Thank you, Mr. Speaker. Mr. Speaker, we've learned today that Saudi Arabia, despite the fragile ceasefire with Yemen, has resumed bombing the port of Hodeidah, the one used to move 80% of humanitarian assistance, which presumably includes Canadian assistance. So we give humanitarian aid to Yemen, but we sell weapons to the country that's preventing the humanitarian assistance from reaching its destination. Can someone explain the logic behind that? The Honourable Minister. Mr. Speaker, as regards Saudi Arabia and the war with Yemen, I want to underscore something. First of all, we condemn the death of journalist Khashoggi and have called for a ceasefire in Yemen. We are actively looking at other measures, including the use of the Magnitsky Law and new export permits will not be granted. The Honourable Member for Chicoutimi-Le-Fjord. Mr. Speaker, the Australian F-18s will be a liability for the Royal Canadian Air Force and for taxpayers. The capability gap is nothing more than a political play to detract Canadians from more urgent problems. There's a shortage of pilots, technicians. Our fleet is currently unable to be fully operational. Our pilots can't get in the number of flying hours they need. The fighter jet fleet needs renewing. When will the government cancel the purchase of the F-18?
Mr. Speaker, our government will ensure our women and men of the Royal Canadian Forces have the appropriate equipment that they need to do their jobs. And we want to thank the Auditor General for his important work and recommendations. And I encourage the member to read the entire report on this. The report confirms that we have what we have always known. The Harper Conservatives mismanaged the fighter jet file and misled Canadians for over a decade. The report confirms the capability gap exists and which started under the Conservatives, Mr. Speaker. Unlike the Harper Conservatives, we will not compromise on our ability to meet our NATO and NORAD commitments. Thank you.
The Honourable Member for Selkirk, Interlake Eastman.
Well, Mr. Speaker, if there was a capability gap under us, it would have been found in the ATIP, the Access to Information request that came forward that said there were 0 documents about a capability gap. And we know that the Liberals invented this capability gap to give cover for the Prime Minister's naive election promise. And they used this fabricated gap to justify the purchase of rusted-out Australian jets. Now, the Auditor General report was perfectly clear. These used jets will not meet Canada's international military commitments. Will the Prime Minister follow the Auditor General's advice and cancel the purchase of these old, used Australian fighters?
The Honourable Minister of National Defence.
Mr. Speaker, I thank the member for his question and his passion for support of the Canadian Armed Forces, but I want to quote the Auditor General's report, and I quote, "Having a combat-capable fighter force is important to Canadian and national security and to national defence's ability to meet Canada's commitments to NORAD and to NATO, Mr. Speaker." Mr. Speaker, that's why we have launched a full competition to replace all for our fighters, Mr. Speaker, and not 65 fighters Mr. Speaker, that the previous government asked for, 88, because that's what's going to be required to meet our commitments, Mr. Speaker, and we are making commitments.
Order. The Honourable Member for Selkirk, Interlake Eastman.
Mr. Speaker, the Auditor General clearly pointed out that over the last 3 years, pilots have been leaving in droves because of that minister's mismanagement. Well, Mr. Speaker, this proves that the Prime Minister and the Liberals have been playing political games with our Air Force. He is willing to spend billions on trying to upgrade jets that are falling apart instead of investing that money into a new fighter fleet. And the Air Force can't even recruit enough pilots because they don't want to fly these old Australian fighter jets. When will this Prime Minister be honest with Canadians and with the Air Force members and cancel this purchase of obsolete Australian jets?
The Honourable Minister of National Defence.
Mr. Speaker, I want to thank again the member's passion with support for the Canadian Armed Forces. But when the Harper Conservatives were in power, when the member was a parliamentary secretary of national defence, at that time did not support the proper investments in the Canadian Armed Forces. Hence the reason why we were in this situation, Mr. Speaker. That's why back in 2016, Mr. Speaker, the Canadian Armed Forces, as we directed, to start recruiting more pilots, Mr. Speaker, because we knew that we not only need pilots, Mr. Speaker, we also need technicians. Nations to make sure that we have enough fighters, and our new competition that we have already launched will make sure that we have the appropriate.
The honourable member for Northwest Territories.
Mr. Speaker, far too many Northern Canadians are energy insecure. Most communities in Northwest Territories rely on diesel as their primary energy source, and several use diesel as backup source for other aging energy infrastructure. Diesel energy generation is both significant source of carbon pollution and very expensive for families and businesses. Can the Minister of Infrastructure tell this House what the government is doing to help northern communities be more greener, more sustainable, while ensuring they have a secure source of affordable energy?
Hear, hear. Honourable Minister.
Good question.
Really good question.
Mr. Speaker, I want to thank my colleague for his hard work for Canada's North. I was really pleased to join him in the Northwest Territories last week to announce investments of over $14 million to upgrade the Snare Forks hydro plant and also $30 million to help build 4 wind turbines in Inuvik, the first project under the Arctic Energy Fund, Mr. Speaker. These projects will reduce greenhouse gas emissions and improve the lives of residents in the Northwest Territories. We will continue to work with Northern Canadians to ensure they have access to reliable and sustainable energy sources now and for the years to come, Mr. Speaker.
The Honourable Member for Bellechasse-les-Etchemins-Lévis. Mr. Speaker, what happens when the union representing 13,000 media workers announce that they're going to campaign against the Conservatives and for the Liberals? The government and the Liberals announce lots of dollars just a week later. Many respected journalists have expressed their discomfort with this incestuous practice. The question is simple. Instead of really dealing with structural problems, is the government perhaps trying to buy out the media as an election approaches? The Honourable Minister. A conspiracy theory, Mr. Speaker. On this side of the House, we acknowledge the importance of professional journalism. Journalism is they're an important part of our society. It's the foundation of our democracy. That's why invested in journalists. We've supported CBC, we've supported local media, and we continue to work with various stakeholders, unions, etc., to see how we can work together based on a very simple process and principle to protect the independence of the media. We understand that on this side of the House. I wonder if they understand it on the other.
Dina, Bulkley Valley.
Here's a story for you, Mr. Speaker. Imagine you hired somebody, and after a while they said, you know what, I'm quitting. But then 8 months later, you found out they were still taking a salary without having done a day's worth of work. Well, that's exactly what the MP from St. Leonard, St. Michel has done. What kind of prime minister would condone this kind of behavior? And can't Liberals understand it's exactly this sense of entitlement that drives Canadians crazy? So will the Liberals join with us in calling for an investigation by the Ethics Commissioner into this deplorable actions? Yes or no?
Yeah. While it's a little unclear whether this is under the heading of government business, I see the honourable order. The honourable member for Grande Prairie Mackenzie will come to order. Order. I see the honourable government House Leader rising to answer.
Mr. Speaker, if you recognize that it's not government business, we should not be answering the question. I think we all know that we have the utmost respect for the rules here. When it does come to the honourable member's question, he knows very well that the MP has issued a statement. He knows very well that we will always work with the Commissioner's office. Thank you, Mr. Speaker.
The honourable member for Shefford.
The honourable member for Shefford. Mr. Speaker, agriculture is exciting and dynamic and full of opportunities, but not without challenges. The Agriculture Committee is currently looking at mental health challenges facing our farmers, ranchers, and producers. Our commitment to farmers goes well beyond the best economic framework for growing their businesses. Can the Minister tell us about government initiatives designed to support the mental health of Canadian farmers? The Honourable Minister.
Merci, Monsieur le Président. And
thank you, Mr. Speaker.
The member from Shefford and all the members of the Agricultural Committee for their hard work on this very important issue. Together with my parliamentary secretary, we're working with Farm Credit Canada to reduce the stigma around mental health with the publication delivered this week to all Canadian farms. We also announced a new partnership with 4-H Canada to support mental health and physical health, and we're working with Farm Management Canada to support the Canadian farmer. We will continue to work together to promote mental health in the agricultural sector. Thank you, Mr. Speaker.
Member for Thornhill.
Mr.
Speaker, government bailout investment has no place in an independent Canadian news industry. How independent can thousands of journalists at struggling news organizations across the country be if their employers survive, are dependent on government subsidies, slush fund tax relief, or direct cash bailouts? Mr. Speaker, again, and I don't want to hear about millions more for the CBC, why can't the Liberals understand that a media bailout in an election year is simply unacceptable?
Honourable Minister of Canadian Heritage.
Mr. Speaker, on this side of the House, we acknowledge the fundamental role played by our journalists. They are professional journalists who work is based on facts. Professional journalists play a fundamental role in our society. They are one of the pillars of our democracy, Mr. Speaker. We work with them. We are discussing with the various media groups and associations, looking at cooperation, and it's based on a fundamental principle, Mr. Speaker, to preserve journalism. It's a fundamental process. That's what we're doing, Mr. Speaker. The Honourable Member for Rivière-du-Nord. Mr. Speaker, healthcare costs are going up year after year in Quebec, and what does Ottawa do? Threatens to cut transfers if Quebec doesn't comply with its demands. As if patients in Quebec needed that. As if people in our hospitals needed that. To be in a battle with the Prime Minister. Instead of threatening to weaken our healthcare system, will the Minister of Finance commit to restoring the 6% increase to health transfers in a statement tomorrow?
La Santé.
The Honourable Minister of Health. Mr. Speaker, we will not authorize a two-speed system. It doesn't work. Having more money and receiving care more quickly is not the right way. We will continue to work together in order to protect our healthcare system to better serve all Canadians. Thank you, Mr. Speaker. The Honourable Member for Rivière-du-Nord. All the same comments. Ottawa is already failing to meet its commitments to health transfer. Year after year, Ottawa is doing less and less, and now the Minister of Health is threatening to weaken the healthcare system even more at the expense of our people, Quebecers, Mr. Speaker. But the Minister of Finance can take action now. Will he commit to restoring bringing the increase in the transfers up to 6% in his economic statement tomorrow, yes or no? The Honourable Minister. Thank you, Mr. Speaker. We believe that what we need for healthcare is the health card, not a credit card. Across the country, our health system is something we are proud of. People can achieve and receive care without having to pay. Quebec and all of the provinces can use our healthcare system. Thank you, Mr. Speaker.
The
Honourable Member for Montcalm. Mr. Speaker, Tufik Manamish has lost hope. Being detained in Cuba against his will since July 7, 2017, he runs a risk of being thrown in prison any day now. And even if the Cuban Supreme Court quashed his conviction due to procedural errors, a new trial with the same judge, same prosecutors, same procedures awaits him and may well wrongly convict him again. Can the Minister of Global Affairs take action immediately to protect a citizen who is a victim of abuse of power?
The Honourable Parliamentary Secretary for Consular Affairs.
Thank you, Mr. Speaker. Consular officials are providing assistance to Canadians, as we know, and consular officials are in contact with local authorities to gather information. Of course, we're governed by the Privacy Act, and I can't say anything more at this time. Thank you, Mr. Speaker.
I got one. The Honourable President of the Treasury Board is rising on a point of order.
Mr. Speaker, I have the honour to table in both official languages on behalf of 86 departments and agencies the departmental results reports for 2017 to 2018, and if I may add, Mr. Speaker, what great results they are. Thank
you.
The honourable member for Beauport-Côte-de-Beaupré with a point of order. Mr. Speaker, I would like the Minister of the Francophonie to apologize when she says that we on this side of the House do not work for Francophones. I sit on the Committee of Official Languages and have done so for years, and I am standing up now. That is a point of debate. I'm sorry.
Speaker, I rise on a point of order. I believe if you seek it, you will find unanimous consent for the following motion that the government provide the date upon which the budget will balance itself, and that it provide this date tomorrow. Thank you.
It being 3:11 p.m., the House will now proceed to the taking of the deferred recorded division on the motion of Mr. Poilievre relating to the business of supply. Calling the members.
The question is as follows. Mr. Poilievre, seconded by Mr. Deltel, moved that the House call on the government to tell Canadians in what year the budget will be balanced, and to do so in this week's fall economic statement. All those in favor of the motion will please rise.
Mr. Nicholson. Ms. Finley. Mr. Ledoux. Mr. Bazan. Mr. Kent. Mr. Reyes. Ms. Raitt. Mr. Poilievre. Mrs. Bloch. Mrs. McLeod Thompson Caribou. Mr. Blaney Bellechasse Lévis. Mr. McColman. Mr. Nuttall. Mr. Barlow. Mr. Berthoud. Mr. Martel. Mr. Albus. Mr. Chong. Mr. Richards. Mr. Strahl. Mrs. Stubbs. Mrs. Vecchio. Mrs. Wong. Mr. Aboutayev. Mrs. Kuzi. Mr. Kelly. Mr. Generou. Mr. Tilson. Mr. Warwa. Mr. Sorensen. Mr. Reid. Mr. Lukiski. Mr. Nader. Mrs. Wagenthal. Mr. Broussard. Mr. Sweet. Mr. Carey. Mr. Anderson. Ms. Alislev. Madame Boucher. Mr. Lake. Mr. Calkins. Mr. Falk-Provencher. Mr. Gould. Mr. Kimmich. Mr. Macaulay Edmonton West. Mr. Lobb. Mr. Kitchen. Mr. Jennis. Mrs. Gallant. Mrs. Falk Battleford Lloyd-Minster. Mr. Albrecht. Mr. Dreeshen. Mr. Hoback. Mr. McGuire. Mr. Cooper. Mr. Arnold. Mr. Clark. Mr. Godin. Mr. Stanton. Mr. Lauzon-Stormont-Dundas, South Glengarry. Mr. Van Kesteren. Mr. Shipley. Mr. Iglinski. Mr. McKenzie. Mr. Udega. Mr. Diot. Mr. Leipert. Mr. Shields. Mr. Bierson. Mr. Waugh. Mr. Weber. Mr. Motz. Mr. Benzin. Mr. Lloyd. Mr. Trost. Monsieur Beaulieu. Monsieur Plamondon. Monsieur Sainte-Marie. Monsieur Thériault. Madame Posé. Monsieur Fortin. Monsieur Barcelou-Duval. Monsieur Bernier.
Ceux qui s'opposent à la motion vont
All
bien.
those opposed to the motion will please rise.
Mr. Trudeau. Mr. Hare. Mr. O'Regan. Mr. Sajan. Madame Joly. Mr. Goodale. Mr. Rodriguez. Ms. Petitpas-Taylor. Ms. Freeland. Mr. Leblanc. Ms. Chager. Ms. Qualtrough. Mr. Bryson. Ms. Wilson-Raybould. Mr. Macaulay-Cardigan. Ms. Bennett. Mr. Baines. Ms. Haidu. Mr. Hussain. Mrs. Philpott. Ms. Tassie. Ms. Ing. Ms. Mahaichuk. Mr. Casey Cumberland Colchester. Mr. Easter. Mr. McKay. Ms. Scroll. Ms. Scrooge.
Monsieur Lausanne, enchanté de Petite Nation.
Monsieur Lauzon, enchanté de la Petite Nation.
Mrs. McCrimmon.
Mr. McCrimmon.
Ms. Jones.
Ms. Jones.
Mr. Algabra.
Mr. Algabra.
Mr. Leslie.
Mr. Leslie.
Mr. Carr.
Mr. Carr.
Ms. Gould.
Ms. Gould.
Mr. Sohi.
Mr. Sohi.
Mr. Champagne.
Mr. Champagne.
Mr. Holland.
Mr. Holland.
Ms. Monsef.
Ms. Monsef.
Mr. Garneau.
Mr. Garneau.
Ms. Duncan Etobicoke North.
Ms. Duncan Etobicoke North.
Ms. McKenna.
Ms. McKenna.
Madame Leboutier.
Madame Leboutier.
Madame Bibeau.
Madame Bibeau.
Mr. Wilkinson.
Mr. Wilkinson.
Mr. Cusner.
Mr. Cosner.
Ms. Murray.
Ms. Murray.
Mr. Casey Charlottetown.
Mr. Casey Charlottetown.
Mr. Vaughan.
Mr. Vaughan.
Monsieur Lemetti.
Mr. Lemetti.
Mr. Miller, Ville-Marie, le Sud-Ouest des Sœurs.
Mr. Miller, Ville-Marie, le Sud-Est des Sœurs.
Mr. Schiffke.
Mr. Schiffke.
Mrs. Romanato.
Mrs. Romanato.
Monsieur Hébert.
Mr. Hébert.
Mr. Eiking.
Mr. Eiking.
Mr. Bagnall.
Mr. Bagnall.
Mr. Paradis.
Mr. Paradis.
Mr. McGinty.
Mr. McGinty.
Mr. Nanda Sangri.
Mr. Nanda Sangri.
Mr. Fillmore.
Mr. Fillmore.
Mrs. Jordan.
Mrs. Jordan.
Ms. Goldsmith-Jones.
Mr. Goldsmith-Jones.
Mr. Oliver.
Mr. Oliver.
Monsieur Lefebvre.
Mr. Lefebvre.
Mr. Mendicino.
Mr. Mendicino.
Mr. Duguid.
Mr. Duguid.
Mr. Lamoureux.
Mr. Lamoureux.
Mr. McKinnon-Gatineau.
Mr. McKinnon-Gatineau.
Mr. Lightbound.
Mr. Lightbound.
Ms. O'Connell.
Mr. O'Connell.
Mr. Varani.
Mr. Varani.
Mr. Poisson.
Mr. Poisson.
Mr. Fraser Central Nova.
Mr. Fraser Central Nova.
Ms. Young.
Ms. Young.
Mrs. Schultz.
Mrs. Schultz.
Mr. Vandal.
Mr. Vandal.
Ms. Cara.
Ms. Cara.
Mr. DeCourcy.
Mr. DeCourcy.
Mr. Scarpalagia.
Mr. Scarpalagia.
Mr. Sims.
Mr. Sims.
Mr. Tansey.
Mr. Tansey.
Mr. Jesnevsky.
Mr. Jesnevsky.
Mr. Dollywall.
Mr. Dollywall.
Mr. Pesky-Salido.
Mr. Pesca-Salido.
Madame Mendez.
Madame Mendez.
Mr. Oliphant.
Mr. Oliphant.
Monsieur Dubourg.
Mr. Dubourg.
Mr. Aldaig.
Mr. Aldaig.
Mr. Amos.
Mr. Amos.
Mr. Arsenault.
Mr. Arsenault.
Mr. Aria.
Mr. Aria.
Mr. Ayoub.
Mr. Ayoub.
Mr. Badaway.
Mr. Badaway.
Mr. Bayless.
Mr. Bayless.
Mr. Boissonneau.
Mr. Boissonneau.
Mr. Bossio.
Mr. Bossio.
Mr. Bertina.
Mr. Bertina.
Mr. Breton.
Mr. Breton.
Mr. Cesar Chauvin.
Mr. Cesar Chauvin.
Mr. Biddle.
Mr. Biddle.
Madame Lapointe.
Madame Lapointe.
Mr. Chen.
Mr. Chen.
Mr. Bruson.
Mr. Bruson.
Mr. Moff.
Mr. Moff.
Ms. Dillon.
Ms. Dillon.
Monsieur Drouin.
Mr. Drouin.
Ms. Zerowitz.
Ms. Zerowitz.
Mr. Assassi.
Mr. Assassi.
Monsieur Khoury.
Monsieur Khoury.
Mr. Ellis.
Mr. Ellis.
Mr. Erskine Smith.
Mr. Erskine Smith.
Mr. Ailson.
Mr. Ailson.
Monsieur Fergus.
Mr. Fergus.
Mr. Finnegan.
Mr. Finnegan.
Mr. Fisher.
Mr. Fisher.
Mr. Fonseca.
Mr. Fonseca.
Mr. Fragascatos.
Mr. Fragascatos.
Mr. Fraser West Nova.
Mr. Fraser West Nova.
Mr. Fuhr.
Mr. Fuhr.
Mr. Gerritsen.
Mr. Gerritsen.
Mr. Graham.
Mr. Graham.
Mr. Greywall.
Mr. Greywall.
Mr. Hardy.
Mr. Hardy.
Mr. Harvey.
Mr. Harvey.
Mr. Housefather.
Mr. Housefather.
Ms. Hutchings.
Ms. Hutchings.
Mr. Yakino.
Mr. Yakino.
Mr. Johari.
Mr. Johari.
Mr. Levitt.
Mr. Levitt.
Mr. Long.
Mr. Long.
Mr. Longfield.
Mr. Longfield.
Ms. Ludwig.
Ms. Ludwig.
Mr. Maloney.
Mr. Maloney.
Monsieur Massé Vignon Métis Matan Metapédia.
Mr. Massé, Avignon, le Métis, Martin, Metapédia.
Mr. May Cambridge.
May Cambridge.
Mr. McDonald.
Mr. McDonald.
Mr. McKinney Coquitlam Porca Quitlam.
Mr. McKinney, Coquitlam, Porco.
Mr. McLeod Northwest Territories.
McLeod, Northwest Territories.
Mr. Morrissey.
Mr. Morrissey.
Madame Nassif.
Madame Nassif.
Mr. Peterson.
Mr. Peterson.
Monsieur Picard.
Monsieur Picard.
Monsieur Rioux.
Monsieur Rioux.
Monsieur Robillard.
Mr. Robillard.
Ms. Rudd.
Ms. Rudd.
Mr. Rumi.
Mr. Rumi.
Mr. Rusnak.
Mr. Rusnak.
Ms. Sahota.
Mr. Hota.
Mr. Saini.
Mr. Saini.
Monsieur Sanson.
Mr. Sanson.
Mr. Senga.
Mr. Sanga.
Mr. Sarai.
Mr. Sarai.
Monsieur Seri.
Mr. Seri.
Madame Shanahan.
Madame Shanahan.
Mr. Sheehan.
Mr. Sheehan.
Mr. Sidhu Mission Mascot Fraser Canyon.
Mr. Sidhu, Mission Masquerade, Fraser Canyon.
Mr. Sidhu Brampton South.
Mr. Sidhu, Brampton South.
Mr. Tabera.
Mr. Tabera.
Mr. Sorbera.
Mr. Sorbera.
Mr. Spengeman.
Mr. Spengeman.
Mr. Tan.
Mr. Tan.
Ms. Vandenbeld.
Vandenberg.
Mr. Whalen.
Mr. Whalen.
Mrs. Zaid.
Mrs. Zaid.
Madame Fortier.
Madame Fortier.
Madame Lambropoulos.
Madame Lambropoulos.
Mr. Hogue.
Mr. Hove.
Mr. Rota.
Mr. Rota.
Mr. Rogers.
Mr. Rogers.
Ms. Yip.
Ms. Yip.
Monsieur Caron.
Mr. Cahill.
Mr. Julian.
Mr. Julian.
Madame Brousseau.
Madame Brousseau.
Mr. Cullen.
Mr. Cullen.
Mr. Angus.
Mr. Angus.
Mr. Massey Windsor West.
Mr. Massey, Windsor West.
Ms. Ashton.
Ms. Ashton.
Ms. Matheson.
Ms. Matheson.
Ms. Duncan Edmonton Strathcona.
Ms. Duncan, Edmonton, Strathcona.
Mr. Christopherson.
Christopherson.
Mr. Garrison.
Mr. Garrison.
Madame Boutin Suite.
Madame Boutin Suite.
Ms. Blaney North Island Powell River.
Ms. Blaney, North Island, Powell River.
Mr. Rankin.
Mr. Rankin.
Monsieur Dubé.
Monsieur Dubé.
Mr. Davies.
Mr. Davies.
Monsieur Boulris.
Mr. Boulris.
Madame Laverdière.
Madame Laverdière.
Monsieur Dussault.
Monsieur Dussault.
Mr. Donnelly.
Mr. Donnelly.
Monsieur Aubin.
Monsieur Aubin.
Monsieur Nantel.
Monsieur Nantel.
Ms. Malcolmson.
Ms. Malcolmson.
Ms. Ramsey.
Ms. Ramsey.
Ms. Kwan.
Ms. Kwan.
Madame Quash.
Madame Quash.
Mr. Blakey.
Mr. Blakey.
Monsieur Choquette.
Monsieur Choquette.
Madame Moore.
Madame Moore.
Mr. Duval.
Mr. Duval.
Mr. Stetsky.
Mr. Stetsky.
Mr. Cannings.
Mr. Canning.
Mr. Johns.
Mr. Johns.
Mr. McGregor.
Mr. McGregor.
Ms. Benson.
Ms. Benson.
Madame Trudel.
Madame Trudel.
Madame Sans Souci.
Madame Sans Souci.
Ms. Hardcastle.
Ms. Hardcastle.
Ms. May Sanderskull Islands.
Ms. May, Sanderskull Islands.
Mr. Tutu.
Mr. Tutu.
Mr. Kung.
Mr. Kung.
Mr. Weir.
Mr. Weir.
Yeas pour 85, 85. Nays contre 211, 211.
Declare the motion defeated. Orders of the day.
Order. I encourage honourable members to take their conversations into the lobbies, and I appreciate their assistance by saying shh. Thank colleagues. I am now prepared to rule on the question of privilege raised on November 1, 2018 by the honourable member for Windsor West concerning the use of alcohol and other substances within the parliamentary precinct. I want to thank the member for Windsor West for having raised the matter. In his intervention, the member alleged that there have been several incidents recently related to the use of alcohol within the parliamentary precinct that were inconsistent with Ontario laws and with keeping Parliament a safe workplace. While acknowledging that some work has already been done, he asked that I, as Speaker, report back to the House on this issue, as well as those he raised with me previously about providing a more holistic and consistent approach to the use of alcohol on the Hill. Comme l'a souligné le député.
As indicated by the member for Windsor West, he asked me in January of this year to address the issue of alcohol on Parliament Hill at the Board of Internal Economy. In response, I referred the member to his House Leader, who is a member of the board. He indicated that some progress was made using this approach. Subsection 52.3 of the Parliament of Canada Act gives the board, not the Speaker, the legal authority to, and I quote, act on all financial and administrative matters respecting the House of Commons, its premises and its staff, and the members of the House of Commons, unquote. Accordingly, the right forum to raise such matters as raised by the member for Windsor West remains the Board of Internal Economy.
Members have a House Leader who can raise issues on their behalf at the board. Speaker Parent reminded us on April 23, 1998, at page 6037 of the debates, that, quote, as a general rule, I, as Speaker of the House, represent the independent members on the Board of Internal Economy, unquote. Members from caucuses not represented on the board and independent members should feel free to approach me at any time on any matter. I am pleased to be their spokesperson if they wish to be heard on this or any other issue. I also encourage them to make their views known to other board members. While I cannot conclude that there is a prima facie question of privilege in this case, this does not mean the subject is not serious. Indeed, it is incumbent on all of us to ensure that Parliament is a healthy and safe workplace for everyone. The special nature of the work performed here should never be used as a shield from this obligation, this priority. I look forward to our continued work on appropriate measures that will allow those who work here today and in the future to do so with ease of mind and a full sense of security. I thank honourable members for their attention. Orders of the day.
Orders of the day, government orders, government bills. Commons, resuming debate at report stage and motions on Group 1 of Bill C-75, an act to amend the Criminal Code, the Youth Criminal Justice Act, and other acts, and to make consequential amendments to other acts.
Je désire informer la Chambre.
I would like to inform the House that because of the vote, hours will be extended by 7 minutes.
Resuming debate, the Honourable Parliamentary Secretary to the Minister of Infrastructure.
Well, thank you, Mr. Speaker, for that introduction, and it's a privilege to rise and speak on Bill C-75, which, of course, represents a package of bold and comprehensive reforms. This is not the first time that I will have spoken on this significant piece of legislation. I did have the opportunity to comment on it previously in my capacity as the predecessing parliamentary secretary to the Minister of Justice and the Attorney General of Canada. I want to begin by expressing my gratitude to a number of people who have contributed to Bill C-75. First, obviously, the Minister of Justice for her leadership, the members of the Standing Committee on Justice and Human Rights for their close study of this bill, and all of the stakeholders and contributors who, through their testimony before the committee, their written submissions, have all provided for a very rigorous and thoughtful study of this bill. And at the end of this process, I'm confident in saying, having had the benefit of reviewing those submissions and some of the testimony and seeing the hard work, contributing to it myself by participating in roundtables around the country, by meeting with stakeholders and consulting with them in conjunction with the Minister of Justice, that Bill C-75 is indeed momentous legislation which, when it will become law, will improve our overall criminal justice system. I also want to thank the thousands of people who work within our criminal justice system day in and day out, law enforcement, police, obviously members of the judiciary, and all the social services which are wrapped around the criminal justice system. Having worked in it myself for over a decade, I can say without any hesitation that these are individuals who care about protecting our community, but also offering the prospect and opportunity for people who find themselves caught within the criminal justice to reform and to rehabilitate, which is, of course, a fundamental principle of the criminal justice system, especially as it relates to our sentencing processes. There is obviously more to do, and the Supreme Court of Canada put into very sharp focus the task that is ahead of us as a result of some of the ongoing challenges which the criminal justice system is confronted with every day. What are those challenges, Mr. Speaker? Well, they range from, obviously, the over-representation of marginalized individuals, in particular members of the racialized community, as well as our Indigenous peoples, who find themselves far too often, for reasons that have nothing at all to do with their fault or blame, but rather as a result of the systemic challenges which they face on an individual basis, as well as the collective challenges that communities face. They find themselves caught into the web of the criminal justice system. And we need to be very candid with ourselves about what those challenges look like. We see overrepresentation of racialized members as well as Indigenous peoples in our jails right across the country. We also know that there is an underrepresentation of those very same groups within the legal profession, within the judiciary, and certainly the work that the Minister of Justice has undertaken in appointing a bench, a judiciary, which is more reflective of the diversity of this great country, I think is in part a sincere effort to address that challenge. And I can say, having spoken with many members right across the continuum of our society, that indeed we have made progress and there is still more work to do. I also would note that the Supreme Court of Canada in Jordan did point out, quite rightly and quite justifiably, that there are serious concerns when it comes to delay, court delay in particular, and that if not addressed, that obviously a denial of the right to have a trial within a reasonable period of time can amount to an infringement of a person's rights under the Charter, in particular under Section 11B of the Charter. And so it was incumbent upon all of us, in the words of the Supreme Court, to address the culture of complacency, which for far too long has shackled our ability to address delay. And now, having had the benefit of reflection and having had the benefit of the consultation and the discourse, obviously in the context of C-75, we now have a suite of reforms which won't solve all of the problems, but certainly will begin to dramatically rewire and hopefully create a criminal justice system, a set of processes which will allow people to have access to justice, have the right to have their day in court, and begin that path to rehabilitation, which is so important in order to create communities which are strong and resilient and safe. So let me just now highlight some of the important components of C-75. much of which has been debated for quite some time now in this House and before committee, and eventually it will make its way over to the other place and then back. But it begins right at the very start of the criminal justice system process when an individual is arrested and is brought before the court for his or her first appearance, and it is at that moment that the court is then asked to determine whether or not that person should be released or detained pending their trial. We have enshrined a principle of restraint in Bill C-75, the point of which is to ensure that justice actors who are appearing in court, either representing the Crown or representing the defense or in their capacity as duty counsel, are not mechanically or automatically overburdening judicial interim release orders with conditions which essentially are a prescription for reoffense and failure. Rather, through this principle of restraint, we're encouraging all of the parties who are involved in the determination of bail to assess what are the conditions which are necessary to address one of the three statutory grounds on which an individual is released. So from the perspective of the primary grounds, is the person a flight risk? What are the conditions that are necessary to secure their ongoing attendance before the court? On the secondary grounds, is there a serious risk of reoffense? What are the conditions that are necessary for the purposes of ensuring that the community's concerns are addressed on secondary grounds, and obviously under the tertiary grounds, whether or not there are additional conditions which are required to maintain the public's confidence in the administration of justice? Again, we look for some nexus between what are the conditions which are being asked for by either party and their advancement of the tertiary ground concerns. So we have, through the principle of restraint, really fostered a much more responsible approach, and I can say that this is about addressing the culture of the criminal justice system right from the get-go once a person is implicated with charges at the bail stage. We've also, in the context of Bill C-75, addressed a suite of packages or introduced a suite of reforms that will hopefully reduce the number of administration of justice offenses which are in the system. And certainly looking at the statistics which are available right across the country, we see that, for example, in the province of Ontario, that over 40% of the charges in the provincial court system, the Ontario Court of Justice, can be classified under the administration of justice offenses. So we are looking to find alternative ways to address potential breaches, one through the principle of restraint, so actually reducing the likelihood that there will be an unnecessary technical charge which is unrelated to the underlying substantive offense, but also to introduce a concept called judicial referral hearings, where even if there is a legitimate breach, to look for other ways to address it short of introducing an entire set of new charges. I would also point out that C-75 addresses intimate partner violence, and this is something that I heard very personally. I know that the minister did as well in our roundtables, and the need to address the systemic barriers which are for far too long have prevented victims from coming forward. How are we doing that? Well, in the case of repeat offenders, people who have been convicted in the past of sexual offenses or offenses related to intimate partner violence, to put the onus on them to determine whether or not they should be entitled to bail, but also to look for additional factors to be taken into consideration at the back end. There are more tools available both to the prosecutor as well as to the court to determine what is the appropriate sentence by lifting the maximum sentences available, again, for repeat offenders. That, coupled with the investments which we're making in the Victims Fund, by looking at other ways in which we can, again, make it easier for victims to be able to come forward, to ensure that they are heard, to ensure that they have a voice in the system, is absolutely crucial in order to ensure that there is access to justice. These are just some of the highlights in Bill C-75. Again, there is no one solution. There is no one simple solution to solving all of the challenges which the criminal justice are confronted, but I rise with great pride to speak on behalf of this bill. I urge all members to support it. At the end of the day, it will bring the criminal justice system into the 21st century and therefore be a great service to our country. Thank you, Mr. Speaker.
Questions and comments? The honourable member for Kitchener-Conestoga.
Well, thank you, Mr. Speaker. My colleague outlined a number of the positive elements of this bill, and certainly on this side of the House, we agree there are some positive elements in it. The intimate partner violence reform certainly is one that we applaud. But, Mr. Speaker, what he neglected to say is that there are many other crimes for which the sentences are being reduced. For example, human trafficking. Mr. Speaker, under the leadership of our former Prime Minister, Stephen Harper, and my colleague, Joyce Smith, we led the fight on human trafficking. The fact that human trafficking of children and young people occurs in this country is unfortunate. It's despicable, Mr. Speaker. And, Mr. Speaker, in the Committee on Justice, when they held hearings on this issue, on human trafficking, they heard former human trafficker Donald. He testified that if the government were to go lenient on the sentencing of convicted human traffickers, it would be like a carte blanche for traffickers to expand this despicable industry and further harm Canadian kids. So I'm wondering if my colleague could indicate, is he in fact in favor of making more lenient sentences for those who would abduct a child, human traffickers in our country, Mr. Speaker?
The Honourable Parliamentary Secretary.
The honourable colleague across the aisle knows better than to ask such a rhetorical question. Of course, no member in the government side of this chamber is in favour of being lenient and turning a blind eye to human trafficking. And in fact, I would point out that under the last Conservative administration, there were broad cuts made to our public safety apparatus to the tune of $750 million, which undermined our ability to bring human traffickers to justice. This government has reversed those cuts, and not only that, we introduced a piece of legislation to provide additional tools to prosecutors to ensure that the appropriate burdens are in place so that we can bring human traffickers to justice. And to that, I would also add, Mr. Speaker, that Bill C-75 is precisely about ensuring that we have access to justice by introducing a suite of procedural reforms, which I addressed in my commentary. So once we get beyond the kind of regrettable rhetoric that we see from the Conservative benches, and in particular the member who just posed that question, we see we have before us a very strong bill. It's based on evidence, it's based on data, and I would encourage my honourable colleague to look at some of that information and vote in support of Bill C-75.
Right on. Questions and comments. The Honourable Member for North Island, Powell River.
Thank you so much, Mr. Speaker, and I thank the member for his interesting speech. You know, in the work that I've done in my writing, I've heard both from the RCMP and from the legal representatives that they're frustrated with dealing with issues that are really better served being dealt with people who provide support and deal with social issues. And so when you look at this bill, again, we see the absolute neglect of actually dealing with the social issues, understanding that not all of these issues need to be in the legal system. We know that that is a system that's already overflowing. There's so many challenges. And in fact, multiple experts said that this is not going to deal with this at all, and it's not going to actually do what it says, which is to make sure that the system is having less people go through it. So I would really appreciate through you, Mr. Speaker, that this member talk about how he can how he would justify, or this government would justify, not addressing those social issues which are clogging up the system every day in our country.
Parliamentary Secretary, the Minister of Infrastructure.
Well, of course, I agree with my honourable colleague that we cannot solve all of the social issues in the context of Bill C-75. And if she'd listened carefully to my remarks, I made that concession at the very outset. But I would point out that certainly the experts that we listened very carefully to, including the Criminal Lawyers Association, while they don't agree with every aspect of Bill C-75, they do indeed support many of the measures as it relates to bail reform and to reducing the systemic barriers which have plagued our system for far too long when it comes to addressing the Indigenous and marginalized and vulnerable individuals who come before the courts at both the bail and at the sentencing phases. But in as much as my honourable colleague is concerned about this government's commitment to addressing the social issues which our country faces, I would point out that we have introduced a national housing strategy which will invest $40 billion over the next 12 years, which will reduce homelessness significantly. Under this government, Mr. Speaker, we've introduced the Canada Child Benefit Plan, which has put more money in the pockets out of 9 out of 10 families and has lifted hundreds of thousands of children out of poverty. Now, by doing that, Mr. Speaker, we'll see fewer of those youth who I work very closely with, caught up in the criminal justice system. That's a result of both the Bill C-75 that is before this House, as well as the social investments which we are making and which we should all be very proud of.
Right on. Resuming debate, the Honourable Member for Langley, Aldergrove.
Well, thank you, Mr. Speaker. A real honor to be in the House speaking on this important justice bill. C-75, sadly, is a deeply flawed 302-page omnibus bill that's been introduced by the government. Are there some positive aspects? Yes. But the way it's been done and rammed through, and not proper dialogue, not proper consideration, and ignoring the opposition members at committee, Mr. Speaker, it's a very serious and concerning process. The previous speaker, when asked about the bill, said it was the Conservative comments were regrettable rhetoric. Well, it's that attitude where they have a majority in the House where they can ram things through and get their way every time, and it appears like an arrogant attitude, Mr. Speaker, where we're dismissing any critique. The government is, and so the Prime Minister continues to show he doesn't take the safety and security of Canadians serious through this bill because he's not listening to positive critique. He's watering down serious offenses such as participating in impaired driving causing bodily harm, using a date rape drug, human trafficking. Mr. Speaker, these are all serious crimes that he's watering down. So, Mr. Speaker, there is 136, I believe, 136 offenses that are included in C-75. And offenses like participating in the activities of a terrorist group. Now, this is one of two amendments that were made at the Justice Committee, coming from the Conservative Party, and the government then permitted their members in committee to accept an amendment on that one, and that was withdrawn. Also advocating for genocide. Now, Mr. Speaker, how did they come up with this list of 136? And why did they only accept to remove two, advocating genocide and participating in a terrorist group? What about the other 134? Well, Mr. Speaker, what they've done is they've taken any offense that is a serious indictable offense with a maximum sentence of 10 years, and they've grouped them into one group, and we have C-75 in front of us. Offenses like prison breach, municipal corruption, influencing a municipal official, influencing or negotiating appointments or deals in offices, obstructing violence against a clergy person, keeping a common body house, punishment for infanticide, concealing the body of a child. So there's these 134 offenses, and do some of them need to be updated? Yes, it needs to be done in a constructive, proper way. Mr. Speaker, the Criminal Code of Canada did not come into place a year ago. It's come through the judicial system, through the legal system, through the legislative system, years and years. Canada celebrated last year its 150th birthday, and over these years, we've learned from other countries to find out what the laws should be in, what is appropriate sentencing, and also respecting the courts and giving the courts discretion. And over these years, Mr. Speaker, we've come up with appropriate sentencing. To review this is a good practice. It should be done. And one of the things I'm quite concerned about, in the last Parliament, we had a major focus on the victims in Canada, and the Victims' Bill of Rights came out, and that was a huge accomplishment. And part of that was a system where there would be a surcharge, a victim surcharge, where an offender would be paying into a victim's fund to take care of victims. Now, that's one of the things in 75 that is now being repealed. It'll be gone, again, taking away opportunities to take care of victims. But, Mr. Speaker, I would like to focus on, in the little time that I have to speak, on impaired driving. Mr. Speaker, impaired driving causing bodily harm, fact is, causing death, is the #1 criminal offense in Canada. There are more people killed every year in Canada by a person driving their vehicle impaired. It's a very serious offense. I have received tens of thousands of petitions, and there's usually not a week that goes by that I'm not honored to present a petition for the Families for Justice. Now, every one of these Families for Justice have lost a loved one. Marquita Cullius lives in my riding. She's a president of Families for Justice. She lost her daughter. Her and Victor lost their beautiful daughter, 21-year-old, and she was killed by a drunk driver. And so they have sent these petitions, and this is what they're asking for in these petitions, that the charge of impaired driving causing death should be called vehicular homicide, that if a person is arrested and convicted of impaired driving, there should be an automatic 1-year driving prohibition. Sounds reasonable. If a person is convicted of causing bodily harm while impaired by being under the influence of either drugs or alcohol, there should be a minimum mandatory sentence of 2 years imprisonment. That's causing bodily harm. If a person is convicted of causing a collision while being impaired by being under the influence, if they're causing a collision and a person is killed, it should be a mandatory minimum sentence of 5 years. Well, this is what we've heard in this House, and this is what we heard in the last Parliament. And so the last Parliament, the government introduced a bill to toughen up and come up with what Families for Justice is asking for a mandatory minimum sentence. It did not include calling it vehicular homicide. It was dealing with the mandatory minimums, getting tough on crime. So, Mr. Speaker, just at the end of the last Parliament, Families for Justice contacted each of the leaders, and the present Prime Minister wrote a letter to Families for Justice and said, yes, he would support getting tough on crime. Now, sadly, what we see in C-75, which we're debating right now, this is what they will be removing: impaired driving causing bodily harm, failing to provide a bodily sample, blood alcohol over the limit. Mr. Speaker, they're going to take this out of indictable offenses and make it a hybrid offense. In actuality, what this will do is it will take it out of, at the choice of the prosecution, it will take it out of federal court and put it, because it could be a summary conviction, it will put it into the provincial. It's the federal government downloading onto provincial courts. And in British Columbia, I've been regularly shocked to see that court cases are thrown out of court by judges because it's gone on too long. People have had to wait. And then you end up with the federal government downloading all of these indictable cases and passing them on to the provincial court. This will exasperate provincial justice, the criminal code being enforced by making serious offenses like kidnapping, abducting a person under the age of 14. Why would somebody that would abduct a child be now made from an indictable serious offense, 10-year maximum, now making it available to be a summary conviction? 2 years less a day, into the provincial courts. This is a government that says one thing, Mr. Speaker, and does something totally different. They told Marquita Cullius and Families for Justice and other Canadians, they promised they were going to get tough. Fact is, Mr. Speaker, we hear regularly they're getting tough on impaired driving, but in fact, they do nothing like that. What they say and what they do are two totally different things. It brings to mind the proverb, a tree is known by its fruit. If there are apples on the branches of that tree, it's an apple tree. If there are pears on it, it's a pear tree. If it's a tree where what they say and what they do, if it's a tree of deceit, the country groans. Canadians want justice, Mr. Speaker. They want a government that when they make legislative changes, they spend the time and do it right and not rush it through, not ram it through because they have the ability to do it. So, Mr. Speaker, I hope the government will ask some good questions, some important questions, because the way they're handling C-75, I've got a lot of phone calls, a lot of emails, and I do get regular input from my constituents. But C-75, I'm sure every one of us are getting the same kind of phone calls saying, vote against C-75. So that's what I plan to do.
Questions and comments? The Honourable Parliamentary Secretary to the Minister of Justice.
So I thank the member opposite for his contribution to today's debate. And I would just, by way of a comment, just indicate to him that federal, provincial, territorial conferences have been held about this very issue, about responding to the Jordan decision, which was rendered 2 years ago. There have also been extensive consultations, both in person and online, around the country in terms of hearing from Canadians. So ramming this through is probably a bit of a mischaracterization of this bill. That's the comment. In terms of the question, what I would put to my friend opposite is the very specific way we are responding to the problem of domestic violence by categorizing it as intimate partner violence, by expanding the definition of who an intimate partner can be, including a dating partner and a non-married spouse, and also ensuring that the penalties for intimate partner violence are increased. I know the member opposite and many of his colleagues care deeply about victims' rights. In the case of victims of domestic violence, we absolutely abide by that and hear those kinds of criticisms. So could the member comment on whether he approves of our changes to the intimate partner violence provisions and the increased penalties for people guilty of that kind of domestic violence?
Honourable Member for Langley Aldergrove.
Mr. Speaker, consultation is listening and taking it into consideration and learning from one another. Just having meetings with the provincial, people within our provincial director, Mr. Speaker, is not proper consultation. The provinces in this great country of Canada, I believe, did not, and I wasn't part of those consultations, but I believe strongly that the provinces did not say, make impaired driving softer. Just like they've told Canadians, they've told us, Mr. Speaker, and I believe that they've told those provincial bodies that they're going to toughen up impaired driving laws, but in fact, with 75, they're making them weaker. Those provincial consultations did not say it's okay to bypass abducting a child, Mr. Speaker. They did not say it's okay to participate in criminal organizations, Mr. Speaker. So the government has blown it on C-75.
Questions and comments? The Honourable Parliamentary Secretary to the Government House Leader.
Yes, thank you. Mr. Speaker, the member across the way talked about the kidnapping, and it's somewhat disturbing in the sense that the Conservatives don't seem to recognize there is a bit of a difference. Imagine, if you will, Mr. Speaker, an individual going through a divorce custody, and one parent assumes custody. Now, the child is very disgruntled, very upset, maybe with the parent that has custody one day and decides to go over to the other parent's house. A day later, there is allegations of kidnapping. There is a big difference between that sort of a kidnapping versus a kidnapping where someone is apprehended from a schoolyard and taken and literally used for a sex trade or possibly murdered or something of that nature. Would the member across the way not acknowledge the difference between the two kidnap types?
Member for Langley Aldergrove.
Mr. Speaker, I would acknowledge that Mr. Speaker, I'm not sure if the member is going to allow me to speak now. Thank you very much. Mr. Speaker, there is a big difference, and that's why the courts need to have discretion. But what we're hearing is from a government that is saying participation in the activity of a terrorist group or advocating genocide is also within that same grouping of legislation, C-75. They accepted amendments of those two to remove those, but everything else had to stay. Because they're closed-minded, they would not accept consultation from Canadians, Mr. Speaker. So C-75 has a lot of problems with it, and that's why Canadians do not want us to vote for it. Thank you.
La députée de Longueuil.
The Honourable Member for Longueuil, Saint-Hubert. Well, thank you, Mr. Speaker, and I'd like to thank my colleague for his remarks. We don't always agree, the Conservatives and the NDP, but we could undoubtedly agree that it's deplorable to see that we still don't have judges appointed. They are so important in dealing with the delays in the justice system. And I'd like to ask my colleague if he doesn't find it deplorable that the government now because we're 1 year out from the elections and we know that everything done between now and then will be with a view to getting them reelected. Since over the past 3 years, when we look at the legislative agenda, it's quite thin. They haven't changed very much. And in addition, when we do something and when people wait for it, like a bill like this, we botch it. What does the honourable member think about that?
For Langley Aldergrove.
Mr. Speaker, I want to thank the member for his question, and he brings up a very good point. When the Justice Minister had the responsibility for making appointments for judges, 6 months went by before there was any appointments. This created a backlog, and now with C-75 legislation and offences being downloaded onto the provincial government, an additional backlog. So what they've done is they're creating a mess, a judicial mess, a legislative mess, and they've accomplished very little in this House. And now they want to ram through 75 because they have the most bodies in the House. Mr. Speaker, these are important issues that need to be handled properly, and they're not being handled properly by this government.
Resuming debate, the Honourable Parliamentary Secretary to the Minister of International Development.
Thank you, Mr. Speaker. Mr. Speaker, I'm proud to speak on this bill, Bill C-75, Mr. Speaker. And through this bill, our government is fulfilling its promise to move forward with a comprehensive criminal justice reform. And once passed, this legislation will have a real effect on court delays. It will help reduce the overrepresentation of Indigenous people and other marginalized groups in the criminal justice system, including those with mental health and addiction issues. It will also help to make our juries more representatives of our communities that they serve. And I do want to take this opportunity, Mr. Speaker, to thank, of course, our Minister of Justice and, of course, all members of the Standing Committee of Justice for all the hard work that they've done to make sure that we get this bill right. Mr. Speaker, I will focus, though, my remarks on amendments to the Criminal Code that removes provisions declared unconstitutional, primarily by the Supreme Court of Canada, and are therefore already of no longer force or effect, but continue to appear in the Code. Mr. Speaker, Bill C-75 will repeal the offences of anal intercourse, vagrancy, spread false news, procuring a miscarriage, and bawdy house offences. This bill would also remove provisions relating to other offence of murder, as well as provisions that prevented judges from giving enhanced credit for time served in custody prior to sentencing. Mr. Speaker, Bill C-75 proposes to repeal Section 230 of the Criminal Code, which was struck down by the Supreme Court of Canada in R versus Martineau in 1990 because it infringed on Section 7, which is the right of life, liberty, and security of person, and 11D, which is the persecution of innocence of the Charter. Section 230, Mr. Speaker, could result in a murder conviction if the accused caused the death of a person while committing another offence, like robbery, even if they did not intend to kill the victim. The court made clear that the label of murderer and the mandatory life sentence was reserved those who have the intent to kill or injure so severely that they know the victim could die. The Martineau decision also found part of paragraph 229, section C, unconstitutional because it allowed a conviction for murder where a person in pursuing an illegal activity causes someone's death where they should have known, but did not, that death was likely an outcome of their action. Mr. Speaker, Bill C-75 proposes to remove this unconstitutional provision. The continued presence of these invalid provisions in the Criminal Code can cause delays, inefficiencies, and injustice to the accused. Bill C-75's proposed amendments would make it clear that to a convicted of murder and an accused must have foreseen the death of the victim. Mr. Speaker, Bill C-75 would also repeal the prohibition against anal intercourse. It has been declared unconstitutional by several courts because it discriminates on the basis of age, marital status, and sexual orientation. Bill C-75 would also repeal Section 181, which prohibits the spreading of false news. This offence dates back to the 13th century England and targeted conduct meant to sow discord between the population and the king. The Supreme Court struck down this provision in R versus Zundel in 1992 because it unjustifiably violates freedom of expression and lacks a clear and important societal objective that could justify its broad scope. Mr. Speaker, Bill C-75, and as it proposes to repeal this unenforceable offence, some might wonder whether this leaves a gap in the criminal law, including the ability to target false news in some way. And these questions, Mr. Speaker, are quite relevant today in the light of fake news discourse and the concerns of such fake news to promote hate against particular groups. In this respect, Mr. Speaker, it is worth noting that the Criminal Code already contains a robust set of hate propaganda offences and other hate crime-related provisions, including, for example, the public incitement of hatred offences found in Section 319. Now, Mr. Speaker, Bill C-75 would also repeal the abortion offence at Section 287 of the Criminal Code, which prohibits the procurement of a miscarriage and was declared unconstitutional by the Supreme Court 30 years ago in the Morton-Taylor case. And the Supreme Court's guidance was clear, Mr. Speaker. It said forcing a woman by a threat of criminal sanction to carry a fetus to term unless she meets a certain criteria unrelated to her own priorities and aspirations is a profound interference with a woman's bodies and thus a violation of her security of the person, Mr. Speaker. It is long overdue that this invalid provision be removed from our criminal code. Mr. Speaker, additional amendments to modernize the criminal law were adopted by the Standing Committee on Justice and Human Rights. And of course, once again, I want to take this opportunity to thank the committee for their work, and I would like to take a moment to discuss this as well. Mr. Speaker, as tabled, Bill C-75 repealed part of the vagrancy offence. The prohibition against loitering near a school ground, playground, or public park for persons convicted of certain offences, paragraph 179, 1B. This provision was struck down by the Supreme Court of Canada in R versus Haywood in 1994 because it was overly broad and implying that too many places to too many people and indefinitely without possibility of review. The Justice Committee went further and adopted a motion to repeal the vagrancy offence, committed by supporting oneself by gaming or crime and having no lawful provision or calling found in paragraph 179A, subsection A. Modern Canadian criminal law is not concerned with the status of an individual, such as unemployed, but rather and rightly focuses on morally blameworthy conduct, Mr. Speaker. The Justice Committee also heard that this offence was used in a historically discriminatory fashion to target members of a particular communities, and I'm pleased that the committee agreed to remove this offence in its entirety, and I'm confident that it leaves no gap in the law. Mr. Speaker, the Justice Committee also unanimously adopted an amendment that repeals the body house offences at sections 210 and 211 of the Criminal Code. This amendment responds to the concerns of these provisions are antiquated, also have been used discriminatory against LGBTQ community, and no longer serve a legitimate criminal law purpose. Their net effect is to criminalize anyone who has any kind of association with a body house. This is inconsistent with the modern criminal law, which criminalizes blameworthy conduct, not location in which certain activities take place, nor a person's status in respect to such location. The repeal of the body house offences would also leave no gap in the law as discussed by the committee during its consideration of this issue. Mr. Speaker, we have a responsibility as parliamentarians to ensure that our laws is as clear as possible to all Canadians, not just criminal law experts who can weave the criminal code together with the jurisprudence to better understand the true state of the law. Clarity contributes to accessibility. This is particularly important to criminal law, given its significant impact on an individual's liberty and on public safety. Lack of clarity with the law also results in costs, Mr. Speaker. Aside from tangible costs on the justice system, such as wasted police, prosecution, and court resources, there are risks of injustice to the accused and intangible costs to victims, Mr. Speaker. Moreover, Mr. Speaker, the reliance on unconstitutional laws has a negative impact on the reputation of the criminal justice system and affects Canadians' confidence in that system. Mr. Speaker, these amendments promote clarity in the law and respect for the Charter and should be without any controversies. These changes are consistent with the objectives of other amendments contained in Bill C-75 in the way they will make our system more efficient and more accessible. And, Mr. Speaker, I urge all members of this House to vote in favour of this motion. And once again, I want to take this opportunity to thank the Minister for all the consultations that she's done, with many members of our society, as well as the Justice Committee for all the work that they've done. So thank you very much, Mr. Speaker.
Questions and comments. The honourable member for St. Albert, Edmonton.
Thank you, Mr. Speaker. And I would like to ask the Parliamentary Secretary a question in regards to sections of the Criminal Code that have been deemed unconstitutional and are therefore of no force or effect. I was astounded that she would pat the government on the back for moving forward in this bill with the rightful removal of those sections, when it was all the way back in the fall of 2016 when Travis Vader was acquitted of the second-degree murder charges, or those charges were thrown out of court because the trial judge applied Section 230 of the Criminal Code. The member made reference to the Martineau decision. Following that, the McCann family, who come from my community of St. Albert, Brett McCann, her son, and his wife Marianne, and I pleaded for the minister to introduce legislation. The member for Mount Royal, the chair of the Justice Committee, wrote to the minister to urge her to introduce legislation. She introduced legislation, to her credit, on March 8th of 2017 in Bill C-39. Do you know what happened to Bill C-39? It has been stuck at first reading when we could have gotten it done by way of unanimous consent. Why did the government delay almost 2 years before moving forward finally in Bill C-75? It's too little, too late for the McCann family.
Honourable Parliamentary Secretary to the Minister of International Development.
Thank you, Mr. Speaker. Mr. Speaker, I'm proud of the work that our government has done to introduce this piece of legislation, Mr. Speaker. Mr. Speaker, our government has introduced this legislation to modernize the criminal justice system and reduce court delays. The proposed reforms are a key component of a federal strategy to transform the criminal justice system and to make it more efficient, to make it more effective, to make it more fair, Mr. Speaker, and accessible while protecting public safety, Mr. Speaker. They also aim to reduce overrepresentation of Indigenous persons and vulnerable populations in the criminal court system, Mr. Speaker. And many of these laws reforms reflect a collaborative intergovernmental office to address court delays and have been identified by the federal as priorities by the federal, provincial, and the territorial justice ministers. Thank you, Mr. Speaker.
The Honourable Member for Longueuil Saint-Hubert. Thank you, Mr. Speaker. I do appreciate all my colleagues' passion, and if I were in her place, I would want to believe this too. I would want to believe what my colleagues have told me, what my minister has told me. But she could she tell me if she will at least have the opportunity to see whether or not this government's legislative agenda is quite small compared to the previous government at the same date. And then all of a sudden, you come in with this huge bill, you listen to all kinds of experts who say that Bill C-75 isn't enough.
The Honourable Secretary of Parliament.
Honourable Parliamentary Secretary.
Mr. Speaker, I appreciate the honourable member's question, but this is a very comprehensive piece of legislation, and it was done in consultation with many key stakeholders, Mr. Speaker. And Mr. Speaker, as we've said all along, there is no simple solution to address the issue of court delays. We already are doing a part of a collaboration with the provincial and territorial partners, Mr. Speaker. But this legislation and all the actions to date are aimed to address the root causes of delays, Mr. Speaker. This bill will intend to bring more cultural shift within the criminal justice system, something that the Supreme Court in their Jordan decision have stressed is required, Mr. Speaker. Once again, I thank the Standing Committee on Justice and Human Rights for their extensive study on Bill C-75 and amendments that they have proposed, and we believe that these amendments help strengthen Bill C-75. And I hope that all members of this House.
Time for one more short question and response. The honourable member for Sarnia-Lambton.
Thank you, Mr. Speaker. And I'm sure that the member opposite, in her role in international affairs, has encountered countries where forced marriage exists. But I'm astounded that a government could, here in Canada, allow forced marriage in this bill, because essentially what that means is someone is forced to have sex again and again with someone they didn't consent to. And how can a government that claims to be a feminist government and a defender of women's rights think that that penalty should be a summary conviction of less than 2 years or a fine?
Honourable Parliament Secretary, the Minister of International Development.
Mr. Speaker, that's just absurd from what I just heard from my honourable colleague. And again, Mr. Speaker, with Bill C-75, we are advocating for bold reforms that will address court delays in our criminal justice system. And nothing in this bill, Mr. Speaker, will not change the fundamental principles of sentencing. Our court will continue to impose sentences that are, proportionate to the gravity of the offence and the degree of the responsibility of the offendant. And I would appreciate if the honourable member would let me speak when he could have. Thank you, Mr. Speaker.
Resuming debate, the honourable member for Humber River, Black Creek.
Thank you very much, Mr. Speaker. And I, as my colleagues, am very pleased today to join this debate on Bill C-75, introduced on March 28, 2018. This bill has now been studied by the Justice and Human Rights Committee and returned to the House. And I am optimistic that we can move this important piece of legislation forward today. Bill C-75 includes important amendments which reflect the government's unwavering commitment to tackling gender-based violence. Last June, the government launched a federal strategy to prevent and address gender-based violence across Canada. The 2017 budget included $100.9 million over 5 years, and an additional $20.7 million per year thereafter to fund this important strategy, which will ensure more support for vulnerable populations such as women and girls, Indigenous people, LGBTQ2 community members, gender non-binary individuals, those living in rural and remote communities, and people with disabilities, amongst many others. Budget 2018 announced a further $86 million over 5 years and $20 million per year ongoing to enhance this strategy. The 3 pillars of the strategy, prevention, support for survivors and their families, and promotion of a responsive legal justice system, will better align these and existing resources to ensure that current gaps in support are filled. Bill C-75 complements these initiatives and further supports the 3rd pillar of the federal gender-based violence strategy by promoting a more responsive legal and justice system. It specifically targets intimate partner violence, which is one of the most common forms of gender-based violence. Intimate partner violence includes things like sexual, physical, and psychological abuse, as well as controlling behaviors. Bill C-75 proposes to define intimate partner throughout the criminal code to clarify that includes a current or former spouse, common law partner, and a dating partner. This clarification is sorely needed to reflect the current reality, which is that so many of the individuals accused of violence against women before the courts are in fact dating partners, as opposed to spouses. According to data from Statistics Canada, victimization by an intimate partner was the most common form of police-reported violent crime against women in 2016. We also know that based on police-reported data from 2016, violence within dating relationships was more common than violence within spousal relationships. The new definition of intimate partner violence would apply in the sentencing context, where judges would have to consider any evidence of abuse against a former or current spouse, a common law partner, and a dating partner as an aggravating factor. Higher maximum penalties for repeat intimate violence offenders would also be available to sentencing judges under this legislation. In addition to the reverse onus on bail, Bill C-75 would add 2 new factors that a judge would have to consider before making an order to release or detain an accused. Bail courts would have to consider an accused criminal record, something that already routinely occurs but it is not mandated, as well as whether the accused has ever been charged with an offense that involved violence against an intimate partner. These factors would ensure that judges have a more complete picture and are fully informed of any prior history of violence that could threaten the safety of a victim or the public at large. In 2016, Statistics Canada reported that the type of violence most often experienced by victims of intimate partner violence was physical force, which includes more serious harm such as choking. The reforms proposed in Bill C-75 would further enhance victim safety by clarifying that strangulation, choking, and suffocation constitute a more serious form of assault under Section 267 of the Criminal Code, punishable by a maximum of 10 years imprisonment, instead of a simple assault which carries a maximum penalty of 5 years. It would also ensure that sexual offending involving strangulation, choking, or suffocation is treated as the more serious form of sexual assault that imposes a maximum penalty of 14 years. Imprisonment if the victim is an adult, and life if the victim is a child, under Section 272 of the Criminal Code. This would depart from the existing penalty for simple sexual assault, which is a maximum of 10 years imprisonment under Section 271, or 14 years where the victim is under 16. Unfortunately, under existing law, courts do not always recognize the seriousness of these types of assaults, which often can occur in the context of intimate partner violence. These aggressive acts cannot be underappreciated or dismissed as simply reflecting a perpetrator's anger management problem. Strangulation and choking pose a much higher risk to safety than other forms of assault because they deprive a person of oxygen, which potentially fatal consequences. Despite that, they may not have any visible injuries. The proposed amendment would better reflect the gravity of the harm inflicted. While strong laws are a necessary part of tackling gender-based violence, it is important to understand how this legislation complements existing programs and initiatives, which together ensure that the justice system is working at its full potential. Over the last couple of years, the government has been working closely with the provinces and territories to improve the criminal justice system's response to gender-based violence. For example, since 2016, the government has provided funding for projects designed to improve responses to sexual assaults against adults. This funding has been made available through the Federal Victims Fund to provinces and territories, municipal governments, First Nations, criminal justice, and non-governmental organizations. The funding is supporting pilot projects in Saskatchewan, Nova Scotia, and Newfoundland and Labrador to provide independent legal advice to victims of sexual assault, and the Government of Ontario to further enhance their existing project. Alberta has developed a similar program that is being administered and funded through the Provincial Ministry of the Status of Women. Strong criminal justice responses to gender-based violence, including measures that aim to enhance access to justice for victims, as well as proposals in Bill C-75, are especially significant right now in the wake of the Me Too movement, and as so many sexual assault survivors are coming forward to acknowledge and share their experiences of sexual violence. Indeed, a November 9, 2018 report from Stats Canada indicates that the number of police-reported sexual assaults sharply increased by 25% following the beginning of the Me Too movement in October 2017. The harrowing accounts shared by survivors have shed light on the many social and economic barriers that sexual assault victims have had to face and continue to face, with devastating consequences for individuals, their families, and their communities. As more stories of sexual assault are told, we must ensure that the victims and the survivors are treated with compassion and respect, and that the criminal justice system responds appropriately. Mr. Speaker, I firmly believe that the proposals to enhance the safety of victims of intimate partner violence in Bill C-75 are a necessary response to this horrific social problem. I am proud that I'm part of a government that takes violence against women, as I know all of us in the House do, and that remains unwavering in its commitment to ensuring that victims of gender-based violence and their loved ones are treated with the utmost of respect and dignity. I hope you will join me in supporting this bill, Mr. Speaker.
Questions and comments. Question commentaire. The honourable member for Peace River Westlock.
Thank you, Mr. Speaker, and I'd like to thank my honourable colleague for her speech there. One of the things that I find very interesting about this current bill is section clause 106, clause 107 has to do with people who participate in human trafficking. Section clause 106 talks about material benefit, and clause 107 talks about destroying documents. Clause 389 also talks about removing consecutive sentencing for those that participate in human trafficking. Now, I listened to the member's speech, and she talked much about the violence against women. Mr. Speaker, human trafficking is a terrible thing that happens right here in Canada, often 10 blocks from where you live. I'm just wondering how the member can square what she said in her speech with the actual results of this bill, where it's reducing the sentencing for human traffickers. It's reducing, in some cases, you will, if you participate in human trafficking, you will only end up with a fine. Thank you, Mr. Speaker.
Honourable member for Humber River Black Creek.
Let me say to my honourable colleague, I appreciate his interest. The issues of human trafficking are issues that many of us in the House and elsewhere are very well aware of what goes on out there in this terrible world when it comes to trafficking in human beings, and whether it's on our local streets or being trafficked elsewhere. Some of the work that I have done on prostitution and trafficking some years back as a city councillor, and it was all about how do we help people better and what can we do for them. And I have to say that I think all of us, our full intent is to make sure that the laws of the land are there to protect people and to help those victims who find themselves in the terrible position of being trafficked or being used for sexual exploitation.
Questions and comments. The honourable member for Humber River Black Creek.
Thank you, Mr. Speaker. I thank the member for the speech. I just want to say there's a quote from Elizabeth, sorry if I apologize, say this wrong, she and Isabel Grant from the Toronto Star in an article that was called Bill C-75 Reforms Too Little, Too Late. In it, they said, a woman is killed by her current or former partner every 6 days in Canada. Indigenous women are killed by their intimate partners at a rate of 8 times higher. Domestic violence is a national crisis. The federal government's Bill C-75, introduced last month, proposes changes to the criminal law response to domestic violence. But the bill will do too little, too late. What we need is a comprehensive, integrated strategy to prevent and respond to domestic violence and resources to support women extracting themselves from violent relationships. So, Mr. Speaker, through you, my question simply is this. We know that women's organizations that address issues of domestic violence have been coming again and again, begging for money that they desperately need to help these women prevent these kind of situations. And we know that this government is absolutely not providing the support they desperately need. So if this bill is so great, I just want to know what will be the follow-up to make sure that these women are supported so that they can begin to have trust in the justice system of Canada.
My apologies to the member for North Island Powell River, and now we'll direct her question and comment to the honourable member for Humber River Black Creek.
Thank you, Mr. Speaker. I kind of thought that was a bit off here, and I knew you would have that corrected. I think we all share the major concerns to see Bill C-75 is going to improve the safety of women and others throughout this country. Much of the new department on the status of women will be having additional funding in that category so that we can be supporting initiatives that will help women get out of difficult relationships. But also part of all of this as we go forward, and I think the Me Too movement has had a huge impact. The fact is you're not going to get away with abusing anybody, whether it's man, woman, or child. And society for far too long has stayed too quiet on many of these fronts. And I think we've got to really push on the whole issue of education, and I know that our government will continue to invest very significantly so that education becomes a big part of all of this. There is no one should be allowed to raise a hand to anybody, man, woman, or child.
Resuming debate, the honourable member for Peace River Westlock.
Thank you, Mr. Speaker.
Well, these are just
Mr. Speaker, I'm going to just parlay a little bit off of what my honourable colleague before me had to say. It was very interesting that you very much went around the concept of standing up for violence against women. This particular bill is, again, one of these things where the Liberals say that they're trying to do one particular thing and then go off and do something completely different. When this bill was introduced, the minister said that this was going to improve efficiency in the criminal justice system and reduce court delays. Then they just seemed to water down a whole bunch of crime, a whole bunch of sentences in order to reduce backlogs in the court. And also they wanted to improve and streamline bail hearings. Now, their goals that they've stated off the top, Mr. Speaker, are laudable, and I think that everybody in this place has those goals. As when we come here, we want to make the justice system work better. That's something that I think everybody that comes to this place can agree on. How we get there is always where we disagree. Now, if C-75 actually accomplished some of these things, we would be definitely on the right track. Mr. Speaker, one of the things is, as Conservatives, we always look at the justice system from the point of the victim. That's really what this is. And it seems to me that the Liberals always want to look at it from the point of the perpetrator. Now, my first concern with this bill is that it's an omnibus bill. It's a mashup of various other policies, and we could see over the progression of the time that I've been here, bills have been introduced and they keep get it added on into, I think it was C-36 has been put in here, and there's been a number of other bills that have been lumped in with this bill. So we've seen the progression of that, and now it's this monstrosity of a bill that's fairly unmanageable. And like my colleague from St. Albert Edmonton pointed out earlier, is that we had the opportunity to fix a number of these things earlier on, but the government has dithered on some of these. There is a couple of things that I would just like off the top. A lot of people always said, Arnold, you're always criticizing the government. Could you just point out every now and then when they do something good? So there is some good pieces that are in here. When C-75 brings in, it increases the maximum term for repeat offenders involved in intimate partner violence, and it provides that the abuse of an intimate partner is an aggravating factor in sentencing. Totally supportive of that. I'm also supportive of the reverse onus bail in cases of domestic assault. I indeed myself have written letters to the Justice Minister on this particular thing as well, so I'm supportive of that. Women who have been violently assaulted by their spouses should have the confidence in a justice system that will protect their safety, or protect their interests and put their safety first. Another important element of C-75 is the act of strangulation is made to be a more serious level of assault. Totally fine with that as well. Now, there's a number of areas that I have concern with this bill around, particularly around the way that this bill treats human trafficking, Mr. Speaker. With such significant changes, you'd expect that the government would consult widely, particularly I've been working over the last number of years with a lot of groups that are concerned about human trafficking happening right here in Canada. And so we've suggested that these folks contact the Justice Committee and try to be a witness at the Justice Committee. Now, the Justice Committee heard from 95 witnesses on C-75, but when we looked, over 70% of the witnesses at the Justice Committee were justice system lawyers, which totally makes sense. If this bill was about streamlining the justice system, you would want lawyers to show up. But this bill wasn't about that predominantly. Predominantly, it was about lowering sentences for a whole raft of different offenses. And so when we're dealing with a bill that's lowering sentences for a whole bunch of, or hybridizing, I think that's the term that gets used, hybridizing these offenses, certainly we should hear from some of the groups that represent the victims of some of these offenses. But however, Mr. Speaker, we did not hear from them at all. We know that the groups that came to committee was just over 10% of them. And when it came to law enforcement, you'd think, well, law enforcement, they're the people that have to enforce these laws. They're the ones that are using the criminal code to charge people. Perhaps we should hear from them as well. You know how many police officers they heard from at this committee, Mr. Speaker? One. Oh, one out of 95. One police officer showed up, and so, or was asked to come. And so that was also kind of disturbing, because particularly across this country, I know just from my limited experience of traveling across the country, the issues that are faced up in northern Alberta and up in the Peace Country are quite a bit different than the issues that are faced in downtown Toronto, and are quite a bit different than the issues faced in Halifax and then Vancouver and across the territories. So to hear from one police officer on how this bill is going to affect their job seems to me to be limited, particularly when this deals with a whole bunch of different areas that the police work in. The police work every day to keep us safe, and they rely on Parliament to make sure that they have laws of which they can use. It seems to me that we should have heard particularly from victims, but also from the police officers. And to have, out of 95 witnesses, only one of them be a police officer seems a little bit interesting, Mr. Speaker. As I mentioned earlier, C-75 makes significant changes to some of our human trafficking offenses, changing them from indictable to these hybrid offenses. As legislators, we are about to vote on these changes shortly. This is important that we make informed decisions. Are these amendments going to be useful for police officers fighting human trafficking? We don't know, because we only heard from one police officer, and he wasn't able to address specifically the human trafficking aspect of it. But what we do know, Mr. Speaker, is at committee, not a single organization that works to fight human trafficking from across the country was consulted on these changes. In fact, many of these human trafficking units across the country have no idea that these changes were even coming into effect, which could be a problem in the fact that the police are investigating crimes as we speak, and to now have pieces of the criminal code being reduced or disappearing may be a problem for them. I'd also urge my colleagues in the Senate to ensure that there's better representation for victim and law enforcement during the Senate hearings on Bill C-75, as we know that this will be going to the Senate quickly, as we just this morning were voting on the closure bill, motion for this particular bill. One of the other areas, Clause 106 of this bill, changes the material benefit from trafficking offense, and also the destroying of documents trafficking offense. These offenses will be changed from indictable to hybrid offenses. So, Mr. Speaker, the chair of the Justice Committee was in here, and I have debated him before on this, and he said, well, Arnold, you know, the thing is that we need to ensure that there's a leeway within the law. And I agree with him. And he had the example of assault. He said there's a great variance in assault, from like minor fisticuffs in the parking lot to actually somebody being left for dead. So he says we need to be able to have variance in the law for that, from being able to issue a fine. But my point to him on these particular sections is material benefit from human trafficking. There should be a minimum. Could he explain to me could you give me an example of which there would be like a fairly minor human trafficking occasion? That seemed to me to be ridiculous. Like, modern-day slavery, Mr. Speaker, is an affront to humanity, of which there ought to be a minimum sentence of more than just a fine. And I think that all of us standing in this place would agree on that. And I don't care if you were the nicest slave owner on the planet, Mr. Speaker, it's still slavery, and there ought to be a minimum sentence for that, not just merely a fine. And so that I was very frustrated with that. And the other thing is that this will be downloaded to the provincial court. We know that the vast majority of human trafficking victims in this country are female. The vast majority of them are very young, and about half of them, Mr. Speaker, are Indigenous. And so we need to ensure that the human trafficking, the risks of getting caught for human trafficking outweigh the ability to make money of it. The Justice Committee heard in the past on a different study that human traffickers make between $1,500 and $2,000 a day off a trafficked individual. And under Bill C-75, the trafficker could face a maximum of a $5,000 fine. So a trafficker trafficking a young person in this country could make up to $300,000 a year. A $5,000 fine, Mr. Speaker, that's ridiculous. That'll just be a cost of doing business for that particular individual. The other thing is that this takes away the consecutive sentencing for human trafficking. Mr. Speaker, victims of human trafficking are afraid to come forward because they're afraid that when they come forward, it's just a short matter of a short amount of time, and their pimp will be back out on the street hunting them down. Thank you, Mr. Speaker.
Good job. Questions and comments. The Honourable Parliamentary Secretary to the Minister of Justice.
Thank you, and I thank the member from Peace River Westlock for his contribution to today's debate and for his ongoing concerns about human trafficking. It's an incredibly serious issue, and I thank him for raising it in this chamber on repeated occasions. I would highlight one comment and one question, Mr. Speaker. The comment would be that human trafficking was studied extensively by the Standing Committee itself prior to receiving Bill C-75. And in order to actually address some of the very important witnesses and stakeholders that the member has highlighted, the committee actually traveled right across this country to hear from those important witnesses and those important stakeholders. The committee has yet to table its report, but when they do, I hope that we will receive it and study their recommendations carefully. What I would add and the question that I would have for the member is that he and a number of his colleagues have consistently underscored the point about being tough on victims' rights and being tough on sentencing to address victims' rights. What I would say to him is that we agree, and I'm glad he agrees with the intimate partner violence provisions. But what I put to him is that is it a step in the right direction to be taking the standard sentence for summary conviction of offences from 6 months to 2 years less a day? Does that address the needs of the victims that he represents in Peace River Westlock?
Member for Peace River Westlock.
Well, Mr. Speaker, taking it from 6 months to 2 years minus a day, that's not the dispute. The dispute here is about the fact that they're taking something that could be a maximum sentence of 10 years and reducing it to possibly just a fine. That is where the dispute is. And the other thing that comes in when it comes to consecutive sentencing, Mr. Speaker, consecutive sentencing is if a trafficker is trafficking one girl, or if he's trafficking 10 girls, he's going to jail for either 10 years or he's going to jail for 100 years. That makes quite a bit of difference, and particularly when, in most cases, it's not just one individual who's being trafficked. It makes a difference so that the person who is being trafficked has the confidence that they will be put away for a significant amount of time so that they can get their life back in order, so that that particular person will not be coming back to where they lived, hunting them down and putting them back to work. Thank you, Mr. Speaker.
The Honourable Member for Longueuil-Saint-Hubert. Thank you, Mr. Speaker. I'd like to first of all thank my colleague for his speech. And it seems to me that he and others in the opposition, along with us, often want to underscore how disappointing the legislative agenda of the government is disappointing. Now, there are truly great problems in Canada that have to be addressed, but this is completely inadequate with respect to the United Nations. The Criminal Lawyers Association said that unfortunately that there is assault and legislation on assault between intimate partners. that an increase in the sentence could lead to increased sentencing and overrepresentation of Indigenous persons. I'd like him to give me a concrete example of this and not just spin.
River Westlock.
I'm not sure what the point that my colleague was trying to make there exactly, but what I can talk to, he talked about the legislative agenda to some degree, and one of the things that I can talk about there is one of his former colleagues, an NDP member named Maria Morani, introduced a bill over 5 years ago. That bill was passed in a previous parliament and was to come into force. The Liberals said that they were going to bring it into force. That's 5 years ago. It's finally being addressed in this particular bill. While not all of the components of her bill are being, that was Bill C-4452. While most of the tools that were in that bill were coming in, the Liberals have removed consecutive sentencing out of this bill. I think to some degree that proves that the human trafficking angle is definitely a nonpartisan thing, but it just is very frustrating that the Liberals cannot get on board with it. Thank you, Mr. Speaker.
I'm just for a short question and response. The honourable member for St. Albert, Edmonton.
Thank you, Mr. Speaker, and thank my colleague from Peace River Westlock. The Parliamentary Secretary referenced the study that the Justice Committee undertook on human trafficking. I can assure this House that nowhere did we go from all the stakeholders that we met, from the victims, from law enforcement, did they say human trafficking needs to be hybridized. And the member for Peace River Westlock spoke about the fact that he couldn't figure out a case where this would be justified. Doesn't it speak to the haphazard way that this bill was drafted, the fact that such offences were classed amongst offences that are minor offences that could be reduced to a ticketable offence under the criminal code?
For Peace River Westlock.
Yeah, thank you. Thank my honourable colleague for his question, and I think this speaks to the question that I had as well before, and the fact that we look around the country and we say, oh, we have people going to jail. That seems like a bad thing. We also have a court system that seems to be clogged up. That also seems like a bad thing. Now, the Liberal solution to that, that's what we get to. The Liberal solution to that is, just reduce the number of things that you can go to jail for. Well, that's not a solution, Mr. Speaker. We are a country. We are a nation built upon laws. We have a threshold of behavior that we're looking for. Let's work on the Canadian culture if that's what it takes to change this. Not reduce the things that you can go to jail for. A lot of these things are heinous crimes, and you ought to go to jail for them. Thank you, Mr. Speaker.
It is my duty pursuant to Standing Order 38 to inform the House that the questions to be raised tonight at the time of adjournment are as follows. The Honourable Member for Renfrew, Nipissing, Pembroke. Carbon pricing. The Honourable Member for Vancouver East, Immigration, Refugees and Citizenship. The Honourable Member for Nanaimo Ladysmith, Marine Transportation.
Resuming debate. Reprise de débat. The Honourable Member for Kildonan, St. Paul.
Thank you, Mr. Speaker, and I am pleased to stand today here in this honourable House to talk about Bill C-75. This is a long overdue change to the legal system, which was bogged down in many cases, so far so that cases were actually found to have lost their meaning and were adjourned. And actually, people who we suspect had been charged got away without having gone through due process at all. Those circumstances cannot happen. It's not justice. It's not fair. And this is one step towards making a fairer, more efficient, and effective judicial system. C-75 is a meaningful and significant approach to promote efficiency, and I would assume that all members of this House would like to see that happen. Efficiency and effectiveness is something
every member of the House would like to see in our systems, because we would not want to waste 1 penny of taxpayer money on something that could be done better. And it's always our goal to do better. And that's exactly what this bill does. So this bill will make a significant approach to promote efficiency in our criminal justice system, reduce case completion times, as I mentioned earlier, and contribute to increased public confidence while respecting the rights of those being involved in ensuring that public safety is maintained. In terms of preliminary inquiries, this restricts preliminary inquiries to adults accused of the 63 most serious offences in the Criminal Code that carry a sentence of life imprisonment, like murder, and reinforces a judge's power to limit the questions to be examined as well as the number of witnesses who will appear. And Mr. Speaker, the Supreme Court of Canada in Jordan and the Senate Legal Affairs Committee, in its final report on delays, recommended that the preliminary inquiry reform be actually considered. And we should be proud to support a bill that is joining not only recommendations from this House, but from the upper house and from the provinces and territories that have been working on this issue for many, many years. It has actually been discussed for decades, Mr. Speaker, and some say that restricting preliminary inquiries may actually have little impact on the delays. I'd like to say that even though it's only 3% of cases, this will have a significant impact on those provinces which, such as Ontario and Quebec, where their procedure is used more often. And we know, because of a population base, this will have a significant impact on the whole judicial system. Also, we cannot overlook the cumulative effect of all of Bill C-75's proposals that seek to streamline the criminal justice system process. And, Mr. Speaker, it's of course in the betterment of both the accused and those that are victims to have the system move fairly and efficiently in a timely manner. The proposed preliminary inquiry amendments are the culmination of years of study and consideration in federal, provincial, territorial, and other meetings. Mr. Speaker, we know that it's not easy to negotiate a framework when we have many divergent views, many different jurisdictions, but this, Mr. Speaker, is going to be good for Canadians. Special attention. It'll be good for the Indigenous population of our country, which has unfortunately been the victim of a system that many have called racist. And if you looked at the number of Indigenous people in our jails, the numbers are extremely high, Mr. Speaker. And one must ask why the system seems to favor, seems to incarcerate so many more Indigenous people than our population actually warrants. So these changes will be more effective, more fair to our Indigenous population, and a commitment of our Prime Minister. This approach is a balanced approach, Mr. Speaker, and we often see that in this House in particular, where we have the left and the right, the positions can be quite separated, with the Liberals coming in the middle, providing a balanced approach, centre to both. And I think that most Canadians are reasonable centralists, and as we've seen in the past, that this type of negotiated solution means compromises on both sides. And so, as we look at the balanced approach between opposing views put forward by both committees and those expressed by the House, they are considered and put forward in this bill. This bill will make this procedure more efficient and expedient, Mr. Speaker, and of course, that is the goal of all of our programs for Canadians, as well as being meaningful, respectful, and available to all Canadians. Well, it's important to respect the accused rights to a fair trial. This will also help those that are witnesses and victims by preventing some of them from having to testify twice, Mr. Speaker. And that is just not reasonable for the system. It's hard on victims, it's very hard on witnesses, and so where we can eliminate this will be a benefit to all. Mr. Speaker, let's look at the issue of case management. Bill C-75 would allow for earlier appointment of case management judges, which recognizes their unique and vital role in ensuring the momentum of cases is maintained and that they are completed in an efficient, effective, a just, and timely manner. This also was recommended by the Senate report on delays in the criminal justice system. And Mr. Speaker, it is important to discuss, even if briefly, the use of technology and how this provides fairness, particularly, once again, to the Indigenous population of Canada. And coming from Manitoba, we have the highest per capita number of Indigenous peoples of provinces, proportionately, and in many cases are in fairly remote and isolated communities where participating in a full process is extremely difficult, with no roads, limited access, poor broadband connections. These are all issues which make justice much more difficult for Indigenous people in those circumstances. So, in terms of technology, this proposes to allow remote appearances, which is obviously going to assist many, many people by audio or video conference for accused, witnesses, lawyers, judges, justices of the peace, interpreters, and under certain circumstances. So this also shows that it's not always appropriate. Canada has in the past allowed remote appearances for many years, and these amendments seek to broaden the existing framework. These optional tools in Bill C-75 aim to increase access to justice, streamline processes, and reduce system costs, such as the transport of the accused, witness attendance costs, without impacting existing resources, such as those through the Indigenous Court Worker Program. These changes that we're proposing also respond to the Senate committee recommendations, which called for an increase to the use of remote appearances for accused persons. In conclusion, Mr. Speaker, the proposals in Bill C-75 in relation to preliminary inquiries, judicial case management, remote appearances, together with all of the other reforms, will ensure that our criminal justice system is efficient, just, and in line with the values of our communities and all Canadians. Thank you, Mr. Speaker.
Questions and comments. The honourable member for St. Albert, Edmonton.
Mr. Speaker, and I thank the member for Kildonan St. Paul. She spoke about preliminary inquiries, and while there certainly was some support for limiting preliminary inquiries, the vast majority of witnesses who appeared before the Justice Committee said that it was better to keep preliminary inquiries the way that they are. During the human trafficking study that we as a Justice Committee undertook, there was a Crown prosecutor who prosecuted one of the very few successful human trafficking cases in Canada who said that the preliminary inquiry was essential to the successful conviction of the individual at hand because so many witnesses were disappearing. So to get them in under oath at the preliminary inquiry stage was essential to then tender that evidence at trial. In addition, we know that 87% of cases are resolved at the stage of a preliminary inquiry. In addition to that, there was some concern about the arbitrariness of setting life. Only those where the maximum sentence is life. It makes maybe some sense on a superficial level, but there are many instances where certain charges might be a life in terms of a maximum sentence, another charge where the sentence would be less than life, but where the sentencing ranges for both of those offenses are similar, but yet only in one case would the accused be entitled to a preliminary inquiry. So I was wondering if the honourable member could address some of those points.
Member for Kildonan St. Paul.
Thank you, Mr. Speaker. And I'd be glad to talk a little bit about the impacts of the judicial system on those that are victims. And imagine being involved in a sexual abuse or being harmed in some way, having to testify in a preliminary hearing, and then having to do it once again, to be victimized even a second time by the judicial system, to have to do it during the trial. Mr. Speaker, I'm sure that Canadians understand the last thing we want to do is make the life of the victim even harder through a judicial system which is not sensitive to, in particular, to the case of women who have been sexually assaulted. Thank you, Mr. Speaker.
Questions and comments? The honourable member for St. Albert Edmonton.
Another issue that the honourable member for Kildonan St. Paul, I believe, touched upon was the issue of peremptory challenges. And this is something that I can say that we took very seriously in terms of the consideration of abolishing them. But unanimously before the Justice Committee, the Criminal Defence Bar said that they were absolutely essential in order to ensure a fair trial. And in that regard, I would draw the honourable member's attention to the comments of Richard Fowler of the Canadian Council of Criminal Defence Lawyers, who stated before the committee, quote, "I will just say, as an aside, that the abolition of peremptory challenges is a huge mistake. I've selected over 100 juries, and I've never seen it misused. It's necessary." Another lawyer, Solomon Friedman, indicated that it was essential to ensure that, in fact, juries are representative of the broader population. Could the honourable member address those points?
Honourable member for Kildonan St. Paul.
Thank you, Mr. Speaker, and I'd be glad to do so. We remember cases in Canada where the jury did not reflect the local population. In fact, we heard from many people that, in fact, there was a question of fairness and justice. And so by removing the preemptory challenge, that limits the ability of a defense attorney, for example, for removing individuals based on something quite superficial and limits the ability for the jury to perhaps be as reflective of the community as we would hope to be. And, Mr. Speaker, we want to ensure that there is representation from all of our ethnic groups, from our local community, and that the justice system be fair and open for all.
Resuming debate, the Honourable Parliamentary Secretary to the Minister of Canadian Heritage.
Thank you, Mr. Speaker, and I'm very glad to speak here in support of Bill C-75, an act to amend the Criminal Code, the Youth Criminal Justice Act, and other acts, and to make consequential amendments to other acts. And I just want to first start off by acknowledging that we're gathered here on the traditional lands of the Algonquin people, and to kind of give you a sense of my involvement with the criminal justice system. I worked as a youth worker. I ran a youth service agency several years ago. And in fact, I came across a number of young people who have had interactions with the law, with the criminal justice system, and often found it quite frustrating, the manner in which the young people were looked at in silos in respect to the charges that that were in front of them and their involvement with the criminal justice system. I also, as a lawyer, I practiced in this area very briefly, and I have over the years worked with a number of organizations that work with youth, especially involved with the criminal justice system. And just last Christmas, I along with the Toronto Breakfast Clubs and the Second Chance Scholarship Foundation, was at the Roy McMurtry Centre for Young Offenders, and had a really good afternoon meeting a number of young people who were involved in the criminal justice system and who were serving time. And since my election as MP, I have visited a number of institutions across Ontario, including detention centres and penitentiaries. What's clear, Mr. Speaker, to me from my engagement with the criminal justice system is that it's not fully working. There's a lot that we need to do to change it and to improve it. And I believe C-75 does address a number of important issues. First and foremost, the issues of delay, the issue of safety in terms of how our communities are, and of course the massive overrepresentation of certain groups within the system. And I'll note that the Office of the Correctional Investigator, whose reports are actually quite insightful, offer some really drastic numbers, and they reflect what I believe are structural issues within our system that oftentimes render particular groups overly represented within the criminal justice system. And just as an example, 40% of women in penitentiaries are Indigenous women. That is a gross overrepresentation in relation to their population in Canada. Similarly, young black men represent 8% of, roughly 8% of those serving time in penitentiaries. And similarly, Indigenous men are just hovering around the 30% mark. And we know in relation to their numbers, they're much more pronounced and disproportionate in terms of the representation. And one can ask ourselves why this is so. And I think, I've been involved in my current role as Parliamentary Secretary to the Minister of Heritage in undertaking some discussions and some engagements on anti-racism. And it's very clear, Mr. Speaker, that there are underlying structural and systemic issues within our criminal justice system that does have some very specific outcomes. This is on top of issues of poverty, issues of disenfranchisement, the issues of lack of housing, and a whole host of other social determinants. But complicated with that is a system that in many ways is deeply problematic in terms of the manner in which it treats certain groups of people. And I believe that C-75 goes in some lengths to address these issues, probably not to the full extent it may be required, but certainly goes a distance in addressing some of these structural issues. And I want to kind of maybe talk about a few of them this afternoon. First, Mr. Speaker, the C-75 changes the way our system deals with administration of justice offenses. And I can't tell you the number of times I've worked with young people who have been charged with an offense. Oftentimes the evidence against that individual is quite weak, but unfortunately because of the terms of bail, the terms of release, they often find themselves back in detention, back in jail, back facing additional charges. And I think it's deeply frustrating when we see that. And I can tell you one of the immigration cases that came to my office involved a young man, 40 years old. He came to Canada when he was 8, and he was involved with the child welfare system. I believe his first charge was when he was about 13 as a young offender, and within a year he was found not guilty of those charges, but within a year he was charged and convicted of an offense of breach of condition, namely that he did not appear in court. Now we're talking about a 14-year-old young man who, by all measure, had many obstacles in his life, including the fact that he was separated from his parents. He was growing up in the child welfare system. And this young man who ended up going to missing court, who was convicted for the first time. And then I saw his record, and over again, it was not the issues of the actual crime. It is administrative justice offenses, administration of justice offenses that he was convicted of, and which really tells you, Mr. Speaker, that our system is not working, and we can look across the country of many young men and women who are serving time because the way that we have set up our system is one which is very punitive and which is very restrictive. And while it's essential to ensure public safety, I do think we can do this by making sure that the terms of release are proportionate and are reasonable and are acceptable to all the parties. And I think that's something that I see very often. I can tell you, when I work with young people, one of the standard terms of release that I saw in bail is non-attendance of, if an incident took place at school or nearby a school, oftentimes a condition that a young person does not attend to that school or go near the school. Now, how is it fair that you have a 15-year-old in grade 10 who is having some difficulties in life, who is restricted from going to that school? I mean, that the change of schools, change of circumstance will obviously extenuate the challenges that a young person has in life, and oftentimes will lead towards greater involvement with the criminal justice system. Sadly, Mr. Speaker, I don't have time. I was thinking I have more time to speak on this in a bit more detail, but I can tell you that this bill is very important. This does go part ways in addressing some of the systemic issues that we saw, we see in the criminal justice system, and particularly with respect to the racialization of incarceration in Canada and many parts of the world, but particularly in Canada, as documented by the Office of the Correctional Investigator and others who have pointed to highly polarizing numbers that speak to systemic issues within our criminal justice system. In summary, Mr. Speaker, I would I'd just like to say that the issues addressed in this bill, namely the delay aspect, making sure the delays are limited by eliminating undue processes, are important, as well as the overrepresentation that I discussed, as well as making sure that issues such as intimate partner violence are addressed. I believe that this is a very important bill that warrants the support of all of our colleagues here and across the aisle as well. Thank you, Mr. Speaker.
Questions and comments. The Honourable Member for St. Albert, Edmonton.
I thank the Parliamentary Secretary, and I know that he is a lawyer, and I want to ask him a question in regards to the limitation on preliminary inquiries. Evidence before the Justice Committee was that preliminary inquiries can serve an important discovery aspect in which important evidence on complex motions before the court can be that they can serve a useful purpose to avoid mid-trial delays if it's not dealt with until you get to a trial. And so it was pointed out in that regard that limiting preliminary inquiries in that context would actually have the potential impact of increasing delay rather than reducing delay, with an increased likelihood in mid-trial adjournments.
The Honourable Parliamentary Secretary to the Minister of Heritage.
Thank you, Mr. Speaker, and I'd like to thank my friend from Mount Albert, Edmonton, for that question. Look, I think when we talk about issues such as preliminary inquiries, I know there's different perspectives. My experience has been that it's oftentimes delays. There's unnecessary delays put on because of this. You oftentimes have people who are victimized who need to come back and a number of times to testify. I believe the Bill C-75 has found the right balance, Mr. Speaker, and while I respect the work of the committee, but my experience has been otherwise in this area.
The Honourable Member for Drummond. Thank you, Mr. Speaker. Obviously, there had to be a response to the Jordan ruling. And the purpose of Bill C-75 is to do that. However, one thing wasn't done, and that is to ensure that there will not be significant delays in the system so that the real criminals can be convicted and serve their time. Unfortunately, there's a very well-known case right now, Nick Chan's case in Calgary. So a notorious gang leader who was accused of murder was released because his right of the accused to be prosecuted in a reasonable time based on the Jordan ruling did not happen because there were not enough judges. So yes, this bill is a beginning of an answer, and I've spoken to this. But what is the government doing right now to ensure that there are enough judges on the bench in order to make sure that these posts don't remain vacant? The Honourable Parliamentary Secretary to the Minister of Heritage.
Mr. Speaker, this is something that's quite important to me. I know the appointment of judges and judges that bring a breadth of experience and diversity to the bench, I think is quite important. As a government, we've taken some very important steps by establishing a process of appointment of judges that I think is one of the finest in the world that will withstand any type of scrutiny. And we see our benches being filled with exceptionally talented people from all walks of life. And I would say to the honourable member that this is something that, as a government, will be fulfilled. And I think we're on the right path in appointing the type of judges that should represent our benches.
Questions and comments? At this time for a short question, the Honourable Member for Guelph.
Thank you, Mr. Speaker, and thanks to the Honourable Member for his intervention. You mentioned delays and the moving away from the peremptory challenges, which caused a lot of delays in our system, and going towards the set-aside provisions in the current proposed legislation to streamline the jury selection process, give control to the judges to make sure we have diversity. Could the Honourable Member talk about how that can improve our efficiency in the court systems going forward?
The Honourable Parliamentary Secretary.
Look, I think and I want to thank my friend for that question, but I think it's very clear that the outcomes that we see, the numbers that we see year after year after year from the Office of the Correctional Investigator should trouble all Canadians. It should really raise some questions as to why certain provisions exist, why certain practices exist, and how that affects racialized peoples. And I think it's very clear peremptory challenge is one of those issues where we've seen some serious miscarriages of justice over the years, and I think it's a very important step in C-75 that addresses a major concern of many communities, many victimized communities who have been seeking justice.
Resuming debate, the Honourable Member for Drummond. Thank you very much, Mr. Chairman. It's an honour for me to rise today and speak to Bill C-75, an act to amend the Criminal Code, the Youth Criminal Justice Act, and other acts, and to make consequential amendments to other acts as amended. And before beginning, I'd like to thank the member for Victoria for the excellent work he did in committee on this issue. He worked very hard. He brought forward many amendments. He put questions to witnesses, and he was very thoughtful throughout this process. It truly was impressive. And that's what will feed my remarks today. First, Mr. Speaker, why will we be opposing this bill? The purpose of this bill was to respond to the Jordan ruling, and this bill does not do so adequately. And that is why we will be opposing it. The bill does not go far enough in what it was supposed to do. It does not achieve the target that was set, and that's the issue. The purpose of this bill is to respond and comply with the Jordan ruling that was brought down by the Supreme Court in 2016. And most importantly, it was supposed to clear the backlog in the courts, because the problem with the Jordan case and the problem that this ruling was responding to is that there is a right under the Charter to be prosecuted within a reasonable time. And that reasonable time was set in the Jordan ruling. That time was set at 18 months between the charges being laid and the end of the trial, and 30 months in other cases. Mr. Speaker, by setting time periods for these cases and then not meeting those timelines, then you end up with cases like the one I spoke about in my question, where serious criminals can end up being released without having gone through their trial. That is a horrible situation, and it must never happen again. It is something that our society and our government must ensure does not happen again. Bill C-75 had engendered high hopes, but did not meet those expectations. One of the major changes under Bill C-75, which is not evidence-based, and that's the main problem, actually, was to respond to the Jordan ruling, as I said. However, speeding up the prosecution system is questionable. Many steps being proposed will have the opposite effect. It might actually increase the time of a trial. The Liberals have said that this is a courageous change to the criminal justice system. However, Mr. Speaker, there is a problem on top of the one I just mentioned. In the mandate letter for the Justice Minister, there's a very, very important point that is made, and it's something that we also take very seriously. It's the repeal of mandatory minimum sentences. All legal experts all over the world have said over and over again that this system of mandatory minimum sentences is a bad system. It harms it harms the system itself. It harms the judges in the kinds of rulings that they have to be able to make themselves based on the situations that are each and every one of them unique. Now, what are we getting in Bill C-75? You see, we expected to see something based on the mandate letter to the Minister of Justice. We expected that the first important change would respond to that mandate letter. However, that commitment was not kept, and we are extremely disappointed. Defense lawyers, law professors, as I mentioned, have all said that abolishing that method was very important in dealing with the backlog. But the Liberals ignored that. They have not dealt with that key issues. It's extremely disappointing, and I don't understand why they didn't respond to that, why they didn't carry that out. There are other concerns, Mr. Speaker. The one of those concerns is the preliminary hearings under Bill C-75. You wouldn't really gain much time. And furthermore, preliminary hearings may, in some cases, eliminate the need to actually go to trial. So, this is a step that was brought forward. It was pointed out by witnesses as being an important step in reducing backlogs, but actually the opposite is going to happen. It might even increase the time. Now, there will also be a change to the summary offenses. There will be a strengthening of sentences, an increase of sentences for some summary offenses, for example, 18 to 24 months, and that's one part of the change. Many of those who are accused are people who require social support. They don't need to be further criminalized. And this change will affect a disproportionate number of racialized individuals, Indigenous individuals, and those who have a low socioeconomic status or who have issues of addiction or mental health.
So we have missing elements in this bill, which is a very important one. I think that there should be opportunities to deal with problems at their source, to deal with crime at its source. Now, I can talk about things such as poverty. Today is the International Day for Fighting Poverty. There are problems of addiction, there are mental issues, and all these things are things that are important, but we don't see them reflected in this legislation. People are brought before courts, but these are really social problems. There's the whole, there are all the problems surrounding Indigenous peoples, and these are problems. We have to work with the communities that are affected by these things. We have to help them improve their lives, but there's nothing at all to deal with this sort of thing in this legislation. Mr. Speaker, I think what is missing is that there's nothing about increasing appointments to the bench. We cannot continue to tolerate that there are still vacancies on the bench. This government has been in power for more than 3 years. So these vacant positions will have to be filled. And why is it important? Well, it's already been mentioned. There's the case of Nick Chan in Calgary. People are still talking about it today. What happened was that a notorious gang member who'd been accused of murder and other criminal acts was released because his right to a trial in a reasonable amount of time was not respected because there weren't enough judges. So this is an extremely serious problem that the government has to address as soon as possible. Now, there has to be an impartial appointment process, but we have to deal with this as rapidly as possible. We can't continue along with a situation where notorious criminals don't go to trial because we don't have enough judges. I see, Mr. Speaker, that my time is up, so I thank you. Questions and comments. The Honourable Parliamentary Secretary to the Minister of Justice. Thank you, Mr. Speaker. I appreciate the comments of the member for Drummond, and I'd just like to say let's focus on one aspect. He mentioned the number of judges. We have already appointed 31 judges in Quebec, and he knows full well that we inherited a system that was not not in good shape after the Conservatives. We are putting a greater focus on reflecting diversity in the magistrature on the bench. There are a greater number of women. There are a greater number of Indigenous persons, LGBT people, 6% more. And I would also like to say that I know that he is a great defender of official languages. 30% of our candidates are bilingual, not just in Quebec, but across Canada. So the question is, does he agree with this kind of candidate and this kind of person being appointed, which reflects our country in a far more representative way? The Honourable Member for Drummond. Thank you, Mr. Speaker. And yes, I congratulated the government for its new way of appointing justices. I think it's a very good thing. I like the diversity of new appointments. I would like to see them, I'd like to see there be more bilingual judges, and if there are more, that's good, and let's see more again. But my colleague did not deal with a very important element of my speech, and that is the mandatory minimums. And this is in the minister's mandate letter. After 3 years, what is the government waiting for to put an end to these mandatory minimum sentences? Questions and comments?
Edmonton.
Well, thank you, Mr. Speaker. And the Parliamentary Secretary to the Minister of Justice suggested that somehow the appointment process was broken under the Harper government. I hope he's not impugning the character of the very many good justices who were appointed under Prime Minister Harper, as well as the many good justices that have been appointed by this government. The problem, however, is that this government didn't do it quick enough, at least in the first year that this government was elected. Now, the member for Drummond just commented on the new appointment process established by the government. But it took the government a full year to appoint new judicial advisory committees. 1 year. Does the honourable member agree that that demonstrates that when it comes to appointing judges and when it comes to filling judicial vacancies within a reasonable period of time, this government hasn't taken it seriously?
The Honourable Member for Drummond. Mr. Speaker, the new process is a good thing in and of itself. We're happy to see that diversity is better represented, but what we are criticizing is the time it took, how slow it was, and that there are still so many positions that have to be filled. Now, I would repeat my question to the government. It's in the Minister of Justice's mandate letter to abolish, to repeal mandatory minimums. There are specialists in the field, and they say that these mandatory minimum sentences make it impossible for someone to take into account the various kinds of offenses. They don't know whether someone is living in complete poverty, is dealing with mental issues, or may have been victims to racist or other forms of prejudiced aggression in the past. So the government has not accomplished what was set out in its mandate letter.
Honourable Member for St. Catharines.
Thank you very much, Mr. Speaker. I'm pleased to rise to participate in the debate of Bill C-75, an act to amend the Criminal Code, Youth Criminal Justice Act, and other acts, and make consequential amendments to other acts. Yeah, that's an important part. I intend to focus my remarks on the sentencing issue, and at the outset, it's important to address the hybrid offence issue, because we're hearing a lot of misinformation coming from the other side about how this process works. And what that means is offences that were punishable or are punishable by a maximum penalty of 10 years imprisonment or less. And these reforms will allow the Crown to proceed by summary conviction in appropriate cases. And there's suggestion that this minimizes the seriousness of the offence, and nothing could be further from the truth. What is being said from the other side, Mr. Speaker, and what their concerns that they've raised and the misinformation they're raising is a lack of trust of the judiciary, a lack of trust of police officers, and a lack of trust of Crown prosecutors. Now, the opposition is the party that pretends to be the law and order party, party that gets tough on crime, party that never really talks about significant issues that will reduce crime, but they'll wrap themselves in the flag and pretend to go forward based on that and spread misinformation about Bill C-75 to build themselves up to make it seem like this bill isn't accomplishing anything. But what this bill is doing, because the world in the Canadian judicial system changed with the Supreme Court decision in Jordan, that justice had to be quicker. Justice delayed is justice denied, which is something that we've all heard, but it's true, Mr. Speaker. It's something that's guaranteed in the Charter of Rights and Freedoms. And so the Minister of Justice met with provincial and territorial counterparts of all political stripes. Yeah. All political stripes, Mr. Speaker. Really? All parties that are represented in this House, to come up with a way to make justice quicker, to get people before a judge as quickly as possible. And I think that's something we can all agree on, that if someone's been charged with a criminal offence, they should be in front of a judge as quickly as possible. That gets to sentencing as quickly as possible and an outcome as quickly as possible. But the proposal to hybridize offences is procedural in nature and is intended to allow the prosecution by summary conviction of conduct that does not currently result in a sentence of more than 2 years. For instance, it is a mischaracterization of the reclassification of amendments to assert that hybridizing, for example, Section 467.11 of the Criminal Code, which is participation in activities of a criminal organization, is sending a message that we don't take organized crime offences seriously. Now, Mr. Speaker, there's not a member of Parliament in this House that doesn't take organized crime seriously, and to suggest otherwise is preposterous. The proposed amendment simply recognizes that this offence can, by virtue of the range of conduct captured, include circumstances where appropriate sentence falls within the summary conviction range. Proceeding summarily in these circumstances allows for more expeditious proceedings without either undermining public safety or impacting the range of sentences for this offence. Now, let's go back in our time machine, Mr. Speaker, back to 2011-2012. There was as they would call themselves, tough-on-crime government, Mr. Speaker. And so, in that period of time, in those years, there were 49 guilty verdicts issued under Section 467.11 of the Criminal Code. Of these 49 offences, only 34 were given a custodial sentence. Of those, 1 received 1 month or less. Wow. 6 received between 1 and 3 months. 10 received between 3 and 6 months. 9 received from 6 to 12 months. 4 received from 12 to 24 months. And the remaining 4, less than 10% of offences, received a sentence 24 months or more. And that's from the Canadian Centre for Justice Statistics during the Stephen Harper era of tough on crime, Mr. Speaker.
They don't believe in statistics.
And we've heard in question period, as my honourable friend mentioned, that belief in statistics may not necessarily be their thing, but I'm going to put that forward. Okay. And so this bill, Bill C-75, gives the Crown the discretion on how to proceed. The Crown knows when they're going forward with the case the sentence they would ask for at the end of the day. if a conviction happened. They then have to make arguments. They know the range. They've been doing this. Many in my riding have been doing it for 5, 10, 15, 20 years. And the Conservatives say, we don't trust them. We don't trust them to make that call. Even though, and they don't trust judges. We just heard that from the honourable member from St. Albert's, Edmonton, who's yelling for some reason.
Order. I just want to remind the honourable members that while someone's talking, shouting across the floor is not regular parliamentary procedure. So I'll let the honourable member for St. Catharines continue.
Well, Paul, I may have misheard the honourable member screaming and shouting. He may have said that he trusts judges, but, Mr. Speaker, opposing this bill shows that they don't trust judges. Because at the end of the day, it's the Crown and the defence that make the arguments. One will say this is required for a sentence of a certain period of time. The Crown will say that. The defence will say, no, we believe it's less. And the judge will make that decision. But at the end of the day, Mr. Speaker, if the Crown, the Crown prosecutor whose job, they've gone into this business to put dangerous people behind bars. They've gone into the business for that reason. If they believe that the sentence should be less than 24 months, why not make a proceeding to get these people behind bars quicker? This bill is achieving a tougher on crime approach. It's getting those who are charged with offences before a judge faster. And there's scoffing from the other side, but they can't dispute that fact, Mr. Speaker. They can't dispute the fact that they don't trust Crown prosecutors, which is shameful. And that how you surround yourself and wrap yourself up with the law and order agenda, but don't trust one of the most significant aspects of that system, which is Crown prosecutors. They don't trust the police to lay the appropriate charge. They don't trust the Crown.
Don't trust the judges,
and they may or may not trust the judges either. And that's just disappointing at the end of the day, Mr. Speaker. And we still hear the heckling. I think I've touched a nerve in terms of the truth of this, Mr. Speaker. And the honourable member from St. Albert, Edmonton continues to heckle. I believe, Mr. Speaker, I haven't seen the recent reports, I believe he's been the most called out in terms of his heckling, and he continues to do so, which is truly unfortunate. And I'm sure he's had plenty of opportunity to speak, but wishes to shout me down, because again, speaking the truth, Mr. Speaker, and sometimes that stings, and we're seeing that in this particular situation.
Truth hurts.
It's clear in keeping Section 467.11, which I'd mentioned, a straight invitable offence will not in any way prevent the Crown, in appropriate cases, from seeking a non-custodial sentence or a sentence of imprisonment that is in the summary conviction range, or seek a sentence that's even higher, Mr. Speaker. This all comes down to giving the Crown attorneys, those who are on the ground, those that know the facts of the case, Mr. Speaker. Who are we as members of Parliament to say they aren't the best people in the position to make that decision? They live in the communities where they're trying these cases. They don't want to see bad people out on the streets. And I look to the opposition, is that what they believe? That's what they're suggesting. That's what they're suggesting is going on in this bill, Mr. Speaker. It's a complete lack of trust from some of our chief law officials who are living in their communities, who want to see bad people go to jail, and have dedicated their careers to that goal. And it's shameful, Mr. Speaker, utterly shameful that the opposition would try to spin the narrative that this is soft-on-crime legislation. This is getting people to a judge faster, it's getting people to jail faster, and it's meeting the charter requirements as set out by the Supreme Court.
Community safer, faster.
As we saw from the Leader of the Opposition in his plan, which was rated full of baloney, they have no plan to make Canada safer. We have a plan, Mr. Speaker. This plan will get people to justice faster. It will allow Crown attorneys to have discretion and will make the justice system more efficient. Justice delayed is justice denied, Mr. Speaker, and this is going to help our Canadian justice system. Thank you so much.
Questions and comments. Questions et commentaires. The honourable member for St. Albert, Edmonton.
Well, Mr. Speaker, the honourable member's speech was certainly long on rhetoric, but short on substance. The honourable member talks about giving prosecutors discretion, and that's all this is about. Well, Mr. Speaker, if that were the case, then why would we have solely indictable offences at all? Why wouldn't every offence be a hybrid offence? Why wouldn't murder be a hybrid offence if it's all just about giving prosecutors the appropriate discretion? Mr. Speaker, we don't, because there are certain offences that are serious offences and need to be, in all cases, treated seriously, and therefore they're indictable. I was wondering, he spoke about the range of conduct captured such that it would be appropriate to prosecute by way of summary conviction. Just what range of conduct captured does he envision in the case of infanticide, or concealing the body of a child, or perhaps administering a rape date drug? In just what circumstances does he see those offences being on the level of a ticketable offence or a minor property crime?
The honourable member for St. Catharines.
Thank you very much, Mr. Speaker. And I go back to, again, this law and order government. And so I'll give the honourable member an example he can chew on a little bit himself in terms of the offence of sexual assault. Sexual assault is a hybrid offence. It remained a hybrid offence under the Harper government. Why didn't they change it, Mr. Speaker? Maybe it's because it's best to give Crown attorneys discretion. Maybe because it's best to give judges discretion. Or were they soft on crime? I don't know at the end of the day. We gave the honourable member statistics as to the particular offence that was provided, that at the end of the day, again, under the law and order Harper government, that those offences were, or those individuals charged and convicted under that particular offence were not getting offences of more than 24 months. Less than 10% were. So why not come up with a plan, Mr. Speaker, to get those cases that are going to be less than 24 months to a judge quicker, get those people behind bars quicker? Conservatives have no plan, and that's truly unfortunate, Mr. Speaker.
Questions and comments, questions et commentaires, l'honorable député de...
The honourable member for Longueuil Saint-Hubert. Well, thank you very much, Mr. Speaker. When I hear the government talk about a law and order
spin government, clearly. Honnêtement, je dois dire que...
Honestly, I must say, when I look at this bill, now, I'm not a specialist on these issues, but what I do know is you don't have to be a rocket scientist in order to know that minimum sentencing, minimum minimums have crowded the justice system. Now, this is the huge problem. If you call a plumber and you say, the water heater's leaking, and they fixes the tap, well, what's that all about? What is the issue here? They're not fixing the problem that's causing the problems.
I'd like to thank the honourable member for his question. I'll have to respectfully disagree that we are fixing the problem. There are two different methods in two different courts, one at the Superior Court, one at the Provincial Court. Provincial Court matters move quicker. And if a Crown knows at the end of the day that they're going to seek a sentence of less than 24 months, they can move far more expeditiously through the Provincial Court system. And that's what we're doing in this case. If a Crown knows that they're going to only seek 20 months, why send them through Superior Court? Why incur all that extra delay? Why not get offenders before a judge as quickly as possible and get them behind bars?
Questions and comments. We have time for about a 30-second question, a 30-second answer. The honourable member for Parkdale Hyde Park.
30-second question, Mr. Speaker. There's been some discussion about trusting judges. A key aspect of this bill that hasn't been touched on much is the power of a judge to stand aside a juror. Normally, they can only do this in the context of personal hardship, but this bill is amending the criminal code so that you can stand aside a juror to ensure a more representative jury. What does that mean to the members' constituents in St. Catharines and constituents around this country so that they can ensure that there's a more diverse jury hearing cases and rendering verdicts in criminal matters?
The honourable member for St. Catharines.
I'd like to thank the honourable member and the honourable parliamentary secretary for his question. I know he and the committee did incredible work on this. This bill speaks to a whole host of issues throughout the justice system, be it bail, juries, and the like. And so I'm very pleased to be supporting this bill, and at the end of the day, hope that the opposition comes to their senses and supports this bill, because it's going to get offenders to a judge quicker than the previous government ever could.
Resuming debate, the honourable member for Carlton Trail, Eagle Creek. I just want to point out to the honourable member she'll have about 9 minutes, and then we'll have to cut her off. The honourable
Thank
member.
you very much, Mr. Speaker. I am pleased to rise today and speak at third reading on Bill C-75. I did have the opportunity recently to speak on another bill which also sought to amend the Criminal Code, Bill C-375. In that speech, I drew attention to the Liberals' alarming track record on criminal justice. I would like to continue with these thoughts today in the context of the bill before us. C-75 continues a disturbing pattern from this Liberal government. Where previous governments of all stripes sought to protect victims of crime, this Liberal government seems to favour the protection of criminals instead. From their first days in government, the Liberals have used the levers of power to shield and protect criminals while leaving victims and their families in the cold. We've seen this time and time again, Mr. Speaker, with the Liberals' $10.5 million payout to Omar Khadr and their subsequent snubbing of Tabitha Speer, their shocking response to Terry Lynn McClintock's transfer from a secure prison to a healing lodge, their abysmal response to gang crime through Bill C-71, along with countless other examples. And when Canadians dared to raise their concerns, the Prime Minister labelled them ambulance chasers. But perhaps the most tangible examples of this government's disordered protection of criminals have come in this bill. When C-75 was introduced, it reduced the penalties for advocating genocide and participation in terrorist activities to possibly as little as a fine. It was only at the insistence of my Conservative colleagues in committee that these clauses were removed. I am glad the Liberal members on that committee saw the folly of the original text, but it begs the question, how could the government have thought those clauses were in any way appropriate in the first place? Unfortunately, Mr. Speaker, I believe that this is not a one-time occurrence, but, as I said, a disturbing pattern regarding terrorists from this government. As I already mentioned, take the case of Omar Khadr, which resulted in the convicted terrorist becoming a millionaire at the expense of Canadian taxpayers. And this is just one example. Recall that long before the Liberals tried to use C-75 to lower the penalties for engaging in terrorist activities, one of the first items on the Prime Minister's agenda was to pull our Air Force out of the fight against ISIS. This was a backwards decision at the time and, in retrospect, almost indefensible. Just days ago, a mass grave holding the remains of more Yazidi victims of ISIS was discovered in Kar Azir town. This is the 71st mass grave found in the area. The men, women, and children in these graves were slaughtered by members of ISIS, some of whom are from this country. These ISIS terrorists stoned women to death for the crime of being raped. They killed families for believing in the wrong God or being the wrong ethnicity. They burned men alive for refusing to join their evil cause or threw them off of buildings for being gay. As I previously pointed out in this place, the Minister of Foreign Affairs couldn't even bring herself to call these monsters terrorists.
The honourable member for Parkdale High Park has a point of order.
Yes, I've been listening intently to the member opposite and to all of her colleagues, and we're about 4 minutes into her remarks, and we've yet to actually have anything that substantively relates to Bill C-75. We've heard about settlements of litigation. We've heard about foreign affairs policy and defence policy. I'd ask you through her to direct your comments to the bill at hand, please.
I will leave it with the honourable member. I'm sure she'll come to her point. As I've stated before, I often hear arguments go in certain directions that you figure is a tangent that make absolutely no sense to the person who's listening. But as the person explains it, you see it come around and it becomes evident to everyone. I'll leave it to the person, or the member for Carlton Trail, Eagle Creek, to finish up.
Thank you very much, Mr. Speaker. I appreciate that. Mr. Speaker, for his part, the Prime Minister has doled out taxpayer dollars for so-called de-radicalization programs for returning ISIS terrorists, and in the meantime, he has told veterans that they are asking for more than we can give. Wouldn't it be more appropriate to say that to returning ISIS terrorists instead of the brave men and women who have defended our nation? But perhaps we shouldn't be surprised. Indeed, after the Boston Marathon bombing, the now Prime Minister said of the terrorists responsible, and I quote, There is no question that this happened because of someone who feels completely excluded, someone who feels completely at war with innocence, at war with society." End quote. I believe it is this kind of foolishness, this kind of foolish gentleness towards terrorists that caused the Liberals to propose weakening the penalties in Bill C-75. They spent months arguing for and defending the inclusion of that clause before finally backing down and supporting the Conservatives in removing it. It took months of pressure and hard work to make this one obvious change, but even with that change, the bill remains deeply flawed. C-75 still weakens the penalties to as little as a fine for many other serious crimes. Among those are serious sexual crimes, such as using the date rape drug, forced marriage, marriage under the age of 16, polygamy, and acting as a pimp. I wonder how it is that the Prime Minister can claim to be a feminist while simultaneously weakening the punishment for such terrible crimes. In addition to the sexual crimes I mentioned, the Liberals are also weakening the punishment for corruption and fraud. A lighter penalty will be possible for those convicted of bribing municipal officials, insider trading, forging currency, using libel for extortion, fraud through the use of arson, or even illegally influencing political appointments. Perhaps most shocking, Mr. Speaker, is the list of violent and gang-related crimes that will be eligible for summary conviction. Infanticide, hiding the body of a child, obstructing or assaulting an officiating clergyman, abduction under the ages of 16 and 14, conspiracy, and participating in criminal gang activities. And while I know my time is nearly up, Mr. Speaker, I would be remiss if I didn't take the time to point out that this is the Liberals' second attempt to remove or amend Section 176 of the Criminal Code after abandoning their changes to C-51. Assault on officiants during a religious service is very serious and should remain an indictable offence. Yet here they are, breaking yet another promise they committed to keep full protections in place for religious officials. There are many more serious crimes that we see a weakened response to. In fact, I find myself wondering if this isn't the intent of the bill. The previous Conservative government passed the Victims' Bill of Rights, and this is the Liberals' response. Again and again, we see examples of the Liberals' obsession with making criminal lives easier. As one final example, the Liberals recently introduced a plan to provide needles to prisoners who use drugs, despite a zero-tolerance policy on drugs in prisons. It would take a Liberal to square that circle. This ridiculous plan puts correctional officers in the line of danger for no other reason than to satiate them. Jason Godin, president of the Union of Canadian Correctional Officers, said the following on this ridiculous idea, and I quote, "It's pretty obvious the policy changes the government is making are making it more dangerous for us, more dangerous for inmates, and obviously more dangerous for the general public." Why does this government insist on placing the rights of criminals above the rights of victims, police, guards, and citizens overall? As I've said before, Canadians deserve better than a government that treats victims like criminals and criminals like family. Thank you.
Comme il est 17h50.
It being 5:52, pursuant to order adopted earlier today, it is my duty to interrupt the proceedings and put forth with every question necessary to dispose of report staged of the bill that is currently before the House.
The question is on motion number 1. A vote on this motion also applies to motions numbers 11, 13, and 14. Ms. Wilson-Raybould, seconded by Mr. LeBlanc, move that Bill C-75 be amended by deleting Clause 22. Is it the pleasure of the House to adopt the motion? Yes. Did I hear anything else? All in, okay? I'm sorry? Okay, motion adopted. Very good. Je déclare donc la motion.
I declare motion 11, 13, and 14 carried.
The question is on motion number 2. A vote on this motion also applies to motions numbers 3, 10, and 12. Monsieur Cooper, appuyé par Monsieur.
Mr. Cooper.
I covered it. Oh, excuse. 3 à 10 et 12. Je m'excuse.
3 to 10 and 12. That's why we have these people here to correct me when I make a mistake. Mr. Cooper, seconded by Mr. Sorensen, moves that Bill C-75 be amended by deleting Clause 61.
The House to adopt the motion. No! All those in favor of the motion will please say yay. Yay! All those opposed will please say nay. Nay! In my opinion, the nays have it. Okay, so call in the members.
Chair. The question is on motion number 2. A vote on this motion also applies to motions numbers 3 to 10 and 12. Mr. Cooper, seconded by Mr. Sorensen, moved that Bill C-75 be amended by deleting Clause 61. All those in favor of the motion will please rise.
Ms. Bergen.
Ms. Bergen.
Mr. Nicholson.
Mr. Nicholson.
Ms. Finley.
Ms. Finley.
Ms. Gledoux.
Ms. Gledoux.
Mr. Allison.
Mr. Allison.
Mr. Bazan.
Mr. Bazan.
Ms. Rempel.
Ms. Rempel.
Mr. Kent.
Mr. Kent.
Mr. Reyes.
Mr. Reyes.
Mr. Poilievre.
Mr. Poilievre.
Mrs. Block.
Mrs. Block.
Mrs. McLeod Kamloops Thompson Caribou.
Mrs. McLeod Kamloops Thompson Caribou.
Mr. Blaney Bellechasse Les Etchemins Lévis.
Mr. Blaney Bellechasse Les Etchemins Lévis.
Mr. Nuttall.
Mr. Nuttall.
Mr. Barlow.
Mr. Barlow.
Mr. Bertod.
Mr. Berthold.
Mr. Martel.
Mr. Martel.
Mr. Albus.
Mr. Albus.
Mr. Chong.
Mr. Chong.
Mr. Richards.
Mr. Richards.
Mr. Workington.
Mr. Workington.
Mr. Strahl.
Mr. Strahl.
Mrs. Stubbs.
Mrs. Stubbs.
Mrs. Vecchio.
Mrs. Vecchio.
Mrs. Wong.
Mrs. Wong.
Mr. Abu Taif.
Mr. Abutayev.
Mrs. Kuzi.
Mrs. Kuzi.
Mr. Kelly.
Mr. Kelly.
Mr. Generu.
Mr. Generu.
Mr. Tilson.
Mr. Tilson.
Mr. Warwalk.
Mr. Warwalk.
Mr. Sorensen.
Mr. Sorensen.
Mr. Zimmer.
Mr. Zimmer.
Mr. Reed.
Mr. Reed.
Mr. Lukiski.
Mr. Lukiski.
Mr. Nader.
Mr. Nader.
Mrs. Wagenthal.
Mrs. Wagenthal.
Mr. Broussard.
Mr. Broussard.
Mr. Sweet.
Mr. Sweet.
Mr. Anderson.
Mr. Anderson.
Ms. Alislev.
Ms. Alislev.
Madame Boucher.
Madame Boucher.
Mr. Lake.
Mr. Lake.
Mr. Calkins.
Mr. Calkins.
Mr. Falk-Provencher.
Mr. Falk-Provencher.
Mr. Generer.
Mr. Generer.
Mr. Gould.
Mr. Gould.
Mr. Kimmich.
Mr. Kimmich.
Mr. Macaulay Edmonton West.
Mr. Macaulay Edmonton West.
Mr. Lobb.
Mr. Lobb.
Mr. Kitchen.
Mr. Kitchen.
Mr. Jennis.
Mr. Jennis.
Mrs. Gallant.
Mrs. Gallant.
Mrs. Falk Battleford Lloydminster.
Mrs. Falk Battleford Lloydminster.
Mr. Albrecht.
Mr. Albrecht.
Mr. Dreeshen.
Mr. Dreeshen.
Mr. Hoback.
Mr. Hoback.
Mr. McGuire.
Mr. McGuire.
Mr. Cooper.
Mr. Cooper.
Mr. Arnold.
Mr. Arnold.
Mr. Clark.
Mr. Clark.
Mr. Godin.
Mr. Godin.
Mr. Stanton.
Mr. Stanton.
Mr. Lozan Stormont Dundas South Glengarry.
Mr. Lozan Stormont Dundas South Glengarry.
Mr. Van Kesteren.
Mr. Van Kesteren.
Mr. Shipley.
Mr. Shipley.
Mr. Glinsky.
Mr. Glinsky.
Mr. McKenzie.
Mr. McKenzie.
Mr. Yordega.
Mr. Yordega.
Mr. Diot.
Mr. Diot.
Mr. Leipert.
Mr. Leipert.
Mr. Shields.
Mr. Shields.
Mr. Vierson.
Mr. Vierson.
Mr. Waugh.
Mr. Waugh.
Mr. Weber.
Mr. Weber.
Mr. Motts.
Mr. Motts.
Mr. Benson.
Mr. Benson.
Mr. Lloyd.
Mr. Lloyd.
Mr. Trost.
Mr. Trost.
Monsieur Caron.
Mr. Caron.
Mr. Julian.
Mr. Julian.
Madame Brosseau.
Madame Brosseau.
Mr. Cullen.
Mr. Cullen.
Mr. Angus.
Mr. Angus.
Mr. Massey Windsor West.
Mr. Massey Windsor West.
Ms. Ashton.
Mr. Ashton.
Ms. Matheson.
Ms. Matheson.
Ms. Duncan Edmonton Strathcona.
Ms. Duncan Edmonton Strathcona.
Mr. Christopherson.
Mr. Christopherson.
Mr. Garrison.
Mr. Garrison.
Madame Boutin Suite.
Madame Boutin
Ms.
Suite.
Blaney North Island Powell River.
Ms. Blaney North Island Powell River.
Mr. Rankin.
Mr. Rankin.
Mr. Dubé.
Mr. Dubé.
Mr. Davies.
Mr. Davies.
Mr. Bulleris.
Mr. Bulleris.
Madame Laverdière.
Madame Laverdière.
Monsieur Dussault.
Mr. Dussault.
Mr. Donnelly.
Mr. Donnelly.
Monsieur Aubin.
Mr. Aubin.
Monsieur Nantel.
Mr. Nantel.
Ms. Malcolmson.
Ms. Malcolmson.
Ms. Ramsey.
Ms. Ramsey.
Ms. Kwan.
Ms. Kwan.
Madame Quash.
Madame Quash.
Mr. Blakey.
Mr. Blakey.
Monsieur Choquette.
Mr. Choquette.
Madame Moore.
Madame Moore.
Mr. Duval.
Mr. Duval.
Mr. Stetsky.
Mr. Stetsky.
Mr. Cannings.
Mr. Cannings.
Mr. Johns.
Mr. Johns.
Mr. McGregor.
Mr. McGregor.
Ms. Benson.
Ms. Benson.
Madame Trudel.
Madame Trudel.
Madame Sanssouci.
Madame Sanssouci.
Ms. Hardcastle.
Ms. Hardcastle.
Mr. Weir.
Mr. Weir. All those opposed to the motion will please rise.
Ms. Chager.
Ms. Chager.
Mr. Hare.
Mr. Hare.
Mr. O'Regan.
Mr. O'Regan.
Mr. Sargent.
Mr. Sargent.
Madame Joly.
Madame Joly.
Mr. Goodale.
Mr. Goodale.
Mr. Rodriguez.
Mr. Rodriguez.
Ms. Petitpot Taylor.
Petitpot Taylor.
Ms. Freeland.
Ms. Freeland.
Monsieur Leblanc.
Monsieur Leblanc.
Ms. Qualtrough.
Ms. Qualtrough.
Mr. Bryson.
Mr. Bryson.
Ms. Wilson-Raybould.
Ms. Wilson-Raybould.
Mr. Macaulay Cardigan.
Mr. Macaulay Cardigan.
Ms. Bennett.
Ms. Bennett.
Mr. Baines.
Mr. Baines.
Ms. Haidu.
Ms. Haidu.
Mr. Hussain.
Mr. Hussain.
Mrs. Philpott.
Mrs. Philpott.
Ms. Tassie.
Ms. Tassie.
Ms. Ing.
Ms. Ing.
Ms. Mahichuk.
Ms. Mahichuk.
Mr. Casey Cumberland Colchester.
Mr. Casey Cumberland Colchester.
Mr. Easter.
Mr. Easter.
Mr. McKay.
Mr. McKay.
Ms. Scrow.
Ms. Scrow.
Mr. Lausanne Château, La Petite Nation.
Mr. Lausanne, Argentine, La Petite Nation.
Mrs. McCrimmon.
Mrs. McCrimmon.
Ms. Jones.
Ms. Jones.
Mr. Algabra.
Mr. Algabra.
Mr. Leslie.
Mr. Leslie.
Mr. Carr.
Mr. Carr.
Ms. Gould.
Ms. Gould.
Mr. Sohi.
Mr. Sohi.
Mr. Champagne.
Mr. Champagne.
Mr. Holland.
Mr. Holland.
Ms. Monsef.
Ms. Monsef.
Mr. Garneau.
Mr. Garneau.
Ms. Duncan Etobicoke North.
Ms. Duncan Etobicoke North.
Ms. McKenna.
Ms. McKenna.
Madame Leboutillier.
Madame Le Boutillier.
Madame Bibot.
Madame Bibot.
Mr. Wilkinson.
Mr. Wilkinson.
Mr. Cusner.
Mr. Cusner.
Ms. Murray.
Ms. Murray.
Mr. Casey Charlottetown.
Mr. Casey Charlottetown.
Mr. Vaughan.
Mr. Vaughan.
Monsieur Lemetti.
Mr. Lemetti.
Mr. Miller, Ville-Marie, le Sud-Ouest et des Sœurs.
Mr. Miller, Ville-Marie, le Sud-Est, Île des Sœurs.
Monsieur Schiffke.
Mr. Schiffke.
Mrs. Romanato.
Mrs. Romanato.
Monsieur Hébert.
Mr. Hébert.
Mr. Eiking.
Mr. Eiking.
Mr. Bagnall.
Mr. Bagnall.
Mr. Paradis.
Mr. Paradis.
Mr. McGinty.
Mr. McGinty.
Mr. Nanda Sangri.
Mr. Nanda Sangari.
Mr. Fillmore.
Mr. Fillmore.
Mrs. Jordan.
Mrs. Jordan.
Ms. Goldsmith Goldsmith-Jones.
Goldsmith-Jones.
Mr. Oliver.
Mr. Oliver.
Monsieur Lefebvre.
Mr. Lefebvre.
Mr. Mendicino.
Mr. Mendicino.
Mr. Duguid.
Mr. Duguid.
Mr. Lamoureux.
Mr. Lamoureux.
Mr. McKinnon-Gatineau.
Mr. McKinnon-Gatineau.
Monsieur Lightbound.
Mr. Lightbound.
Ms. O'Connell.
Mr. O'Connell.
Mr. Varani.
Mr. Varani.
Monsieur Poisson.
Mr. Poisson.
Ms. Young.
Ms. Young.
Mrs. Schultz.
Mrs. Schultz.
Monsieur Vandal.
Mr. Vandal.
Ms. Cara.
Ms. Cara.
Mr. DeCourcy.
Mr. DeCourcy.
Mr. Scarpellegia.
Mr. Scarpellegia.
Mr. Sims.
Mr. Sims.
Mr. Tansey.
Mr. Tansey.
Mr. Jesnevsky.
Mr. Jesnevsky.
Mr. Dollywall.
Mr. Dollywall.
Mr. Pesky-Salido.
Mr. Pesca-Salido.
Madame Mendez. Madame Mendes. Mr. Oliphant.
Mr. Oliphant.
Monsieur Dubourg.
Mr. Dubourg.
Mr. Aldag.
Mr. Aldag.
Mr. Amos.
Mr. Amos.
Mr. Arsenault.
Mr. Arsenault.
Mr. Aria.
Mr. Aria.
Mr. Ayoub.
Mr. Ayoub.
Mr. Badaway.
Mr. Badaway.
Mr. Bayless.
Mr. Bayless.
Mr. Boissonneau.
Mr. Boissonneau.
Mr. Bossio.
Mr. Bossio.
Mr. Bettina.
Mr. Bettina.
Mr. Breton.
Mr. Breton.
Mrs. Cesar Chauvin.
Mrs. Cesar Chauvin.
Mr. Biddle.
Mr. Biddle.
Madame Lapointe.
Madame Lapointe.
Mr. Chen.
Mr. Chen.
Mr. Bruson.
Mr. Bruson.
Mr. Moff.
Mr. Moth.
Monsieur Drouin.
Mr. Drouin.
Ms. Zerowitz.
Mr. Zerowitz.
Mr. Assassi.
Mr. Assassi.
Monsieur Khoury.
Mr. El Khoury.
Mr. Ellis.
Mr. Ellis.
Mr. Erskine Smith.
Mr. Erskine
Mr.
Smith.
Ailson.
Mr. Ailson.
Mr. Fergus.
Mr. Fergus.
Mr. Finnegan.
Mr. Finnegan.
Mr. Fisher.
Mr. Fisher.
Mr. Fonseca.
Mr. Fonseca.
Mr. Fregascados.
Mr. Fregascados.
Mr. Fraser Westnova.
Mr. Fraser Westnova.
Mr. Fuhr.
Mr. Fuhr.
Mr. Gerritsen.
Mr. Gerritsen.
Mr. Graham.
Mr. Graham.
Mr. Greywall.
Mr. Greywall.
Mr. Hardy.
Mr. Hardy.
Mr. Harvey.
Mr. Harvey.
Mr. Housefather.
Mr. Housefather.
Ms. Hutchings.
Ms. Hutchings.
Mr. Yakino.
Mr. Yakino.
Mr. Johari.
Mr. Johari.
Mr. Levitt.
Mr. Levitt.
Mr. Long.
Mr. Long.
Mr. Longfield.
Mr. Longfield.
Ms. Ludwig.
Ms. Ludwig.
Mr. Maloney.
Mr. Maloney.
Monsieur Massé Vignon Lamitis Matan Matapédia.
Mr. Massé Avignon Lamitis Matan Matapédia.
Mr. May Cambridge.
Mr. May Cambridge.
Mr. McDonald.
Mr. McDonald.
Mr. McKinnon Coquitlam Port Coquitlam.
Mr. McKinney Coquitlam Coquitlam.
Mr. McLeod Northwest Territories.
Mr. McLeod Northwest Territory.
Mr. Morrissey.
Mr. Morris.
Madame Nassif.
Madame Nassif.
Mr. Peterson.
Mr. Peterson.
Monsieur Picard.
Mr. Picard.
Monsieur Rioux.
Monsieur Rioux.
Monsieur Robillard.
Mr. Robillard.
Ms. Rudd.
Ms. Rudd.
Mr. Rumi.
Mr. Rumi.
Mr. Rusnak.
Mr. Rusnak.
Ms. Sahota.
Mr. Hota.
Mr. Saini.
Mr. Saini.
Monsieur Sanson.
Mr. Sanson.
Mr. Sanga.
Mr. Sanga.
Monsieur Seri.
Mr. Seri.
Madame Shanahan.
Madame Shanahan.
Mr. Sheehan.
Mr. Sheehan.
Mr. Cedar Mission Masque Fraser Canyon.
Mr. Cedar Mission Masque Fraser Canyon.
Mr. Tabera.
Mr. Tabera.
Mr. Sorbera.
Mr. Sorbera.
Mr. Spengeman.
Mr. Spengeman.
Mr. Tan.
Mr. Tan.
Ms. Vandenbeld.
Ms. Vandenbeld.
Mr. Whalen.
Mr. Whalen.
Mrs. Zaid.
Mrs. Zaid.
Madame Fortier.
Madame Fortier.
Madame Lambropoulos.
Madame Lambropoulos.
Mr. Hogue.
Mr. Hogue.
Mr. Rota.
Mr. Rota.
Mr. Rogers.
Mr. Rogers.
Ms. Yip.
Ms. Yip.
Monsieur Beaulieu.
Monsieur Beaulieu.
Monsieur Plamondon.
Monsieur Plamondon.
Monsieur Boudria.
Monsieur Baudrillard.
Monsieur Sainte-Marie.
Monsieur Saint-Marie.
Monsieur Marcel.
Monsieur Marcel.
Monsieur Thériault.
Monsieur Thériault.
Madame Posé.
Madame Posé.
Monsieur Fortin.
Monsieur Fortin.
Monsieur Barcelou Duval.
Monsieur Barcelou Duval.
Ms. May Standish Gulf Islands.
Miss May Sanish Gulf Island.
Mr. Tutu.
Mr. Tutu.
Mr. Kung.
Mr. Kung.
Yeas pour 118, 118. Nays contre 176, 176.
I declare motion number 2 defeated. I therefore declare motions numbers 3 to 10 and 12 defeated. Madame Wilson-Raybould, appuyée par Monsieur Leblanc, propose que...
Seconded by Mr. Leblanc, moves that Bill C-75, an act to amend the Criminal Code, the Youth Criminal Justice Act, and other acts, and to make consequential amendments to other acts, as amended, be concurred in at report stage with a further amendment. Is it the pleasure of the House to adopt the motion? All those in favor of the motion will please say yea. All those who are opposed will please say nay. In my opinion, the yeas have it. All those in favor of the motion will please rise.
Hager.
Mr. Hager.
Mr. Hare.
Mr. Hare.
Mr. O'Regan.
Mr. O'Regan.
Mr. Sargent.
Mr. Sargent.
Madame Joly.
Madame Joly.
Mr. Goodale.
Mr. Goodale.
Mr. Rodriguez.
Mr. Rodriguez.
Ms. Petitpot Taylor.
Ms. Petitpot Taylor.
Ms. Freeland.
Ms. Freeland.
Monsieur Leblanc.
Monsieur Leblanc.
Ms. Qualtrough.
Ms. Qualtrough.
Mr. Bryson.
Mr. Bryson.
Ms. Wilson-Raybould.
Ms. Wilson-Raybould.
Mr. Macaulay Cardigan.
Mr. Macaulay Cardigan.
Ms. Bennett.
Ms. Bennett.
Mr. Baines.
Mr. Baines.
Ms. Haidu.
Ms. Haidu.
Mr. Hussain.
Mr. Hussain.
Mrs. Philpott.
Mrs. Philpott.
Ms. Tassie.
Ms. Tassie.
Ms. Ing.
Ms. Ing.
Ms. Mahichuk.
Ms. Mahichuk.
Mr. Casey Cumberland Colchester.
Mr. Casey Cumberland Colchester.
Mr. Easter.
Mr. Easter.
Mr. McKay.
Mr. McKay.
Ms. Scrope.
Ms. Scrope.
Monsieur Lausanne Chantal La Petite Nation.
Mr. Lausanne, Argentin de la Petite Nation.
Mrs. McCrimmon.
Mrs. McCrimmon.
Ms. Jones.
Ms. Jones.
Mr. Algabra.
Mr. Algabra.
Mr. Leslie.
Mr. Leslie.
Mr. Carr.
Mr. Carr.
Ms. Gould.
Ms. Gould.
Mr. Sohi.
Mr. Sohi.
Mr. Champagne.
Mr. Champagne.
Mr. Holland.
Mr. Holland.
Ms. Monsef.
Ms. Monsef.
Mr. Galno.
Mr. Galno.
Ms. Duncan and Etobicoke North.
Ms. Duncan, Etobicoke North.
Ms. McKenna.
Ms. McKenna.
Madame Leboutier.
Madame Leboutier.
Madame Bibo.
Madame Bibo.
Mr. Wilkinson.
Mr. Wilkinson.
Mr. Cusner.
Mr. Cusner.
Ms. Murray.
Ms. Murray.
Mr. Casey Charlottetown.
Mr. Casey Charlottetown.
Mr. Vaughan.
Mr. Vaughan.
Monsieur Lemetti.
Mr. Lemetti.
Mr. Miller Ville-Marie du Sud-Ouest des Sœurs.
Mr. Miller, Ville-Marie, du Sud-Est, Île des Sœurs.
Mr. Schiffke.
Mr. Schiffke.
Mrs. Romanado.
Mrs. Romanado.
Monsieur Hébert.
Monsieur Hébert.
Mr. Iking. Mr. Bagnall. Mr. Paradis. Mr. McGinty. Mr. Hernandez Sangri. Mr. Fillmore. Mrs. Jordan. Ms. Goldsmith-Jones. Mr. Oliver. Mr. Lefebvre. Mr. Mendicino. Mr. Duguid. Mr. Lamoureux. Mr. McKinnon-Gatineau. Mr. Lightbound. Ms. O'Connell. Mr. Varani. Mr. Poisson. Ms. Young. Mrs. Schultz. Mr. Vandal. Ms. Kara. Mr. DeCourcy. Mr. Scarpalegia. Mr. Sims. Mr. Tansey. Mr. Jesnevsky. Mr. Dollywall. Mr. Pesky-Salido. Madame Mendez. Mr. Oliphant. Mr. Dubourg. Mr. Aldaig. Mr. Amos. Mr. Arsenault. Mr. Aria. Mr. Ayoub. Mr. Badaway. Mr. Bayliss. Mr. Boissonneau. Mr. Bossio. Mr. Bertina. Mr. Breton. Mrs. Cesar Chauvin. Mr. Biddle. Madame Lapointe. Mr. Chen. Mr. Bruson. Mr. Moff. Mr. Drouin. Ms. Zerowitz. Mr. Assassi. Mr. Khoury. Mr. Ellis. Mr. Erskine-Smith. Ailson. Mr. Fergus. Mr. Finnegan. Mr. Fisher. Mr. Fonseca. Mr. Fragascatos. Mr. Fraser-Westnova. Mr. Fuhr. Mr. Gerritsen. Mr. Graham. Mr. Greywall. Mr. Hardy. Mr. Harvey. Mr. Housefather. Ms. Hutchings. Mr. Yakino. Mr. Jahari. Mr. Levitt. Mr. Long. Mr. Longfield. Ms. Ludwig. Mr. Maloney. Mr. Massé Avignon Métis Matin Matapédia. Mr. May Cambridge. Mr. McDonald. Mr. McKinnon Coquitlam Port Coquitlam. Mr. McLeod Northwest Territories. Mr. Morrissey. Madame Nassif. Mr. Peterson. Mr. Picard. Mr. Rioux. Mr. Robillard. Ms. Rudd. Mr. Rumi. Mr. Rusnak. Ms. Sahota. Mr. Saini. Mr. Sanson. Mr. Sanga. Mr. Seri. Madame Shanahan. Mr. Sheehan. Mr. Sidhu Mission Mascui Fraser Canyon. Mr. Tabera. Mr. Sorbera. Mr. Spengeman. Mr. Tan. Ms. Vandenbeld. Mr. Whalen. Mrs. Zaid. Madame Fortier. Madame Lambropoulos. Mr. Hogue. Mr. Rota. Mr. Rogers. Ms. Yip. Monsieur Beaulieu. Monsieur Plamondon. Monsieur Boudria. Monsieur Sainte-Marie. Monsieur Marcil. Monsieur Thériault. Madame Posé. Monsieur Fortin. Monsieur Barsalou Duval. Mr. Tutu. Mr. Kang. All those opposed will please rise. Mr. Nicholson. Ms. Finley. Ms. Gladue. Mr. Allison. Mr. Bazan. Ms. Rempel. Mr. Kent. Mr. Reyes. Mr. Poiliev. Mrs. Block. Mrs. McLeod Camels Thompson Caribou. Mr. Blaney Belchas Les Etchemins Lévy. Mr. Nuttall. Mr. Barlow. Mr. Bertod. Mr. Martel. Mr. Albus. Mr. Chong. Mr. Richards. Mr. Workington. Mr. Strahl. Mrs. Stubbs. Mrs. Vecchio. Mrs. Wong. Mr. Abu Taif. Mrs. Kuzi. Mr. Kelly. Mr. Generu. Mr. Tilson. Mr. Warwa. Mr. Sorensen. Mr. Zimmer. Mr. Reed. Mr. Lukiski. Mr. Nader. Mrs. Wagenthal. Mr. Broussard. Mr. Sweet. Mr. Anderson. Ms. Alislev. Madame Boucher. Mr. Lake. Mr. Calkins. Mr. Falk Provencher. Mr. Généreux. Mr. Gould. Mr. Kimmich. Mr. Macaulay Edmonton West. Mr. Lobb. Mr. Kitchen. Mr. Jennings. Mrs. Gallant. Mrs. Falk Battleford Lloydminster. Mr. Albrecht. Mr. Dreeshen. Mr. Hoback. Mr. McGuire. Mr. Cooper. Mr. Arnold. Monsieur Godin. Mr. Stanton. Mr. Lausanne-Stormont-Dundas, South Glengarry. Mr. Van Kesteren. Mr. Shipley. Mr. Iglinski. Mr. McKenzie. Mr. Yordega. Mr. Diot. Mr. Leipert. Mr. Shields. Mr. Viersen. Mr. Waugh. Mr. Weber. Mr. Motz. Mr. Benzin. Mr. Lloyd. Mr. Trost. Mr. Carroll. Mr. Julian. Madame Brosseau. Mr. Cullen. Mr. Angus. Mr. Massey Windsor West. Ms. Ashton. Ms. Matheson. Ms. Duncan Edmonton Strathcona. Mr. Christopherson. Mr. Garrison. Madame Boutin-Sweet. Ms. Blaney North Island Powell River. Mr. Rankin. Monsieur Dubé. Mr. Davies. Mr. Bouiris. Madame Laverdière. Monsieur Dussault. Mr. Donnelly. Monsieur Aubin.
Monsieur Aubin.
Monsieur Nautel.
Monsieur Nautel.
Ms. Malcolmson.
Ms. Malcolmson.
Ms. Ramsey.
Ms. Ramsey.
Ms. Kwan.
Ms. Kwan.
Madame Quash.
Madame Quash.
Mr. Blakey.
Mr. Blakey.
Mr. Choquette.
Mr. Choquette.
Madame Moore.
Madame Moore.
Mr. Duval.
Mr. Duval.
Mr. Stetsky.
Mr. Stetsky.
Mr. Cannings.
Mr. Cannings.
Mr. Johns.
Mr. Johns.
Mr. McGregor.
Mr. McGregor.
Ms. Benson.
Ms. Benson.
Madame Trudel.
Madame Trudel.
Madame Sanssouci.
Madame Sanssouci.
Ms. Hardcastle.
Ms. Hardcastle.
Ms. May Saanich Gulf Islands.
Ms. May Saanich Gulf Islands.
Mr. Weir.
Mr. Weir.
Yeas pour 175, 175. Nays contre 118, 118.
Je déclare la motion adoptée.
I declare the motion carried.
Quand ce projet de loi sera
When shall the bill be read a third time?
à la prochaine séance de la
At the next sitting of the House.
It being 6:42 p.m., the House will now proceed to the consideration of private members' business as listed on today's order paper.
Private members' business consideration at second reading of Bill S-240, an act to amend the Criminal Code and the Immigration and Refugee Protection Act, the trafficking in human organs in the name of Mr. Jimmy Smith.
Order, allowed. I would invite members to take their conversations into the lobby so that we can get started. Mr. Jennis, seconded by Mr. Rankin, moves that Bill S-240, an act to amend the Criminal Code and the Immigration and Refugee Protection Act, trafficking in human organs, be now read a second time and referred to the Standing Committee on Foreign Affairs and International Development. Debate, the Honourable Member for Sherwood Park, Fort Saskatchewan.
Thank you, Mr. Speaker. Two well-known Canadians, David Matas and David Kilgore, have uncovered something shocking. Their painstaking research unearthed that between 60 and 100,000 human organs are being transplanted in Chinese hospitals each year with virtually no system of voluntary donation in place. Most of the organs come from prisoners of conscience, primarily Falun Gong practitioners. I make this speech today in the presence of people who have been arrested in China and had their blood tested in prison. It may have been the only thing that prevented their victimization was that they did not match a potential recipient. They understand more than anything else, the importance of what is happening on the floor of the House today. Today I am moving a Senate bill to ask the House of Commons to rule on a fairly simple proposition, that the removal of vital human organs from living patients without their consent is morally unconscionable and must be stopped. Now, about a similar bill in the past, the Parliamentary Secretary has said this bill raises some complex legal and social policy issues. There is no doubt, though, that the moral issues raised by this bill are quite clear-cut. On the legal side, this bill has been well studied by the Senate. I believe it significantly improves on Bill C-350 that I proposed and also on the original Bill S-240, which was subsequently amended by the Senate committee to bring us the version that we have today. The legal issue is not particularly complex, but in an effort to stop this horrific practice, it does invoke the idea of extraterritoriality. That is, where a state seeks to punish someone for a crime that they committed elsewhere. This is relatively uncommon, although morally necessary in cases like this. Generally, states do not see it as their affair to prosecute crimes which take place elsewhere because the government of the state in which the crime occurs is best positioned to undertake that prosecution. The government ought not be indifferent to serious crimes committed by Canadians abroad, but is generally wise to leave the prosecution of those crimes to the state where they took place. But the normal practices should clearly not apply in cases where the local government is indifferent to, is unable to respond to, or is directly facilitating a grievous violation of fundamental human rights. In such cases, Canada can and must prosecute Canadians who go abroad to abuse human rights. Human rights do not apply any less to human beings in other countries. Nation-states provide the practical framework through which rights are generally identified and preserved, but should not be an excuse for allowing their own people to be complicit in grievous violations of human rights. In 1997, during the tenure of Liberal Justice Minister Alan Rock, Canada explicitly made it a criminal offence in Canada for a Canadian citizen or permanent resident to engage in so-called child sex tourism, that is, to go abroad and participate in the sexual exploitation of children. Exactly the same principle applies in this case. One notable difference, though, is that offences related to organ harvesting are probably easier to prosecute. Unlike someone who engages in the despicable practice of child sex tourism, someone who benefits from organ harvesting will have follow-up medical needs here in Canada. So this bill is morally necessary, and it follows a legal track well established. Now, a brief word on the legislative history of this initiative. My friend from Etobicoke Centre began this process on February 5th, 2008, with a very similar Bill C-500. He is, for those who don't know, a Liberal. C-561 was proposed by former Liberal Justice Minister Irwin Cotler in December of 2013, and I proposed Bill C-350 in this Parliament before Bill S-240, proposed by the very excellent Senator Salma Atulajan, was proposed in the Senate. So 4 bills, 10 years. And now we have less than 1 year until the next election. When the next election is called, every bill will die and we will go back to the beginning. 4 bills, 10 years, and fundamental human rights are at stake. If we do not proceed to a vote on this as soon as possible, I fear that we will significantly reduce our chances of getting this done this Parliament. 4 bills, 10 years, and cross-party cooperation and engagement up until now. Let's not force the victims to wait any longer. Let's pass this bill as soon as possible. Thank you.
Questions and comments? The Honourable Member for Winnipeg North.
Yes, thank you, Mr. Speaker. I appreciate the comments from my colleague across the way, and as he made reference to many different people that are supporting the initiative that is being presented, I just wanted to provide a very quick comment in regards to the many Canadians across Canada that have actually participated by petitions, whether one is in full support or doesn't support the legislation that my colleague has brought forward, to recognize that there has been a good deal of Canadians from all regions that have participated through petitions. I know that there have been a number of members of Parliament that have raised the issue on the floor over the years, and I just want to thank those individuals for taking the time to, at the very least, heighten the public awareness of what is an important issue. Ultimately, whatever happens on the legislation, we'll have to wait and see, but to recognize that there have been a significant amount of effort from a number of people outside of the House just to raise the profile of this issue.
The honourable member for Sherwood Park, Fort Saskatchewan.
Thank you, Mr. Speaker. I agree with the member. A great deal of work has been done. It underlines the importance of passing this bill as quickly as possible, ensuring we get this done to help the victims. Thank you.
Questions and comments? Questions et commentaires? The honourable member for. I'm sorry. Parkdale High Park. I'm sorry. It's getting late.
I thank the member for his contribution to this debate in terms of introducing this here in the chamber, the bill that originated in the Senate. And I want to ask him, in terms of the research he's done on the bill and the discussion of the bill thus far, if he could elaborate for the House his understanding of the practice of organ harvesting and organ trafficking, and what organs are we talking about, and where is this problem the most acute from his perspective?
The honourable member for Sherwood Park, Fort Saskatchewan.
Well, thank you, Mr. Speaker. This is a bill that does not name specific countries or speak to specific situations in the text of the bill. I think that's very important because there are new situations in which this type of practice could be done that we may not be seeing right now. That said, this bill does respond to a reality that exists in many countries of exploitation, whereby people's organs are taken without their consent, people are coerced, and it in particular responds to a practice that we know, a major issue that I referred to in the People's Republic of China, the forced organ harvesting, often involving political prisoners, Falun Gong practitioners very commonly. And this research has been done excellently by David Matus and David Kilgore. Many others have commented on this as well. And other countries have responded to this phenomenon by passing similar legislation. Taiwan, Israel, and there's other examples of countries that have passed similar legislation. It's striking how it was Canadians who did the initial research, and yet we're behind on passing legislation to address this problem. So let's catch up, let's lead, let's get this done as soon as possible so this law is passed before the next election.
Questions and comments? Questions et commentaires? Seeing none, or the honourable member for Winnipeg North, brief question, 30 seconds, and we'll have a 30-second answer.
Yes, thank you, Mr. Speaker. The member across the way made reference to Irwin Cotler, someone that we know is fairly well respected on all sides of this House. And if my friend can just I guess more so provide that perspective in a very clear and concise way as to what Mr. Cotler is actually saying on the legislation.
The honourable member for Sherwood Park, for Saskatchewan.
Thank you. Mr. Cotler is very supportive of the legislation.
Resuming debate, reprise du débat, the Honourable Parliamentary Secretary to the Minister of Justice.
Thank you, Mr. Speaker. I'm very pleased to be able to participate in the second reading debate this evening on Bill S-240. As has been discussed already, the bill would enact new offences to target organ trafficking and to make those who engage in such conduct inadmissible to Canada. Illegal organ trafficking is a growing problem around the world. According to the World Health Organization, kidney transplants occur in 91 different countries around the planet, with liver and heart transplants also occurring with some regularity. Yet, despite there being a legal and regulated environment in which these life-saving procedures occur, the demand for organ transplant surgery far outweighs the supply. For this reason, we are actually seeing a rise in the new form of crime, organ trafficking. Although it's important to note that no known cases have occurred in Canada. According to some estimates, 10,000 kidneys are traded on the underground market each year. I'm very troubled to have learned about some of the numbers and circumstances surrounding organ trafficking and the fact that, as with other types of crime, it is often the most vulnerable members of society who find themselves at the greatest risk to be victimized. In countries around the world, impoverished individuals may be provided little or no money in exchange for a kidney. News articles have noted that the average payment for a kidney may be around $5,000, and in many cases there is no payment provided. In contrast, the average purchaser will spend well in excess of $100,000 to be provided with a new organ. It is clear, given those facts, that there's a great deal of money being made for those who operate in this illicit marketplace, Mr. Speaker. In my very own riding of Parkdale High Park, constituents have approached me to raise their concerns specifically about the practice of organ harvesting. Political prisoners, including Falun Gong practitioners mentioned by my friend opposite, have been subjected to organ harvesting in order to support the trade in human organs, and these abuses are ongoing. I'm happy that the member from Sherwood Park, Fort Saskatchewan, raised the issue of former parliamentarian David Kilgour in his 2006 report. That report documented the many Falun Gong adherents who have been killed to supply the organ transplant industry. In that report, Kilgour stated that he and his fellow researchers, quote, believe that there have been and continue today to be large-scale organ seizures from unwilling Falun Gong practitioners. La majeure partie du trafic d'organes humains est...
Much of the organ trafficking trade is fueled by the fact that patients from wealthy countries cannot access the needed life-saving organs in their home countries, and so turn to help in other countries where organs can be purchased. Bill S-240 seeks to target organ trafficking through the enactment of new offenses in our criminal code. Safety of human cells, tissues, and organs for transportation regulations are an important issue, and the sale and purchase and dealing with them is strictly prohibited. I'd also like to note that the Criminal Code already prohibits trafficking in persons for the purpose of organ removal. This offense targets the exploitation of others, and exploitation is defined in the Criminal Code to include causing a person, by means of deception or use of threat or force or any other form of coercion, to have an organ or tissue removed. End quote.
S-240 seeks to focus on the demand side of organ trafficking. It does this through the proposed 4 new offences included therein that would apply to situations where Canadian citizens or permanent residents travel abroad and engage in conduct that would be prohibited if it occurred here in Canada. 3 of the bill's 4 offences are focused on the situation where an organ is removed from one person in order to be transplanted into another in a situation where there's proof that the donor did not provide informed consent. Bill S-240 was actually amended in the Senate to provide a concrete definition of informed consent, which is as follows. Quote, consent that is given by a person capable of making decisions with respect to health matters and with knowledge and understanding of all material facts, including the nature of the organ removal procedure, the risks involved, and the potential side effects, end quote. Mr. Speaker, this presents a challenge. I wanted to underscore this for the purposes of this debate, as proof of this would require evidence that the accused knew that they obtained an organ from someone who did not offer informed consent, which would in turn require evidence that the accused knew that the person providing the organ had the requisite knowledge level. It is quite possible that the accused will have no information concerning who the person providing the organ was, let alone their knowledge of the risks associated with the transplant procedure. I'm looking forward to following the debate on this bill on this particular point. In targeting the demand, Bill S-240 would also allow Canada to assume extraterritorial jurisdiction. This was outlined by the member opposite, and prosecute cases here at home, even where the conduct occurred abroad and was committed by Canadians or permanent residents. This is laudable and perhaps very appropriate given the fact that much of the conduct targeted by this bill occurs abroad. Nevertheless, I would highlight for the purposes of this opening debate that extraterritorial investigations and prosecutions are indeed challenging. They require police-to-police cooperation, as well as more formal methods of international cooperation in order to secure the necessary evidence. Frequently, they involve Canadian police officers traveling abroad, and of course, they require the accused to either be present here in Canada or to be returned to Canada. Such investigations are costly, and they will be borne by the provinces and territories who are responsible for the administration of justice. These matters are worthy of close consideration by all of us as we examine Bill S-240 more closely. Another aspect of Bill S-240 is the proposal to establish a reporting mechanism in order to track organ transplants in Canada. Under the proposed Section 240.2 of the Criminal Code, medical practitioners under this bill would be required to report to a federally established body made via Governing Council appointment information concerning the fact that a person they've treated received an organ transplant. This requirement would apply in all cases, Mr. Speaker, including in respect of organ transplants that occur right here in Canada. This begs the question, Mr. Speaker, whether such an approach is necessary, given the purpose of S240 is focused on illicit organ trafficking abroad. There can be no doubt to anyone in this House that illicit organ trafficking merits serious consideration and appropriate responses from all governments, including our own here in Canada. Even though it does not appear to be a significant problem, domestically we should not take an approach that treats this issue as a problem that does not concern us. Like all forms of transnational crime, criminals find ways to exploit loopholes in the international legal framework. In this respect, it is right for us to be examining our laws, programs and policies to ensure they are as comprehensive and effective as they can be. And I would highlight here at this point, Mr. Speaker, some of the comments made by my friend opposite in introducing this bill in this House that had come from the Senate, when he underscored the fact that there have been successive efforts made by parliamentarians on both sides of the House to address this important issue. It is an important issue. It's one that we take very seriously as parliamentarians. It is one that all parliamentarians in elected legislatures literally around the planet need to take seriously in light of the fact that an illicit underground market has occurred for organs, and that underground market is actually exploiting vulnerable individuals in various nations around the planet, whether it's in respect of kidney harvesting, liver, heart transplants, etc. These are concerns that we need to draw attention to. That is why we're looking forward to concrete debate today and in the days and weeks to come on this bill to ascertain its merits. Thank you very much, Mr. Speaker.
Resuming debate, reprise du débat, the honourable member for Victoria.
Thank you very much. Thank you very much, Mr. Speaker, and I'm very honoured to rise and debate this matter. I'm pleased as well to second this bill brought to us by the honourable member for Sherwood Park, Fort Saskatchewan, and of course it's the work of Senator Toulajan from the other place, the Senate, that led us here. I understand the bill passed with enormous support in the other place, and I'm hoping it has the same level of support here in this place. Canada is, of course, a little bit behind the times on this. I note, for example, that the Europeans have for quite some time had a convention entitled the Council of Europe Convention Against Trafficking in Human Organs. And for the honourable member has already set out the cross-party support that such an initiative has had in this place for very many years. And it seems to me, Mr. Speaker, that the time has come to join the Europeans and other countries to deal with the scourge of trafficking in human organs that this bill seeks to address. I note that the bill is to amend the criminal code to create a new offence in relation to trafficking in human organs and tissue. It also amends the Immigration and Refugee Protection Act to provide that a permanent resident or foreign national is inadmissible to Canada if the Minister of Citizenship and Immigration is of the opinion that they have engaged in any activities relating to trafficking in human organs or tissue. The Honourable Parliamentary Secretary pointed out, I think quite properly, the difficulties sometimes of going after people in other jurisdictions. Of course, that hasn't stopped Canada dealing with sex trafficking, as has been pointed out, sex tourism as it's called. We know that's the case. Also, there's a section in Bill S240 that requires any proceedings to be instituted only with the consent of the Attorney General, therefore making it likely that we can address these practical problems to which he made reference through that intermediary. Mr. Speaker, the scourge of organ trafficking is absolutely appalling, and its exponential growth as well should cause concern amongst every member of this place. In her speech, the Senator referred to situations that sound like horror movies. Waking up in a weary haze in an unfamiliar house on the outskirts of Delhi, a gentleman named Khan was greeted by a stranger in a surgical mask and gloves. As he began to ask where he was and what had happened, he was told curtly, "Your kidney has been removed." In another expose published in the Haaretz newspaper, describing just earlier this year thousands of Sudanese refugees living in Cairo who have fallen victim to the illegal organ trade. And Mr. Speaker, these people are amongst the most desperate, and they're easy prey for people who can simply push them aside, often by putting a mask with anesthesia over their mouth, take them to the back of a private clinic and remove most popular organs being kidneys, livers, and others, and then send them back home after a while, still drugged, maybe unconscious, put them back in their house without the organ in question. And so Professor Sean Coulomb of Liverpool University published last year a study showing a connection between the organ harvesting industry and the societal exclusion of minorities and refugee groups in Cairo. This is a huge problem. It's growing exponentially, according to the experts, in part, as the parliamentary secretary pointed out, due to the fact that the demand has grown and the supply has become limited. And I feel that there's been some practical steps taken in this place. Just recently, the member for Calgary Confederation has introduced in the House addressed Bill C-316, which would deal with information from tax records being used for an organ donor registry, another initiative that I was proud to second and support, because as the population ages, the demand is likely going to increase, and these crimes by organized criminals are going to only increase. Now, I don't want to take much time on this bill. To me, it's a quintessential no-brainer, Mr. Speaker. I want to join the Europeans. I want to join others around the world that are recognizing the scourge of organ trafficking, and as a Canadian, stand proud with them and deal with this very real problem. As my friend has said earlier, we don't have any problem if we can come together, as other jurisdictions have done, and say, let's get this done in this Parliament to make a difference in people's lives right now. Thank you, Mr. Speaker.
Resuming debate, the Honourable Parliamentary Secretary to the Government House Leader.
Yes, thank you, Mr. Speaker, and it's a pleasure to rise to address what is a really important issue that many are following. And I suspect if we take a look at the number of issues that have come before the Chamber, you will find that the whole issue of organs, organ donations, and today we're spending a bit of time talking about the harvesting of organs in an unethical manner, in good part, is something that I am very personally much interested in. And I hope to see members from all parties contribute to the debate. We have seen that in previous private members' bills or resolutions where we talk about the importance of recognizing the roles that the different stakeholders have to play in, for example, in getting organ banks, Mr. Speaker, or having a way or a mechanism that enables those that are prepared to donate an organ. I was actually pleased with my colleagues' comments in regards to having the individual that is prepared to donate an organ to be fully aware of what it is that he or she is offering to be able to do. That's a very important point. That's a point in which we've heard a great deal of discussion on both sides of this House, Mr. Speaker. You know, one of the other aspects of that debate has been recognizing that it's not just the House of Commons, that in fact it entails having Ottawa work with the different jurisdictions, our provinces, territories, and possibly other stakeholders, Mr. Speaker, in order to be able to deal with this particular issue. We recognize right at the very beginning that it is an international issue. International issue of grave consequence that's having a serious impact around the world. Even though, to the best of my knowledge, there has never been a case cited here in Canada, we have still seen Canada play important roles in terms of leaderships and trying to convey a very strong message on important issues. the first question I had asked my colleague across the way was in regards to a petition. I first heard about this issue, Mr. Speaker, through a group of individuals in my own community of Winnipeg, where they had taken the time to try to explain the issue to me personally. It's fairly offensive in terms of just to the degree in which that exploitation is in fact taking place. And I think that a good number of Canadians, if not a vast majority of Canadians, would be very surprised. I've had the opportunity, as other members have, to travel outside of Canada, and I've seen members of the Falun Gong group actually promoting and encouraging and making that higher sense of public awareness that even goes far beyond our borders. And that is, in part, for me, one of the reasons why I didn't have a problem or an issue at tabling petitions on it, Mr. Speaker. And if I reflect on some of those petitions, it highlights what the core of the issue really is. It recognizes, for example, Mr. Speaker, that the Falun Gong is a traditional Chinese spiritual discipline which consists of meditation, exercise, and moral teachings based on the principles of truthfulness, compassion, and tolerance. You know, it makes reference to the fact of an incident back in 1999 where we had the Chinese Communist Party, which launched an intensive and nationwide persecution campaign to eradicate Falun Gong. And this is the type of issues that are being raised through petitions. And I would suggest to you that it does more than just make us inside this chamber aware, because it's engaging citizens, Mr. Speaker, in a very real and tangible way by requesting them to look at the petition, try to better understand the issue, and then to sign in support of it, Mr. Speaker. You know, it talks about David Matas, someone that has been referenced, someone that I personally have known for many, many years. And the former Canadian Secretary of the State for Asia Pacific, David Kilgour, who conducted an investigation back in 2006 and concluded that the Chinese regime and its agencies throughout China have put to death a large number, in the tens of thousands, Mr. Speaker, of Falun Gong prisoners of conscience. Their vital organs were seized involuntarily and for sale at a high price. Many doctors that were against forced organ harvesting has got about 1.5 million petition signatures over the years from countries all over the world, Mr. Speaker. This here is making reference to 50-plus countries. To the United Nations, the High Commissioner for Human Rights calling for immediate action to end the unethical practice of forced organ harvesting in China, and calls for an end of the persecution of the Falun Gong. Mr. Speaker, when we take a look at the European Parliament, we have seen some actions to date where there was a resolution that was condemning organ harvesting abuse in China. And it called on the government of China to end immediately the practice of harvesting organs from prisoners of conscience. Mr. Speaker, there's one of the things that somewhat surprises me, and again, to the very best of my knowledge, we haven't seen a motion or a resolution to that effect. This is a number of attempts by private members to bring forward legislation. There appears to be a number of outstanding issues or concerns that we're hoping to kind of draw out during this second reading debate and the debate that might follow it in the coming days, Mr. Speaker, to try to address some of those concerns. In part, it has been raised already. You know, the people that were signing these petitions were asking, in good part, for the Government of Canada to take action. This is not something that's new. It's been there for a number of years, as my friend has pointed out. Even former Prime Minister Stephen Harper was unable to get it to an ultimate vote. And we'll have to see in terms of what takes place here, Mr. Speaker. We recognize, for example, the issue of the criminal code. Many of the aspects within the legislation that is being proposed today, from what I understand, is covered already within the criminal code. Maybe not directly, but definitely indirectly, which is dated back to 2005, where the criminal code was in fact amended. And what I would reference, Mr. Speaker, is that we look at 279.01 to 279.05. The main trafficking in persons offense prohibits engaging in specified types of conduct in order to exploit or facilitate the exploitation of another person. Exploitation is defined broadly and includes causing a person by means of deception or the use of or threat of or force or of any other form of coercion to have an organ or tissue removed. In addition, it is an offense to receive a financial or material benefit knowing that it was derived from trafficking in persons. The concept of a material benefit is sufficiently broad to encompass the receipt of an organ in cases where the recipient knew the organ was obtained through deceit or any other form of coercion. Canada's human trafficking offences also apply extraterritorially. Look at subsection 7, bracket 4.11, Mr. Speaker, and therefore can be used to prosecute in Canada Canadians or permanent residents who commit human trafficking offences abroad. Mr. Speaker, there's also provincial statutes that prohibit sales, purchase, and dealings in human tissues or organs outside the applicable regulatory framework. Mr. Speaker, the point is, in good part, is that there are a number of issues. Just like I'm sure former Prime Minister Stephen Harper had recognized that as a government that we are looking at all aspects. We hope that members across the way will maybe pick up on some of those points and possibly expand on it, Mr. Speaker. What we do know is there is an obligation for the government to work with other stakeholders, in particular, let's say, our provinces and our territories, to listen in terms of good part what the Canadians have to say, and we'll have to wait and see how this debate ultimately evolves. Thank you for the opportunity to share a few thoughts, Mr. Speaker.
Resuming debate, reprise du débat, the honourable member for Edmonton Centre.
Thank you very much, Mr. Speaker. I appreciate the opportunity to speak to Senate Public Bill S-240, which proposes amendments that seek to tackle, as we've heard this evening, an issue of concern internationally and to Canadians, the illicit trafficking of human organs. And now, before I discuss the substance of this relatively small but important piece of legislation, I would like to spend a few minutes discussing the issue on which it focuses. And this is an issue that I mentioned is one that has affected many other countries around the world. And yet, as my honourable colleague from Winnipeg has said, it's important to note that, to our knowledge, no known cases have yet occurred in Canada, and nor would we want them to. Organ trafficking is a lucrative and dangerous form of transnational organized crime. And according to a 2015 study by the United Nations Office on Drugs and Crime, this activity purports to net in excess of $1 billion US annually in illegal profits. What this illicit revenue is used for can be far-reaching, but one can well imagine that some of it is funneled into other criminal ventures, which can undermine public safety, fuel corruption, and negatively impact on the rule of law. It's also important, I think, for members to understand what it is we're talking about when we say organ trafficking. According to the Council of Europe Convention Against Trafficking in Human Organs, the only international treaty on this issue, the Trafficking in Human Organs, includes the removal of organs from another person who has not provided free, informed, and specific consent, or has received a financial benefit in exchange for the removal of organs. And we know that organ trafficking puts lives at risk. Medical procedures that might be performed in substandard and unregulated environments can impact those whose organs are being removed or those who are seeking organs themselves. Quite simply, this is appalling, and dangerous business and requires a strong legislative and operational response. So it is, Mr. Speaker, against this backdrop that I would like to turn my attention to the substance of Bill S-240. And as I said earlier, this legislation is short and proposes amendments to both the Criminal Code and to the Immigration and Refugee Protection Act. But despite the protests of my colleague across the way, there are still some questions that we must address. Now let's start first with the Criminal Code proposals, the most significant of which relate to the creation of new criminal offences punishable by considerable periods of imprisonment. Bill S-240 would enact 4 new offences targeting organ trafficking and related conduct. Now, the first offence at paragraph 241, subsection 1A, would prohibit obtaining an organ in order for it to be transplanted into one's body, and in a situation where the person who has received the organ knew or was reckless as to whether or not the person who provided the organ gave informed consent. This particular proposed offence appears to focus or be focused on the beneficiary of the organ and not on anyone else who may be involved in organ trafficking generally. The second offence proposed at paragraph 240, subsection 1B, however, is more squarely addressed at the facilitators. Now, this offence would target those who carry out, participate in, or facilitate the removal of an organ in cases where they know or were reckless as to whether or not that person had provided informed consent to have their organ removed. The third offence at paragraph 241(1) subsection C would address those who enable illegal organ removals by prohibiting acting on behalf of or at the direction of or in association with a person who has removed an organ and where the accused knows that the organ was removed from someone who has not provided informed consent or was reckless as to that fact. Finally, Bill S-240 proposes an offence at subsection 240.1 paragraph 3 to target those who are involved in obtaining of an organ for consideration. Now, in essence, this offence would make it illegal to obtain an organ for money, even in cases where the organ is provided by someone who has provided free and informed consent. Now, as I mentioned, these proposed offences are subject to significant maximum penalty, imprisonment of 14 years. As with the other indictable offences, a sentencing court would also have discretion to impose a fine in any amount. And Mr. Speaker, I'm interested in our discussion of these proposed new offences, and I say this because I have a number of questions surrounding these proposed new offences, and while I won't be able to raise all of them here this evening, I wonder, for example, whether it is the role of Parliament to use criminal law to target someone who has purchased an organ, perhaps in another country, where it may be legal to do so, in a situation where the individual who has provided the organ did so freely, in a safe manner, and under circumstances that were closely regulated. This type of action would be captured by the bill because the bill also proposes to allow the prosecution in Canada of Canadians who go abroad to purchase organs. These are extremely difficult and complicated situations. And I can well understand why some who are faced with the prospect of serious health consequences or even death and who cannot otherwise obtain a necessary organ might look to other options for saving themselves or that of someone they love. Now, on the other hand, I also recognize the motivation behind the proposal and the need to ensure that individuals, often from developing countries and who may be vulnerable to abuse given their own economic situation, are protected from potentially exploitative practices. Bill S-240 proposes a definition of informed consent, which would be a key feature of these new offences. I would note that as introduced, the bill did not propose to define this term, but that a definition was added by the Senate out of concern for the need to be clear in the law, particularly given we are talking about criminal offences. From my own perspective, I welcome the changes by the Senate in this regard and that they try to make the law clear and clearly understood. At the same time, the Senate committee did not appear to consider the impact of this change in any significant detail, and I wonder, for example, whether this definition of informed consent is consistent with the approach that is taken in the medical assistance in dying legislation, or whether defining it in the criminal code in the manner that has been done is consistent with how that term is understood in health law context. I look forward to hearing more and considering these points further. I would also like to comment briefly on the changes proposed to the Immigration and Refugee Protection Act, which would result in someone who has engaged in conduct captured by 3 or 4 of the proposed offences being inadmissible to Canada. Now, in thinking about this proposed change, I wonder whether or not it is, strictly speaking, essential, given that the current laws on inadmissibility already address criminality and organized criminality. I am curious as to why the offence prohibited the receipt of an organ for money would not provide a basis for excluding someone from Canada when the other newly proposed offences would. Mr. Speaker, there can be no doubt that Bill S-240 is targeting an important issue and that this issue is deserving of our attention. Yet, as we are talking about the criminal law, one of the most blunt and powerful instruments available to government is that critically important that we do our due diligence and fully examine the proposals contained in this bill and the full range of consequences that flow from its changes. Having worked on Bill C-75 with several hundred clauses, Mr. Speaker, I can tell you that when you are in the cut and thrust of such legislation, it is hard work. You need to do the homework, and you need to take the time to make sure that the laws that we pass in this country are fair and balanced for all concerned. Thank you, Mr. Speaker.
Resuming debate, reprise du débat. The Honourable Parliamentary Secretary to the Minister of Immigration.
Thank you very much, Mr. Speaker, and thanks to everyone in this House who have participated in debate on this S-240 private members' business relating to trafficking in human organs. Mr. Speaker, to begin, let me just clearly state that our government is entirely committed to ensuring that our criminal justice system keeps communities safe, that it protects victims, and that it holds offenders to account. Additionally, Mr. Speaker, our government has a proven record over the last 3+ years of presenting a solid face on the international stage as relates to trafficking in organs, to trafficking in people, to the illicit trafficking of arms exports. Members in this House will recall that not too long ago, under the leadership of our Foreign Affairs Minister, our government introduced Bill C-47, which would allow Canada to accede to the Arms Trade Treaty to ensure that the sale of arms to other state entities were not going to places where they could contravene international law, where they could cause all kinds of horrific things to occur. And quite frankly, Mr. Speaker, we introduced that bill, and we believe in the philosophy that belies that bill because we understand the importance of global human rights, of the equality of human dignity, of ensuring that international law is upheld. And we certainly share that philosophy when it comes to any and all other matters that concern trafficking and activities that occur across borders in illicit ways. And that would relate as well to the trafficking in human organs. Mr. Speaker, peut-être que je pourrais réitérer en français.
Perhaps I might repeat in French for the benefit of those who are watching us at home across Canada. Our government has committed to make sure that our justice system, our criminal justice system, it protects victims, ensures the safety of our communities, and prosecutes criminals. And, Mr. Speaker, we want to make sure that this kind of traffic in human organs, we would like to put an end to it worldwide. This is why we have a justice system in Canada which acts in a way that Canada is on guard against this kind of thing. And we know that abroad, we don't want these things to happen anywhere in the world.
Furthermore, we certainly condemn the illegal and exploitative trade of human organs in the strongest terms, and we say that both in Canada and on the international stage, and you can be sure, Mr. Speaker, that those officials who represent Canada at embassies and in international forums abroad would share that same message. Again, as would all members on the government side of the floor, both when meeting with constituents in their home ridings and representing the government from coast to coast to coast, and when they travel abroad to represent the government of Canada and all Canadians on the international stage. Mr. Speaker, organ transplantation and donation is governed by a comprehensive legislative framework at both federal, provincial, and territorial levels, and encompassing health and criminal law. So as you can imagine, Mr. Speaker, We're talking about significant coordination between different federal departments and agencies who all have to work together to ensure that we can guard against the trafficking of human organs. And it takes cross-jurisdictional and bi-jurisdictional conversations as well to ensure that at a provincial and a territorial level, officials and public safety officials as well are ensuring that these sorts of things can be snuffed out, can be guarded against, and as much as possible that we prevent this sort of trafficking, as we prevent trafficking in drugs and in humans and in human smuggling here at home, and when things arrive at our borders or on our shore. And we want to make sure that we take a public health approach when we look at these sorts of things as well, to make sure first and foremost that we're looking after the safety, security, health, and well-being of Canadians. And when we do that at home, we have the ability to share that story around the world and work with other partners on the international scene who may not have the same level of capacity that Canada has to deal with these issues. And it's a lesson, and it's something that we share across the world. Where we have the capacity to step up and lead, Canada always has. It's certainly been the story under this government. Mr. Speaker, we have to be aware of trafficking in humans and organs and other illicit goods, especially in the context of increased migration and increased flows of people who are on the move, more so than we've seen since the end of World War II. Many cases, people fleeing persecution, fleeing in some cases gang violence and other activities that cause them both personal, physical, mental, and psychological harm. And so it's important that we understand why people are on the move, what other illicit activities could be camouflaged in with people moving around, and how we guard against seeing any at all trafficking, but certainly a proliferation of trafficking of things like human organs, and or the trafficking again of persons or other illicit goods. Another point, Mr. Speaker, that I'll make is that the Criminal Code in Canada currently prohibits the removal of an organ without the informed consent of the donor. Think of if we had lacking that provision in our Criminal Code, how terrible it would be to have an organ removed without one's consent. We've taken steps in this country to ensure that that's not the case. It's reflected in our view that human dignity is something to be upheld in all cases, and consent of someone to have an organ removed is something that we certainly uphold here in Canada. Et encore pour le bénéfice des gens.
And again, for the benefit of people watching us on television, I'd like to reiterate that the Criminal Code prohibits organ transfers without the agreement of the donor.
It might be worth just re-emphasizing for those who have been watching over the last few minutes how important we take, and seriously we take, the issue of the trafficking in human organs, just like we take all matters that would have a negative or deleterious effect on the health, well-being, safety and security of Canadians or on the Canadian population. I hear one of my colleagues snickering about my use of the word deleterious, and I would encourage that colleague to look it up and perhaps use it in a debate in the House here before the end of the coming session. I'm sure he will find that usage of such words can be helpful in really painting a picture of the negative consequences that not addressing these issues seriously can have, again, on individual Canadians and on our population as a whole. Monsieur le Président, je viens...
Mr. Speaker, I've just emphasized the importance of bringing attention to these issues, about how important it is to speak about this and about the negative effects of trafficking in human organs, and speaking out loud and clear on the international stage, and about continuing to be a leader on these issues and other issues which affect the safety and security of people and in Canada and worldwide. Resuming debate.
Order. The honourable member for Sherwood Park, Fort Saskatchewan.
Thank you, Mr. Speaker. In light of the urgency of this, and I think the direction in which the debate is going makes clear that the key arguments have been made, I would seek unanimous consent at this point to deem the motion adopted at second reading stage so we can proceed to the urgently needed study at committee, review any amendments that are forward that allow us to move forward with this bill. I'm seeking unanimous consent for that motion.
Absolutely.
Yep.
We have no, we don't. Unfortunately, we don't have unanimous consent. Resuming debate, the Honourable Parliamentary Secretary to the Minister of Science. I just want to point out that she'll have about 9 minutes, and then we'll have to call it a night for this debate. The Honourable Parliamentary Secretary.
Thank you very much, Mr. Speaker, and thank you to my honourable colleague for bringing this to the House. I think it's an important debate that we need to have, and it will be a debate that will continue, I'm sure. And what has been stated before, of course, is very true. Our government is committed to ensuring that our criminal justice system keeps communities safe, protects victims, and holds offenders to account. And of course, we condemn the illegal and exploitive trade of human organs in the strongest of terms. Organ transplantation and donation is governed by a comprehensive legislative framework at both the federal and provincial territorial levels, encompassing health and criminal law. The Criminal Code currently prohibits the removal of an organ without the informed consent of the donor. And I think that last part is especially worth noting, informed consent. That is, in and of itself, the most important part of any discussion about human organ donation. Organ trafficking is, of course, a growing concern internationally, and I appreciate the fact that this has been brought to the House to debate. But no known cases have occurred in Canada, and we, of course, hope that that never happens. In Canada, organ transplantation and donation is governed by, as I mentioned, a comprehensive legislative framework at both federal and provincial territorial level. Health regulatory offences apply where organs are removed, transplanted outside the regulatory framework, while criminal laws apply where the organ donor did not consent or was coerced. More specifically, provincial statutes prohibit the sale, purchase, and dealing in any human tissues or organs outside this regulatory framework. These laws require the explicit consent of the donor or next of kin in the case of deceased donation. Federally, the safety of human cells, tissues, and organs for transplantation regulations administered by Health Canada prohibit transplant activities unless carried out by a registered establishment. You know, in Canada, we talk a lot about encouraging people to donate organs, and it's an ongoing issue. We all, I think probably everyone in this House, knows someone who has been on that waiting list, waiting sometimes months for an organ transplant. And we have to encourage Canadians to make sure that they sign up so that they can become organ donors if, in fact, the situation arises where they would be considered a donor. And that is what we need to address too in this House, is to encourage education so that people understand the differences between consent of an organ and what is actually going on around the world that I agree is abhorrent in nature. The Criminal Code also includes a number of general and specific offences that can respond to the conduct targeted by this bill, Bill S-240. In 2005, the Criminal Code was amended to enact a number of specific offences that comprehensively address all aspects of trafficking in persons. And for those who want to look it up, it's sections 279.01 and to 279.04. The main trafficking in persons offense prohibits engaging in specified types of conduct in order to exploit or facilitate the exploitation of another person. Exploitation is defined broadly and includes causing a person by means of deception or the use or threat of force or of any other form of coercion to have an organ or tissue removed. Coercion, consent, those are the two main words in this discussion. In addition, it is an offense to receive a financial or material benefit knowing that it was derived from trafficking in persons. The concept of material benefit is sufficiently broad to encompass the receipt of an organ in cases where the recipient knew the organ was obtained through deceit or any other form of coercion. And it's terrible to think that people get so desperate in this world that they know that the organ that they are receiving has been taken from another human being without their consent or through coercion. That is the worst possible point of this bill that we must address. Canada's human trafficking offences also apply extraterritorial and therefore can be used to prosecute in Canada Canadians or permanent residents who commit human trafficking offences abroad. So Canadians who travel abroad and who knowingly go there in order to have an operation, in order to receive an organ from someone who was either paid or coerced, that has no place in our civilization. In addition to the human trafficking offences, criminal offences of general application could also be used to respond to organ trafficking. Depending upon the facts of the case, aggravated assault, unlawfully causing bodily harm, uttering threats, organized crime offenses, or extortion could all be used to address organ trafficking conduct involving coercion of the organ donor, and all are punishable by significant penalties of imprisonment, as they should be. These provisions, however, do not have extraterritorial effect. So there are some real important issues that need to be discussed, and I'm certainly glad that my honourable colleague has brought this forward. Trafficking in human organs is something that no one in this House would agree with, I'm sure. It needs to be debated, though, because there are laws that may conflict with this bill, and we need to make sure that we get it right. It's certainly something that I think as a government we are looking into and need to really address, need to have that discussion both here in the House and possibly at a committee stage. This is something that I think will need to be addressed. We all can understand that some people take matters into their own hands, and certainly there have to be rules and regulations around trafficking in human organs to make sure that people are not either leaving Canada to have an operation to get an organ in this way, but we also have to educate people in Canada to the fact that yes, organ donation is a very positive thing to do, but you have to be able to consent, and no coercion can be involved at all. Thank you very much, Mr. Speaker.
The time provided for consideration of private members' business has now expired, and the order is dropped to the bottom of the order of precedence on the order paper. À l'ordre, à ce moment-ci, conformément à l'article 38.
Pursuant to Standing Order 38, a motion to adjourn the House.
Order. 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 Excuse me. Do I have to name the two members who insist on shouting across the floor? They're more than welcome to meet on the side or behind. Now that they're gone, one of them is gone anyways, we'll continue. À l'ordre. À ce moment-ci.
Order. Pursuant to Standing Order 38, a motion to adjourn the House is deemed to have been made and seconded at this time. Therefore, the question is that this House do now adjourn.
Nipissing Pembroke.
Thank you, Mr. Speaker. On June 14th, I asked the Prime Minister a very specific question. I asked how much the Liberals' new carbon tax was going to cost Canadians. While Canadians listening to the official reply from the government would have been baffled by the response, which was an attack on small business and their next payroll tax increase, it's evident from that non-response the last thing this government wants people to know is how much the Liberals' carbon tax is going to make all Canadians poorer. When it comes to the Canadian government, talking points on the cost of the new Liberal carbon tax, Canadians know they're hearing government spin. Carbon taxes will become a tax and spend grab that lets this government spend ever greater amounts on wacky left-wing experiments in social engineering as it tries to move Canadians ever closer to the dystopian world described by George Orwell in his novel 1984. And I quote from the member from Ottawa Centre from the same question period, as her comments apply to her own non-answers to legitimate carbon tax cost concerns of Canadians. Quote, "It is really sad that we have fake news, misinformation and fake news." End of quote. This comment comes from a government and a Prime Minister who thinks the novel 1984 is prophecy. The author of that fiction novel, George Orwell, is quoted as saying, quote, "In a time of universal deceit, truth-telling is a revolutionary act," end of quote. For the benefit of Canadians who want to know how much the new Liberal carbon tax is going to cost them, here is the revolutionary act of providing some cold, hard facts. Using energy consumption data from Statistics Canada and imputing prices from average household expenditure on transportation fuels and provincial gasoline prices, we can calculate the impact of the carbon tax on a typical Canadian household. The costs to households will be significant. 3 provinces, Alberta, Saskatchewan, and Nova Scotia, will be hit with more than $1,000 of carbon tax per year to comply with the $50 per ton carbon tax Ottawa has mandated for 2022. Nova Scotia, $1,120, and Alberta, $1,111 will have the highest bills, followed by Saskatchewan at $1,032, New Brunswick at $963, Newfoundland at $859, and Prince Edward Island at $788. The average household in Ontario will pay $707 a year to comply with the carbon tax once it's fully implemented. But wait. Federal, provincial, and municipal taxes already make up 44 cents of the average fuel pump price of $1.34 per litre. The reality is the typical Canadian driver already pays the equivalent of a carbon tax of $200 per tonne, costing more than $28 for a $64-litre fill-up and generating government revenues of $24 billion in 2018. Now, Ontario tax ratepayers, they've been paying a huge carbon tax for years. Itemized as a global adjustment on Ontario Hydro One electricity bills, the price paid is at least $8 billion or $655 per tonne of emissions per household. But it gets worse. Carbon prices must continue to increase sharply to effectively lower emissions. At $100 a tonne, for example, households in Alberta will pay $2,223. In Saskatchewan, they'll pay $2,065, and in Nova Scotia, $2,240. In fact, at $100 a tonne, the average price for households in all provinces is well in excess of $1,000 a year. In Ontario, a significant number.
Secretary to the Prime Minister.
Well, thank you very much, Mr. Speaker. I'd like to thank my honourable colleague for her remarks. In response, Mr. Speaker, I have to say that, of course, our government cares about the cost of living for Canadians, and that is why the Government of Canada has a serious, credible plan with low-cost measures to make sure that we tackle climate change head-on. Carbon pollution pricing, Mr. Speaker, is a common-sense way to reduce our emissions, invest in a cleaner tomorrow for our kids and grandkids, and help Canada compete in the emerging global low-carbon economy. In fact, Mr. Speaker, last year the province, with a price on carbon pollution, also led the country in economic growth. We know from experiences in BC, Alberta, and other provinces that governments can make sure that a price on carbon pollution protects middle-class families from any negative economic impacts. Putting a price on carbon pollution, Mr. Speaker, creates incentives for individuals, households, and businesses to build on investments they have already made to lower their emissions. Carbon pollution pricing also reduces our impact on the environment. The upfront costs to businesses and households depends on the designs of the respective carbon pricing systems, the types of fuel consumed, and how revenue is used or rebated. Revenues, Mr. Speaker, from the federal system will be returned directly to the province or territory that they came from. Revenues from pricing carbon pollution can be used to support Canadians, grow the economy, and protect the environment. And we've seen this already in BC, Alberta, and Quebec, Mr. Speaker. BC has reduced income and business taxes and provided northern and rural homeowners a benefit of up to $200 annually. And Alberta provides rebates to low and middle income households. Canadians want to take advantage of these significant economic opportunities in the low-carbon economy, Mr. Speaker. Analysis by the Global Commission on the Economy and Climate estimates that transitioning to a low-carbon economy will deliver direct economic gains of $26 trillion and generate 65 million new jobs and, Mr. Speaker, help avoid 700,000 premature deaths by 2030. So with that, Mr. Speaker, I want to reiterate once again, we do care about costs that will be incurred by Canadians, and that's why our plan puts in place measures to ensure that these costs are not directly borne by Canadians, and that at the same time, Mr. Speaker, we're doing what we need to do to protect future generations from the scourge of climate change. Thank you, Mr. Speaker.
The honourable member for Renfrew, Nipissing, Pembroke.
In Ontario, a significant number of households fit the definition of energy poverty. That is, 10% or more of household expenditures are spent simply procuring the energy needed to live, to power the home, and for transportation. When you add up the costs of power to power the home and the cars, 19.4% of Canadian households devote at least 10% or more of their expenditures to energy. Energy poverty is unconscionable in a country with the world's third largest proven oil reserves and is the fourth largest generator of hydropower. In Ontario, taxpayers have been paying the carbon tax on power since 2009. That year, the Ontario Liberal Party brought in a huge carbon tax on electricity. It was brought in under legislation properly referred to as the Green Energy Act. The Green Energy Act was conceived by Gerald Butts, and as Principal Secretary today to the Prime Minister, Butts played the same role to the disgrace.
Well, thank you, Mr. Speaker. Once again, I'd like to thank my colleague for her remarks. The reality is, Mr. Speaker, that not taking action on climate change comes with significant consequences that my honourable colleague refuses to mention. For example, more frequent extreme weather events are already taking hard-earned money out of the pockets of Canadians across the country. And also across the country, Mr. Speaker, people are starting to experience firsthand the devastating wildfires, extreme flooding, for example, in my own riding, Mr. Speaker, severe droughts and stronger storms that are associated with climate change. In fact, for the past 6 years, annual insurance payouts from extreme weather have been close to or above $1 billion across the country, and that is up, Mr. Speaker, from $400 million a year over the 25-year period from 1983 to 2008. Thank you, Mr. Speaker.
The honourable member for Vancouver East.
Mr. Speaker, when I rose in June to ask the Prime Minister if he still believed the United States was a safe country, the international community was still in shock of the Trump administration's blatant disregard for international refugee and human rights law by forcibly separating migrant children from their family as a deterrent to claiming asylum, and just announced that they would no longer accept asylum claims made on the basis of gender-based violence or gang or drug cartel violence. Sadly, the Prime Minister didn't seem to care. We know that there are now over 14,000 migrant children being held in detention facilities in the U.S. 10 cities have been erected. The President sent the military to the U.S.-Mexico border and suggested that the U.S. military should treat having a rock thrown at them the same way they treat being shot at. Let's be clear, he was suggesting that the U.S. military should open fire on asylum seekers. We're now learning that the U.S. is actively engaged not just in U.S. legislation, but in amending international agreements to define transgender people out of existence. At both the UN and the U.S. Department of Health and Human Services, it appears the Trump administration is attempting to narrowly define human rights protections so that they would not apply to transgender people. This is beyond troubling, and it cannot go unchallenged. The goals of these policies are clear: to delegitimize and dehumanize asylum seekers, to deter them from attempting to find safety in the U.S. This abdication of international responsibility is as morally bankrupt as it is illegal under international laws. Yet the Prime Minister sits idly by, doing nothing, claiming the U.S. is still a safe country for asylum seekers. How is that possible? We need to hold the United States accountable for what they are doing. Donald Trump is attempting to shut down the U.S. border to Central American asylum seekers by disqualifying the reasons they are in need of protection. A 2017 report by Doctors Without Borders found that asylum seekers from El Salvador, Honduras, and Guatemala, 39% cited direct attacks, threats, extortion, or forced gang recruitment involving themselves or their families as the reason they fled. 43% had a relative who died due to violence in the last 2 years. And in 2017, Amnesty International also released a report outlining significant risk in the Northern Triangle region of Central America that the LGBTQI individuals face. The report states, and I quote, "Despite the difficulty in obtaining accurate figures from the country's governments, there is evidence that lesbian, gay, bisexual, transgender, and intersex people are particularly exposed to violence, and that is related to intrinsically to the multiple forms of discrimination LGBTI people face. Yet the U.S. is moving to prevent all of these individuals from even having access to fair hearing to their asylum claims. By continuing to defend the Safe Third Country Agreement, the Prime Minister is not just remaining silent to these disturbing policies, he is actively supporting them by claiming the U.S. remains a safe country for asylum seekers. How can this be justified?
Parliamentary Secretary.
Thank you very much, Mr. Speaker. I appreciate this opportunity to respond to the question from the member for Vancouver East in more detail. As you know, Mr. Speaker, the Safe Third Country Agreement is a treaty that was established with the United States in 2004. And under this agreement, Canada and the United States cooperate to ensure the orderly handling of asylum claims. The Safe Third Country Agreement is based on the principle that people must claim asylum in the first safe country in which they arrive.
Under this agreement, Mr. Speaker, Canada and the United States collaborate in order to ensure orderly processing. This is based on the principle that a person must seek asylum in the first safe country they arrive in.
With our U.S. colleagues, and we continue to collaborate closely on border issues to this day, Mr. Speaker. That being said, the Immigration and Refugee Protection Act requires the continual review of all countries designated as safe third countries to ensure that the conditions that led to the designation as a safe third country continue to be met, Mr. Speaker. Factors that are monitored on a continuing basis include whether the U.S. is a party to the Refugee Convention and Convention Against Torture and to an agreement with Canada, such as the Safe Third Country Agreement. And, Mr. Speaker, U.S. policies and practices with respect to claims under the Refugee Convention and with respect to obligations under the Convention Against Torture and its human rights record. Mr. Speaker, we take our responsibility to monitor the U.S. as a safe third country seriously and always have. We also remain in contact with the UNHCR, who is responsible for interpreting the Refugee Convention and associated international obligations. Canada has carefully analyzed recent developments in the United States, including the executive orders related to immigration and refugee matters. And we consider the United States a safe country for asylum claimants to seek protection there. And this finding is also shared, Mr. Speaker, by the UNHCR, something I encourage my honourable colleague to take note of. While the Safe Third Country Agreement remains an important agreement to ensure the orderly handling of asylum claims, the reality is that much has changed since this treaty was first negotiated. The
biometrics and other current technology provide us with opportunities that we did not have 14 years ago, and that is why, Mr. Speaker, it's important that our two countries work together to find ways of improving this agreement, because the current context is different than the one that existed when the agreement was signed.
Many times, our government remains committed to ensuring an orderly and efficient immigration process, to protecting the safety of Canadians, and, Mr. Speaker, to keeping our borders secure. And that is exactly what we are doing.
Member for Vancouver East.
Blind to this fact. We know that in the current migrant caravan traveling to the U.S. border, there is a small subset caravan of transgender women and gay men. They're forced to band together in order to keep themselves safe. Not only did they flee their homes because of violence and discrimination they face, but they face similar dangers as they make the journey to the U.S. border to make an asylum claim. My colleague, the member for Esquimalt-Sandwich-Sooke, has called for Mexico to ensure the safety of this highly vulnerable group and for the U.S. to allow these clearly valid asylum claims to be made, and that the condition of this group be monitored by NGOs like Amnesty International. This government claims to be a champion of human rights. If these vulnerable individuals are denied having their claims heard at the U.S. border, will that finally be enough to make them realize that it's not a safe country for asylum seekers, Mr. Speaker?
Parliamentary Secretary.
Thank you again, Mr. Speaker. I want to reiterate that Canada has a strong working relationship with our U.S. colleagues, and we continue to collaborate closely on border issues. The Immigration and Refugee Protection Act, Mr. Speaker, requires the continual review of all countries designated as a safe third country to ensure that the conditions that led to that designation in the first place as a safe third country continue to be met, and that's exactly what we're doing with the United States. We will also remain in contact with the UNHCR, who is responsible for interpreting the Refugee Convention and associated international obligations. That is what Canadians expect from us, Mr. Speaker, and that is exactly what we continue to deliver to Canadians all across the country. Thank you.
Honourable Member for Nanaimo Ladysmith.
Thank you, Mr. Speaker. When I picked this issue up initially, I was talking with the Transport Minister about an issue of key passenger and marine safety in my riding, Nanaimo Ladysmith, which I'm honoured to represent. I asked if it was true that the Transport Minister would allow passenger vessels to sail with engineers 5 decks above critical machinery and steering equipment, an arrangement that we do not allow on bulk cargo ships. I asked the minister whether this was what he meant by increasing marine safety, and he mostly avoided the question. So this is, when I posted this online, I got a huge response from people in the riding. They certainly were concerned about the issue, and in fact, the scenario that we had described as a possibility, in that there was a loss of power. If theoretically there's a loss of power incident, and the engineer, as opposed to being in the engine room in the machinery space and being able to help shut parts of the engine down or turn other parts of the engine on without having to travel a great distance, in this case 6 floors between the bridge and the engine room. In fact, an incident just like that happened just a week after I asked the question in the House, so it certainly got people's attention. So since then, this is what some of the crews working with this arrangement, this great separation between machinery space and the bridge, have had to say. This is a quote from Dan Kimmerly, who's BC Ferry and Marine Workers Union Ships Officers Component President and Marine Engineer Second Class. He says, quote, "Coastal passenger ferries still regularly sail in congested waters very near land. These sorts of passenger ships regularly go almost full speed just a few hundred feet from the rocks, with pleasure craft traffic making the task even more difficult. Having personnel in the machinery spaces to immediately take local control of machinery and emergency steering is essential. Interpreting the control room as being part of the machinery space while being 5 decks above is putting the safety of unsuspecting passengers and pleasure boaters at unnecessary risk." End quote. So if that weren't enough, in the draft marine personnel regulations that are now under consideration, the Transport Minister is proposing that passenger vessels under 2,000 kilowatts can operate without any certified engineers on board at all. The Transport Minister now proposes replacing marine engineers who have years of specialized education and experience with small vessel machinery operators who have a 3-day course and a month's sea time. This means that the minister is allowing these passenger vessels to sail our waters without anyone trained or certified to make safety-critical repairs. Now, the passenger vessels that are affected by this proposed regulatory change are not small vessels. For example, the Quinsam, the ferry that takes me and my family and neighbours and constituents back and forth to Gabriola Island, where I live, is 89 metres, just under 300 feet in length, weighs 1,400 tons, has 4 engines, carries large volumes of commercial cargo, including dangerous goods, and carries up to 400 passengers and crew at a time. So my question through you, Mr. Speaker, is how could that not be interpreted as a watering down of marine regulations and a threat to marine safety?
Treasury Secretary.
Well, thank you very much, Mr. Speaker, and I'd like to thank my honourable colleague for her remarks. Mr. Speaker, the safety and security across all modes of transportation is our government's priority, and the safe crewing of Canadian vessels is a key part of that work. The Canadian vessel's minimum crewing complement and their qualifications are determined by Transport Canada marine safety and security officials. The marine personnel regulations are reviewed regularly, and adequate amendments are made to reflect modern technology. Mr. Speaker, BC Ferries Salish-class vessels do not have unmonitored machinery spaces. This is simply not true. The 3 BC Ferries Salish-class vessels are equipped with technologically advanced machinery control and monitoring systems. This means that the equipment in the engine room can be controlled and monitored from a remotely located engine control room, which is required to be continuously manned by a qualified engineer. Transport Canada officials analyzed the matter and confirmed that the continuously manned engine control room is the equivalent of a continuously manned engine room. This arrangement of having a centralized machinery control station on vessels is becoming more and more common with technological advances, Mr. Speaker. The Salish-class vessels reflect some of the most recent advances in machinery monitoring and is used extensively in the marine environment and even in the warships of the Royal Canadian Navy. In this structure, a qualified engineer and engineering rounds personnel are continuously monitoring not only the ship's engines, but also the ancillary systems necessary for power generation, pumps, and firefighting equipment. This construct permits personnel to respond directly from a central location that keeps passengers safe from a number of possible incidents. Our government remains committed to ensuring that Canadians have a safe and secure transportation network, and rest assured, Mr. Speaker, that the engine rooms of the BC's Ferries 3 Salish-class vessels are adequately manned and that these ships are operated in a safe and adequate manner. Thank you, Mr. Speaker.
The honourable member for Nanaimo Ladysmith.
Thank you, Mr. Speaker. This is what the Marine Ferry Workers Union is saying to me. Transport only just released these draft regulations just on November the 8th. They held the national consultation meeting on the 14th of November, doing the Vancouver consultations yesterday. And the closing comments are in February, but if you don't have it in by January, they were told that they won't be addressed, and the regulations will not be brought back for any further national consultation prior to gazetting. So it sounds like they're drafting these new regulations on the fly. I, as a rep of coastal communities, certainly haven't been informed of it. So again, how does this square with the government's commitment to consultation and marine safety? It looks like a lowering of the bar.
Honourable Parliamentary Secretary.
Mr. Speaker, thank you very much for the opportunity to speak again, and I'd like to thank my colleague for her passion and commitment to this issue. I want to reiterate some key facts. A Canadian vessel's minimum crewing complement is determined by Transport Canada's marine safety and security officials through a thorough assessment based on the marine personnel regulations. BC Ferry's Salish-class vessels do not have unmonitored machinery spaces, Mr. Speaker. They are indeed equipped with technologically advanced machinery control systems. What that means, Mr. Speaker, is that the equipment in the engine room can be controlled and monitored from a remotely located engine control room, which is required to be continuously manned by a qualified engineer, Mr. Speaker. Our government, as I stated earlier, remains committed to ensuring that Canadians have a safe and secure transportation network. And please be assured, and I'd like to reassure my honourable colleague, that these vessels are adequately manned and are operating as per the regulatory requirements. Thank you again, Mr. Speaker.
The motion to adjourn the House is now deemed to have been adopted. La Chambre demeure donc ajournée jusqu'à demain.
The House remains adjourned until tomorrow, 2 p.m., pursuant to Section 24(1).
Thank you.